Gundars Kittenbergs, Vice Rector for Science at the University of Latvia. Please, floor is yours.
Thank you. Good morning, dear all. Labrīt, as we say in Latvian. It is my great pleasure to welcome you here at the University of Latvia. It's the largest and most research-intense university we have in Latvia. And we're a classical university, so in these hallways, as well in the campus just across the river, you will see activities happening in life sciences, medicine, natural sciences, humanities, social sciences, and also law that I'm quite sure you all are more than familiar with. As the university is named after our country, Latvia, it puts a large responsibility in our hands. We have a special role in the development of Latvian language, literature, culture, but also in many other aspects. And that's where the Faculty of Law and the University of Latvia has served very specifically. It is the cornerstone of the legal education and legal thought in this country. It has produced judges, legislators, diplomats, scholars, practitioners who have shaped and also continue to shape the legal landscape of Latvia. In moments of historical transitions, in times of reform, throughout the nation's European integration, this faculty has not only observed the legal evolution, but it has actually led it. And that's a great role. However, as much as the legal system is country-specific, we can't look at it only from one country's perspective. And as we are a research university, this is something we have to do by combining the viewpoints, by having different exchanges of opinions, discussions, and this is why I'm very proud to welcome ECLAN Network and ECLAN Annual Conference here at the university. And all of you made this network of European criminal law work. And I've seen that it has been active already for more than 20 years, bringing together academic experts of criminal law, and I congratulate you on this, and I wish you a beautiful future ahead as well. The topic of the conference on this presumption of innocence, I think, is more than timely. For example, we have seen how popular votes can ignore the facts that you can have in court decisions. Also, the last decision has not been made, and I'm sure that you will have wonderful discussions from very different aspects. Before I conclude, let me highlight some of the colleagues without whom this event would not be possible. So it's the Faculty of Law, it's Professor Christine Standerosenberg, who's also my colleague as Vice Rector for Studies here, her assistant Itia. I also thank the Internal Security Academy for help and sponsoring the event. And of course, thank you, ECLAN Network, for letting us organize this event, and I hope it will be a success. And finally, I wish you a very nice time here in Riga. Enjoy it. It's a beautiful city. I hope the weather will be a bit nicer than it seems at the moment. However, I wish you to come back to Riga and the University of Latvia also in the future. We are a melting pot of excellence, development, and responsibility. So, successful conference to all of you, and thank you for your attention.
Yes, thank you, Mr. Kittenbergs. And now I'm happy to invite Mr. Edvin Zdanovskis, Dean of the Faculty of Law.
Distinguished members of the European Criminal Law Academic Network, and dear guests of this notable conference. As the Dean of the Faculty of Law, I am happy and proud that by hosting this annual conference of this network, we can do our fair share in supporting your significant endeavors in facilitating research of criminal law. However, in the context of the topic of this conference, I must declare that I should be presumed completely innocent regarding the fact that this conference is organized in Riga and by our university. As you all know, the main culprit is my wonderful colleague, Professor Kristina Rosenberger, who has led the efforts of organizing this year's annual conference, for which we all are immensely grateful. The European Criminal Law Academic Network is an example of excellence in organization and promotion of joint research and sharing of scientific knowledge in the area of law. Your various activities and initiatives that are so well presented in the web page of the network is an inspiring source for researchers of other branches of law to organize themselves for a greater good. My message to you and your colleagues in your respective countries is, irrespective of season and weather, the Faculty of Law of the University of Latvia has many talents and open minds eager to collaborate on various research initiatives. And I am hopeful that I really do hope that there will be a joyful atmosphere in this conference, and of course your well-being, ensured by our staff, will remind you for a long time that this is a good place to return to. I give you my blessings.
Thank you for the very kind words. And next we will hear from Andris Miltana, Deputy State Secretary for Legal Policy, Ministry of Justice of the Republic of Latvia.
Dear distinguished guests, dear ECLAN members, it is my great honor actually to welcome you here in this premises, which is also my own alma mater. Well, who doesn't know what the presumption of innocence is? I think most of us knew about it even before we started our first semester in the Faculty of Law. Namely, the thief cannot be called a thief until this is proven in a court. Well, nowadays, crime is much more complicated than that. Starting with family violence, domestic violence, and ending up with transnational organized crime with branches of drug trafficking, modern slavery, digital fraud, and environmental crimes, and of course, also the money laundering. So the truth and reality is much more complicated than just the first perception of this concept. And the concept of presumption of innocence goes hand in hand with the concept of standard of proof and the burden of proof. And especially it is in those modern money laundering cases. Just a few months ago, I participated in European Union high-level forum on future of criminal justice. And in this forum, the Eurojust representatives said that in average, all across Europe, only 5% of all the criminal illegal assets nowadays are being confiscated. Just 5%. And partly this is because also discrepancies of legal provisions. And indeed, also the Latvian criminal procedure regulation on threshold of proof and burden of proof for confiscated illegal assets has been recently scrutinized in our constitutional court. And before the judgment, there was widespread debates among academics and professionals. Is it just to shift the burden of proof to the property owner to prove that this is legal? And the Constitutional Court judgment has recognized that standard of proof established in Latvia regulating the property recognition as a criminal asset is in accordance with Latvian constitution. The court concluded that contested regulation does not shift the burden of proof only to the property owner. Actually, our regulation has shared burden of proof between the investigation and the property owner or defendant, namely the evidence that substantiates the assumption of the criminal origin of the asset must be provided by the investigation, and the evidence that proves that the asset is of legal origin must be provided by the owner of property. I think these conclusions give some new grounds for reflection for the academics, and of course it gives new hope and courage for Latvian legal enforcement. And this is very indeed special, especially at this moment when Latvia, as the first country in the world, is undergoing the 6th elevation phase of Moneyball recommendations. The criminal world is changing. What I wanted to mean, that criminal world is changing and our doctrines must change alongside in order to stay very effective to combat and forestall the crime in all its sizes and shapes. But on the other hand, there is some more everyday aspects for the presumption of innocence. In the criminal law textbook, we can read that the presumption of innocence is a fundamental human right that is essential for ensuring fair trial, protecting the integrity of justice system, and respecting the dignity of the accused. And respecting the dignity of the accused person is especially hot topics in nowadays prevailing culture of naming and shaming, crowd hating, and cancellation culture. And the pressure this new element, this new phenomenon puts on the accused person, on the court, and also on the judges is something new, something that we couldn't imagine some, let's say, 30 years ago when those persons in courtroom enjoyed, let's say, relative anonymity from the crowd opinions. Must the law protect a defendant person from the crowd opinion? Is the famous thesis of William Blackstone is that it is better that 10 guilty persons escape than one innocent person suffer, still in force in nowadays modern crowd culture? I think in next 2 days, many similar, very interesting questions we will hear in this audience, and we will hear many detailedly elaborated answers from most brilliant scholars coming from all across Europe. And I'm convinced that this conference will contribute to the European legal thought, and most definitely to the Latvian criminal doctrine. And in the end, let me wish that each of you finds in this conference and here something on which you can build your future legal research. And of course, let me wish you also for those 2 days very interesting times to meet and develop very warm relationship with your colleagues, confronting this very cold and untypically cold weather outside here in Riga. So, welcome to the University of Latvia and welcome to Latvian legal space.
Thanks, Sandy, for a very thoughtful speech. And now I'm very glad to give floor for an ECLAN point, ECLAN coordinator who will give us an open speech from the ECLAN side.
Thank you very much, Christine. Honorable Vice Rector for Research, Honorable Dean of the Faculty of Law, dear representative of the Ministry of Justice, honorable judges, dear colleagues, and dear friends. It is both a true pleasure and a great honor to open this year's ECLAN annual conference on the presumption of innocence. And on behalf of my two co-coordinators, Katalin Ligeti and Valsamis Mitilegas, on behalf also of all members of the ECLAN Management Committee, and on behalf of our entire ECLAN community, I would like to extend our heartfelt thanks to the University of Latvia, to its Faculty of Law, and of course to Professor Christine Strada-Rosenberger and her team for their outstanding efforts in organizing and hosting this event here in Riga. We are truly grateful for the opportunity to gather here today around a topic that is both highly relevant and deeply important to the future of criminal justice in Europe, as was mentioned earlier. As you know, the presumption of innocence is a fundamental right and a core principle of criminal law, enshrined in national constitutions, as well as in Article 6 of the European Convention of Human Rights and Article 48 of the EU Charter of Fundamental Rights. It lies at the very heart of fair trial guarantees. Yet, in recent years, this principle has come under increasing pressure, notably due to the growing use of digital technologies, digital investigative techniques, and more broadly, in light of the ongoing transformations in criminal procedure, as one also mentioned earlier. Addressing these questions at the European level is both timely and essential, particularly in a context where instruments of judicial cooperation are becoming increasingly digitalized and where the role of EU criminal justice agencies in collecting and sharing sensitive personal data is expanding significantly. And I'm referring here especially to the recent controversies surrounding Europol. Beyond examining how the presumption of innocence operates in a rapidly evolving environment, both nationally and transnationally, we must also reflect on their very applicability in certain contexts. Long-standing debates surrounding so-called preventive measures remain acutely relevant today. And this is clearly the case with the so-called targeted sanctions, which, as you know, operates some kind of green zone despite their punitive effect. This is also particularly the case in areas such as non-conviction-based confiscation, where recent legislative developments have brought these issues back to the forefront. And we will have the opportunity, of course, to discuss all of this during these today's conference. Almost a decade after the adoption of the EU directive on the presumption of innocence, which aim, as we know, to harmonize a set of minimum safeguards, one may ask whether this first-generation EU instrument in the field offers a level of protection that is still fit for purpose in the face of evolving framework and challenges. In this respect, of course, the case law of our two European courts play a crucial role, not only in shaping the meaning of the principle itself, but also in ensuring that the associated safeguards remain applicable and effective. All this makes this
year's conference a particularly timely opportunity to bring together scholars, but also practitioners and institutional actors from across Europe to reflect critically on how the presumption of innocence is being interpreted, applied, and at times challenged in today's shifting legal and societal environment. From its establishment in 2004 and throughout the years, our network, ECLAN, has been committed to strengthen academic research all across Europe, bridge the gap between academics, practitioners, and experts, share knowledge and experiences, and foster meaningful dialogue and collaboration in the dynamic and very sensitive fields of EU criminal law. It's in this spirit that one of the ECLAN classics, so namely those annual conferences, have become a particularly rich forum to discuss and explore the most pressing developments in EU criminal law. Last year, in 2024, the ECLAN annual conference took place in Ghana and was organized by our colleague Robert Gert, and it focused on the collection and admissibility of evidence in Europe. And as you can see, of course, well, there is a very narrow link with the topics we will be discussing during these 2 days. Most of our ECLAN conferences result in collective publications. And so I have the pleasure to tell you that the collective book, the edited volume, relates to victims' rights, which is the result of the 2023 conference on victims' rights, will be out of press around this year. Among the ECLAN's classic, let me also mention our annual PhD seminars. And so a few weeks ago, a few days ago, so the last PhD seminar took place in Utrecht and was organized by our colleagues Vicky Lufman and Art de Vries. Our commitment to fostering dialogue also continues through our summit, annual summit. And the next one will take place in Brussels, last days of June, early or beginning of July. And this year it will focus on the external relations of the EU in this field of criminal law. Returning to today's conference, I would like to say that it is deeply encouraging to see many researchers and practitioners from so many different countries gathered here to exchange a diversity of perspectives on the presumption of innocence, its meaning, its limits, and the many challenges surrounding its effective application in a fast-evolving legal and societal environment. In a period of very high geopolitical tensions and attacks on academic freedom, on research and universities, not only in the United States of America, but also within our European Union, including in my own country, Belgium. Let's take advantage of these moments, be aware of their importance, and continue to promote academic collaboration. Once again, dear Christine, and you all team, including of course PT as well, we would like really to reiterate how much grateful we are for the great organization and hosting of this conference. You managed really to build an amazing program. I would like also to take this opportunity to thank very warmly my two colleagues, fellow co-coordinators of ECLAN, so Catherine and Vanzanis, all members of the management committee of the network, Gintaras, Pedro, Robert, and Adam, all ECLAN contact points and members, of course, also for their support and contribution to our network and to our activities. Huge thanks also to the Brussels team, especially to Julia Burchett. I wish you all 2 very fruitful days of debate. I'm sure they will be quite interesting, quite fruitful. And with that, back to you, Christine. Thank you very much.
Okay, it seems that we fixed it. So, dear colleagues, it's truly an honor for me to open this conference with a presentation that is by design quite general. My aim is not to go into details, but rather to offer an introduction to set the scene, raise some key questions, and hopefully create the mood for the discussion that will follow. Usually I prefer to speak freely, but today I'll follow my notes closely because that's quite a lot I want to say, and I'd like not to get lost in details and to be on time. So let's start. The phrase presumption of innocence is, I believe, both familiar and thought-provoking. And on one hand, we all think we know what it means. On the other hand, it remains abstract, differently understood, and often evaluated in surprisingly different ways. Most of us here today are lawyers, criminal law experts, or scholars, so naturally we tend to link the presumption of innocence to the jurisprudence. And this will be my focus of today as well. So let us begin with what may seem simple, the presumption of innocence as a fundamental principle of criminal procedure. The presumption of innocence is one of the key principles of criminal procedure. It has a long and rich history, although inexact origins are still discussed among scholars. Some researchers believe it can be traced back to the Code of Hammurabi, others point to the time of Emperor Justinian. There are also different views on where the principle devoted later, either in England or in France. Today, the presumption of innocence is included in many legal texts, in national constitutions, in international and European Union law, and in national criminal procedures. I will now briefly mention some of these legal acts. As you see, these documents describe the presumption of innocence in a very short and almost unchanging way, but this simplicity leads to many important questions, and let's take a look at some of them. The essential questions can be summed in a simple, elegant phrase: who must be presumed whom by innocent of what? As formulated by Anthony Duff in his widely discussed article with the same title. To these core questions, I would also add a few more. What does presumption of innocence actually mean? Does it also include the burden and standard of proof and other procedural safeguards? We must also ask what happens when this presumption is violated. And finally, thought perhaps it should be the first question, why does this principle exist and what is its true nature? These questions have remained largely the same over decades. But can we say that the same are the answers? This is a question we will be exploring through this conference. The goal of my presentation is not to provide a detailed analysis of the presumption of innocence and all its elements. Instead, I hope to introduce some key ideas and open the door for further discussion. I will highlight a few selected aspects, starting with the most general. Let's begin with a little wordplay. The phrase presumption of innocence included the word presumption, but as several scholars, including Duff, Weigand, and Lipke, have pointed out, the presumption of innocence does not fit the typical meaning of this term. Normally, a presumption is based on some existing facts or experience. We presume something to be true because another fact supports it, or because past experience tells us it's likely. In that sense, presumptions are different from mere assumptions. They have a factual and empirical basis. The presumption of innocence is quite different. It does not depend on any factual basis. It does not require any other fact to apply, and it certainly doesn't reflect real life experience. In fact, it's quite the opposite. Being accused of a crime often leads people to think the person is guilty. And statistics show that most people who are charged also end up being convicted. So we can say the presumption of innocence reflects what is usually true. We can't say that presumption of innocence reflects what is usually true. That's why Weygand and others have called this principle counterfactual. It deliberately goes against the way people usually think and what experience would suggest. So why maintain such a legal fiction? That's the question we turn on now. The presumption of innocence serves a dual purpose. It protects the individual against unjust punishment, and it safeguards the public interest in maintaining a fair, reliable justice system. This principle consists of two closely related dimensions: its instrumental value and its attitude dimension. The instrumental dimension protects individuals from being wrongfully convicted. It included safeguards like placing the burden of proof on the prosecution and requiring that any reasonable doubt must benefit the accused. In Latvian, this side often linked to being found guilty. The attitude dimension ensures proper treatment and respect towards the accused throughout the process, not only in legal decisions, but also how authorities and the public relates to them. It connects more closely to being regarded as innocent. Only when we apply the presumption of innocence properly, we can be sure that people are found guilty not because they are accused, but because the evidence truly proves it. As Stammer noted, referring to Kafka's The Trial or The Process, the idea that someone could be convicted merely because they were accused is the darkest nightmare of criminal justice. And as Lipka suggests, the presumption does not require us to believe the person is innocent, because belief is not something the law can demand. But what the law does require is that we treat the accused as if they were innocent and evaluate all evidence accordingly. The presumption also protects against excessive state power, especially when someone is socially vulnerable and facing powerful state mechanisms. Finally, this principle is essential for public trust. Weakening it, for example, by lowering standard of proof, risks punishing people who are actually innocent instead of strengthening justice. This would harm it and reduce trust in legal system. The presumption of innocence matters not only because of the result, but also because of how the result is reached. So we can look at the importance of two dimensions: substantive or material dimension, the outcome, and procedural dimension, the fairness of the process. It's not only about whether someone is guilty or not. It's also about how we reach this conclusion. Without fairness in the procedure, even a correct result can be unjust. So the presumption of innocence protects both what we decide and how we decide it. At first, to understand why the presumption of innocence is so important, we need to look at what it really means to be declared guilty, not just in terms of punishment, but in terms of broader and long-lasting consequences. When a person is found guilty, the effects don't stop with the sentence. They go much further in many parts of a person's life. First, they are direct legal consequences. These include, for example, loss of freedom, restrictions on movement, work, or property. They are also indirect effects that come with serving a sentence. For example, problems with health care, education, moving around, or maintaining family life while in prison. Then come the criminal consequences beyond the sentence. For example, being marked as a repeated offender can lead to harsher penalties in the future. Third, there are legal consequences outside criminal law. A person found guilty may lose job opportunities, have problems with migration, or even face limits on personal and family rights. And finally, there are extra-legal consequences, like damage to reputation, public shame, being socially excluded or labeled. Many of these consequences are being found guilty are explored in detail in the books shown in the slide. But the central message here is clear. Being declared guilty has long-term, multi-layered effects, many of which extend far beyond formal punishment. That is precisely why the presumption of innocence is so vital. Now that we've seen why being found guilty really matters, let's go back to the procedure. What does the presumption of innocence actually require? And from whom? Who should be protected? And who has to make sure that the protection works? And so, let's return to the great question. Who must presume whom to be innocent and on what? As Doug has suggested, the answer depends on how broadly we understand the presumption of innocence. Duff distinguishes between two types of presumption. One is the trial presumption, narrowly tied to the criminal trial itself and the assessment of guilt for a specific past offense. Another is civic presumption of innocence, a broader social and ethical concept. It reflects the idea that citizens should assume one another to be law-abiding even outside the courtroom. Still, from the legal perspective, I believe that the presumption of innocence should retain its judicial nature. It's a legal norm operating without formal procedures directed toward persons who are suspected of having committed a crime. This supports a narrower view. The presumption applies to individuals involved in a criminal case beginning at the moment when substantial suspicion arises, even if their procedural status has not yet been formally confirmed. This raises a further question. Should the presumption of innocence apply even to those who have indeed committed a crime? The answer is yes, but until they are found guilty by a lawful decision. After that, the presumption no longer applies. It has fulfilled its role. However, this leads us to a more complex issue. Could some elements of the presumption, such as fair treatment or burden of proof, still matter even after guilt is confirmed, for example, during sentencing? This is precisely the question raised by scholars such as Tomlin in criminal law and philosophy. And this question is, could the presumption of innocence protect the guilty? Finally, there are gray areas that complicate the boundaries of this principle. One example is confiscation of presumed criminal assets, a process that clearly relates to criminal conduct, yet is not identical with declaring a person's guilt of a specific crime. Here, too, we prompted to consider where the presumption begins and where ends, and how far its protective scope should reach. It's also not simple to say who exactly should follow the presumption of innocence. I think here, too, we should take a narrower view. meaning it shouldn't apply to spheres like private disputes or situations outside criminal proceedings. But even then, it's not clear if this principle applies only to the officials in a criminal case. That's something we'll look at more closely in our next sessions of conference. Next key question is, what exactly are we being asked to presume? One thing is clear, we must not presume guilt. The presumption of guilt is legally and morally excluded. But that leaves us with other two possibilities, a non-presumption of guilt and the presumption of innocence. At first glance, they might seem quite similar. But as Richard Lipker asks, is there a real difference between presuming innocence and simply not presuming guilt? And the answer is yes, the significant one. The non-presumption of guilt is a neutral approach, like starting from blank slate. It avoids judgment, but does not give the accused any affirmative benefit. In contrary, the presumption of innocence means we must actively assume the person did not commit the crime. It's not just a matter we don't know. It is what we must treat them as innocent. This is a stronger, more protective starting point, and it shapes how we have handled this entire process. After looking at several general aspects of the presumption of innocence, I've now reached my final slide, where I'd like to highlight some of the challenges this principle faces in today's criminal justice systems. We are seeing various developments that are changing the environment in which the presumption of innocence is supposed to function. In some systems, people can be held responsible without clear proof of intent or fault. For example, in strict liability cases or situations where there's duty to explain. These may seem efficient, but they also can undermine fundamental guarantees, including the presumption of innocence. We also see more and more administrative and hybrid mechanisms, like financial monitoring and counterterrorism tools, that start shaping legal outcomes before any formal charges are filed. Legal presumptions are being used in new ways, such as assuming the criminal origin of someone's assets. That raises a question, is the presumption of innocence still strong, or it's slowly being weakened? In some situations, people are even expected to justify their actions, a clear shift from the classical model where the burden of proof lies with the prosecution. This issue becomes even more complex when we talk about legal persons. The presumption of innocence was designed for individuals. So how do we can apply this presumption meaningfully to the corporations? And finally, there's a push for simplified procedures. Plea bargains, penalty orders, out-of-court solutions. Of course, they may speed things up, but they can reduce important safeguards. People might admit guilt without fully understanding the consequences. And this raises concerns about pressure, fairness, and whether the presumption still has a real meaning. And all of these trends show us that the context is shifting. They push us to think more deeply about what this principle truly demands and whether legal doctrine should adapt to protect it. These issues will be explored further by my colleagues today and tomorrow. My role here is to simply open the door and set the stage for what comes. And now let me conclude with just a few reflections. The presumption of innocence is one of the most essential and yet most misunderstood principles in criminal law. It's not merely a legal formula, but a fundamental expression of fairness, respect, and justice. Its meaning is more nuanced than it may seem at first. It's not just an absence of a presumption of guilt. It's an active protection, one that requires a certain attitude, a certain approach, and concrete procedural safeguards. At the same time, this principle doesn't stand in isolation. It's constantly under pressure, whether from efficiency-driven reforms, preventive measures, or shifts in the burden of proof. Sometimes, even well-intentioned changes in criminal justice risk undermining its very foundation. And perhaps this is the right moment to recall a well-known phrase, often repeated in very different ways. It's better that 100 guilty persons go free than the one innocent suffer. This idea, which dates back to Justinian's Digest, tells us something fundamental, that the presumption of innocence plays a dual role, to protect the individual, yes, but also to express the kind of society we aim to be. For the accused, this principle is deeply personal. In fact, they don't care about statistics, about legal theory. The only thing they want is the law sees them, and in fully, fairly way and as individuals. But for society, it's also vital. It reminds that justice is not only about punishment, but it's also about restraint, about refusing to let machinery of the state move forward without certainty. And it's a measure of who we are and how far we are willing to go to protect even those who are vulnerable or unpopular until the truth is proven. My aim today was not to answer these questions, but to raise them, to highlight what is at stake, and to invite all of us to think not only about what the law says, but about what kind of legal culture we are shaping. Throughout the rest of the conference, you will hear more detailed and expert perspectives of many of these issues. So let this just be the beginning of a deeper and much needed conference. Thank you for your attention. It was a pleasure and honor for me to give this first speech, and now pass the baton to my colleagues to a deeper exploration. And I would like to give the floor to Professor Stefan Braun from the University of Luxembourg, who will give us into a deeper reflection on the meaning of presumption of innocence in democratic societies and protection the rule of law. Thank you.
So good morning, everyone. Colleagues and friends. It's a pleasure for me and already this wonderful atmosphere in this room shows that we are is not just officially a framework for law, but also for a framework for writing the I have a pleasure to discover this part of your corner, and it's really fantastic to look at this wonderful guides. So that was a good start, despite this sorry, my French, excuse my French, so the organizers asked me to give a general introduction and now some deeper reflection on what you say is, of course, is unfair pressure, presuming me not to be innocent, but to look at deeper reflection. We're going to see. So the objective, anyway, of my presentation is a pedagogical one, right? I hope that will succeed. I will phrase this topic in order to give you guys a certain reference, hopefully, inspiring you stays today and tomorrow to have this general reference in all presentations. And hopefully you can also in your
to be connected. I approach the topic, so this framework, if you like, that I would like to deploy in 4 points or 4 aspects. Very first point, the presumption of innocence as a barrier, as a normative barrier to criminal proceedings and its diverse facets. Second, the presumption of innocence as a seismograph of freedom and truth, which will be my main message. Third, the historical part, the short historical part on the side. You could do a seminar on historical foundations and fundamentals of the presumption of innocence, which would be quite interesting. But the presumption of innocence is a historical counter-model to the permanence of justice. And last but not least, I already announced it, not that you guys have to be pressed afterwards. The presumption of innocence is already not a fade, of course, but it's getting used to its erosion already, and we now eroded, and I wonder what extent digital developments, AI, will completely eradicate it, and that remains to be certainly discussed today, tomorrow. So let's start. All that has been said already this morning seem to be very familiar with the presumption of innocence, derived even by Paragraph 2 of the European Convention on Human Rights. Constitutional status in many national criminal justice systems, in many national constitutions, it states that it is presumed that the person accused of a criminal offense is innocent until proven guilty according to law. So if you look at the first point, the normative barrier, and if we try to get a bit more concrete insights on what presumption of innocence is, we see what we're reading for very unfortunately, but luckily it is. The presumption of innocence is nothing which is actually that easy to understand, although it seems we all know it. It has a lot of aspects, a lot of facets, a lot of elements that are deploying on different levels of criminal procedure and of substantial criminal law as well. Historically, the presumption of innocence initially unfolds in the requirement that the burden of proof for criminal offense lies with the state. Hence, it's not the accused who must prove their innocence, but the state and the prosecuting authorities must prove the possible guilt of the accused. So far, so good. If we ask how is that done, it turns out that the presumption of innocence is a very complex construct that attempts to limit proceedings at different levels, with different means, and by means of various normative obstacles imposed. So there are different elements that are inextricably connected, they're closely connected with presumption of innocence. However, there is, of course, the paradigm principle maxime dubio pro reo. So if there's any doubt as to the guilt of the accused, he must be acquitted. One important element of the presumption of innocence already. Second, regarding coercive measures within criminal proceedings, there are throughout the criminal investigation high hurdles beyond the simple suspicion, legitimating, justifying, for instance, pretrial detention, justifying seizures, justifying coercive investigative measures. So there are urgent suspicions, there are sufficient suspicions, there are different degrees of suspicion needed if you want to interfere in fundamental rights during a criminal investigation. And these different levels are, of course, motivated and legitimated and required by the presumption of innocence. The regular review of whether the requirements for certain coercive measures are still met, and the question of the extent to which they comply with the principle of proportionality with regard to the presumption of innocence and its value. So you find quite complex system within criminal investigation with different degrees of suspicion, and these different degrees of suspicion have to do with the implementation of presumption of innocence throughout the criminal investigation. Rules of evidence. In addition to these limitative requirements of criminal investigation, you have the rule of evidence in the preliminary and main proceedings, which are also inextricably linked to the presumption of innocence. Its effect is comprehensive in this respect. It affects the entire criminal proceedings up to the sentencing and even to the decision on costs. Last but not least, this applies to the presumption of guilt, that has been mentioned already. For example, when we pretend that an element of the offense has objective condition of criminal liability, which is a very bad translation of the German Objektivliegenschaft, or with the intent to, with regard to the offense that is at least partially presumed to exist. So we have, for instance, the development of sexual offenses throughout the past few years. We can observe that there is a presumption always that the offender is aware of the age of the victim, and not longer the other way around. So this is a development which in that development of an element of the offense that presumes to exist. And at least, at the very least, this presumption must be rebuttable and must not constitute serious, means disproportionate interference with the presumption of innocence. In European law, other facets are also associated with it. If you read, or if you know, of course, the directive on the presumption of innocence, if you read the jurisdiction of the European Court of Human Rights, it goes with the presumption of innocence, the right to remain silent, the right not to defend oneself, the right to immediacy and publicity. In his recent concurring opinion in the case of Episcopo and Bazan versus Italy, judgment of the European Court of Human Rights from 19th December 24, Judge Zeis also links the presumption of innocence to human victim. It is, says he, vital for the protection of the individual as well as for maintaining the integrity of the proceedings and the credibility of the judicial system itself. History shows, quoting, that the presumption of innocence is the first of all rights of the defense. So the expectations of presumption of innocence as a guarantee that limits proceedings are therefore very high. The principle contains many sub-aspects, each of which is elementary for the conformity of criminal proceedings with the rule of law. The presumption of innocence is therefore something omnipresent, and at the same time, it is also particularly vulnerable, because the broader the scope of application is, the more vulnerable its normative substance appears. It appears large and significant, and yet could ultimately turn out to be a pseudo-giant. The more principled it is, the more likely it is to be subject to political attempts to undermine it. Which brings me to the second point, which basically concerns the deep relation between policy, the political system, and the situation of presumption of innocence in which we were and we currently are. If we try to dig a little deeper, we may realize then what is really at stake when we consider the erosion of the presumption of innocence and its endangerment by legal policy objectives. The principle of the presumption of innocence as a guarantee of the right to limit criminal proceedings is an expression and constitutive element of freedom on the one hand, and of truth on the other. Unfortunately, as we know, not just since this orange hat by enlightenment has taken power last year, that both freedom and truth cannot be taken for granted. The state of the presumption of innocence therefore says something about the state of our freedom and our relationship to the truth. Let me try to explain the seismograph function of symbolic folding, its historical and philosophical background. And there is a very nice text written by a German philosopher, Immanuel Kant. Translation is very bad, I call it on the integrity of the citizen. Kant calls that the Unbescholtenheit des Bürgers. In that context, the presumption of innocence is inextricably linked to the idea of freedom. In this connection, it is also a prerequisite for the rule of law and democracy. In the derivation and consequences of this concept, Kant unfolds and makes it clear that it is part of the characteristic of a citizen that he or she should act responsibly in mutual recognition within the community. He or she can only do this if one is free from suspicion and false accusation. Otherwise, one cannot effectively exercise freedom. Anyone who is accused of moral or legal misbehavior takes themselves back in the exercise of freedom, makes themselves small before society and before the state. One might be, hopefully not, but there's a lot of discussion also when it comes to problems of integrity or working in government. If one insinuates something negative, then it might have bad effects on people, depending on its extent and intensity. Insinuations that are false, rumor that does the right, the attempt to disregard others means that it could trigger also the core problem of the loss of mutual recognition. And in such an environment, the institution would belong to the road. A state that shakes the integrity of its citizens prevents them from developing freely. The intention of such a state is to make democratic decision-making more difficult. Citizens under suspicion only exercise their freedom with reservations, behind closed doors, if you want, in a state that suspects everyone tends to be an authoritarian state. The second part, and underlying in the story we just said, is the relation between presumption of innocence and truth. A similar situation arises when we relate this connection between presumption of innocence to democracy and truth. A criminal conviction that you find in any procedure requires legal proof of guilt. It is the result of a strictly formalized procedure to determine the truth. In the German criminal procedural law, for instance, there is a section, paragraph 244, paragraph 2, so-called principle of material truth, which makes this requirement of establishing the truth quite clear. However, such a procedure is inevitably based on equal participation of all actors within the criminal investigation. The aim is for all participants to be able to check the plausibility of factual claims and falsify them if necessary. The truth that exists insofar as it is established procedurally. What truth is flows from the contradiction and conflict of different perspectives on the situation. Such a procedure is inevitably also based on rationality and empiricism, both core elements of our own capacity and our own power of judgment. A criminal procedure that dispenses with plausibility, that ignores rational reason and person, makes it objectively impossible to determine the truth. In such criminal proceedings, the truth is destroyed. In such criminal proceedings, the presumption of innocence is not simply violated, it simply comes to nothing. This is all the more true when society and the subsystems, not least the media and universities also. And of course, the state itself simply evades rational falsifiability through propaganda, fake news, and yes, also shameless lies, where empiricism and rational knowledge are ignored, and facts are only used to distort them in the service of political power. When lying becomes the raison d'etre, the presumption of innocence suffocates, then the question of guilty or not guilty is simply an arbitrary act of ascribing shameless and critical power. Third, the presumption of innocence as historical countermodel to Brunner theories. It is quite easy to see this connection I just tried to elaborate between freedom, democracy, rule of law, and presumption of innocence. If one recognizes the historical roots of the presumption of innocence, or at least some of its elements, such as the indubitable principle and its development. Roughly speaking, the presumption of innocence always unfolds in competition with and against the model of suspicion that is punishment, the pena suspicionis. In Roman, the first rudiments of the principle in dubitable reo can be found around 400, and only in the 9th book of Triumphs with script myopia. Although the principle is not formulated there in the way we know it today, two fundamental ideas are expressed. Firstly, that no one should be condemned on the basis of suspicion alone. And secondly, above all, that it was better to leave a guilty offender unpunished than to punish an innocent. The latter contains a concession, and at the same time, a moral advantage for a state that prefers to accept the risk of compromising the state's interest in criminal prosecution in order to protect an innocent person. This moral consideration runs like a red thread through the history of presumption of innocence. Until well into the 18th century, the presumption of innocence was not really able to prevail against punishment or suspicion, particularly in Europe and America and Germany. There were certainly remarkable attempts from, for instance, the Hamburg criminal procedure or the Constitution Notice from 1532, according to which the punishment of an accused person without complete proof was regarded to be illegal. Dedicated attempts to establish at least the dubious sentence failed, however, throughout Europe during the 30 Years' War, which reintroduced suspicion-based sentences across the board insofar as they have been abolished technologically. The most important breakthrough of the presumption of innocence finally came in the Age of Enlightenment. Is that they getting a call for the automation of torture and anti-moral proof of guilt. The Declaration of the Rights of Man and Citizens from 1789 states tout homme étant présumé innocent jusqu'à ce qu'il ait été déclaré coupable. This sentence, which emerged obviously from the French Revolution, had a huge impact on the whole of Europe and beyond. Thomas Paine included its English translation in his Rights of Man as early as 1791. Every man being presumed innocent till he has been convicted. In France, the presumption of innocence was reinforced and further expanded by the qualification under Napoleon, for example, in Article 310 of the Code d'instruction criminelle from 18 8. In 1798, there was, not one of course, the older ones amongst you might remember, but there is a famous, rather famous, criminal procedure theorist that no one knows exactly what is going on. No one knows that his name is Johann van Beck, R.J.K., who was trying to implement the Kant's doctrine in creating rules. He formulated the following remarkable sentence: even if someone cannot justify his innocence completely satisfactorily, he must nevertheless be acquitted, because the judge either has sufficient evidence of his accused offense and is completely convinced or not. In the first case, conviction is required, and the other, acquittal. If someone is punished on the basis of mere suspicion, says he, this is unlawful. What is remarkable about the justification of the sentence is the change of perspective that it contains. It is not the accused who has to dispel the suspicion, it is the state who has to prove it by law. The argument is not yet based on fundamental rights under B. The presumption of innocence is legitimized as a counterpart to the penalty of suspicion with the argument of the moral superiority of the state. This is demonstrated by the fact that the state takes the risk of letting a guilty person in free. A morally superior state ultimately decides in favor of the freedom of its citizens. The Enlightenment also establishes the primacy of freedom over state security in the presumption of innocence. In practice, however, this principle did not initially prevail. The Prussian judiciary continued to impose sentences on suspicion until the end of the 1830s. The presumption of innocence in Germany only finally became established in science from 1805 and in judicial practice from 1850. It is worthwhile delving a little deeper into history to consider that the state and society fluctuate between the presumption of innocence and the punishment of suspicion, depending on the political climate, depending on the political system, depending on political objectives between security and freedom. The presumption of innocence grows in an environment of liberalism. It gains recognition when the state needs recognition. And this is dependent on the extent of the freedom it grants. On the other hand, the presumption of innocence as moral always encounters the powerful interests of states, societies, and their subsistence and security. It then finds itself on the defensive, and with it, democracy and the rule of law itself. The presumption of innocence has an enormous normative power, and yet is a fragile and conceptually often very weak principle. Being weak, not merely because they didn't get presentation, but being weak leads us to the last point. The fact that since quite a while, I think, we are getting used to the erosion of the principle of presumption of innocence. And the attitude that we might have developed that it is actually a conceptually weak principle, of course, doesn't make very optimistic when it comes to discussing all diverse aspects that we will discuss today and tomorrow. Just how fragile and weak this principle can be can be seen from what we have become accustomed to in legal policy in Europe over the past and recent decades. I would just like to indicate 3 examples. First example, grid searches, or rapid searches as you wish. Second, clear bargaining. And third, decisions on cost in the context of discrimination of proceedings. Grid searches throughout Europe. uninvolved third parties are targeted by law enforcement agencies in research. Thousands of potential suspects are filtered out based solely on individual characteristics, such as being male, female, student, aged between 18 and 48, or having an Islamic religious affiliation. In this case, the presumption of innocence gives way to the general presumption of guilt by algorithm. The latter is a modern, if you like, digital form of presumption of guilt. The more investigative instruments are extended to uninvolved third parties, the more procedural criteria associated with presumption of innocence, such as the concrete suspicion of offense, lose the limiting power. Hereby, the so-called deal, I don't like the word remind because it's often very often used in the geopolitical context, but still, the so-called deal has long since made it into the criminal procedure laws of the member states of the EU. Defense lawyers and public prosecutors negotiate a compromise that is acceptable to all parties on the basis of a sufficient suspicion according to the files, but not yet verified by the main hearing. The judicial authorities then initiate a confession that ends the proceedings. The course of the proceedings, the legality of the taking of evidence is largely omitted. The judgment is made on the basis of a reasonable suspicion. The circumvents the procedural limiting effect of presumption of innocence, usually for reasons of procedural economy. Decisions in costs, usually the topic named for next ECLAN topic, which is dramatically underestimated because of which, I mean, decisions of costs can torture all generations of F1 data before the second exam, particularly in Germany. It's awful. It's torture. It's nowadays it's done by AI circuit, but us in former times we had to calculate it on our own. And as long as in math it doesn't go very well together, anyway, decisions on costs in the context of discrimination of proceedings. It is contrary to the presumption of innocence to impose sanctions on defendants that are, mentioned it as well, equivalent in their effect to penalty, or a penalty-like sanction, we discussed it tomorrow, I guess, when it comes to confiscation matters, or to actually guilt to the criminal court decision without criminal guilt having been proven in the statutory procedure described for the purpose. The latter can be is if the judge is very beyond mere suspicions in the grounds for the cost decision and assigns guilt. Only nuances in the wording then decide whether the decision on costs violates presumption of innocence. However, the core of such cost decisions is a kind of probability of guilty cause. As such, it should be unobjectionable with regard to presumption of innocence. The decision in the medical case, for instance, by the invoking rights, the presumption of innocence in that sense, initially seemed to have been restored. However, subsequently, in case of England versus Germany and other versus Austria, this presumption of guilt clause experienced a kind of renaissance. Last sentence to conclude, actually with my views on current state of the presumption of innocence is based on an already amorphous principle whose individual normative components are proving to be less than robust in the face of political attacks. In the state of the presumption of innocence is a seismograph of the state of freedom. Sorry, if the state of presumption of innocence is a seismograph for the state of freedom and truth, then it is clear that the current challenges, not least those associated with artificial intelligence, do not go very well for freedom and truth, and consequently not for democracy and rule of law either. Thank you very much for your attention.
presentation, and now you the floor.
Professor Hertz has its presentation, Presumption of Innocence, Moral Realism, and Method. How to handle it. Floor is yours, please. Of course, very nervous with slides containing a lot of text, and lawyers are less likely to read my text but the screen being very small. So, lawyers want to come to.
And I said, what can I say? And then the answer was, what did you want to say? And it's something about the second thread that Stefan put forward. It is about these machines that put you in categories of suspicion, and that on the basis of that allow and trigger governments to act. Now, there's of course a feeling that the world is going towards an apocalypse, and that is a typical European way of thinking, very Christian-based. So I try to go as much as I can to India, where they have another view on and think less eschatological. But so I'm more into hope than into doom. Okay. So just to with regard to my own doom scenarios, there's a beautiful judgment of the with regard to the digital, with the European Passenger Lane Records Directive or regulation, where the Court of Justice has said no to self-learning algorithms in the judicial apparatus. It's actually under-theorized, but it's one of those brilliant things that we have to explore, and it's undefendable in the digital where everybody flips and is drugged by ChatGPT, but the Court of Justice says, no, we don't do it. And it might be a provisional standard, I don't know. It's law putting thoughtfulness on a technological craze, and that gives me a lot of hope for the future. Most of the work of the Court of Justice, and that's because I want to charm some now, my interest in the presumption of innocence, I never liked Article 6 of the European Convention, too. It's very limited. My take would be much broader. It's protection of the innocent for all the reasons that Stefan has underlined. You don't get a free society if everybody is under suspicion. And so it is a broader value behind that one sense that has crystallized in Article 6 as a defense right. And it's a normal crystallization. I think it's very much inspired by the work of Voltaire, who famously put criminal law on his agenda when he got older and made a big fuss about several miscarriages of justice in France, often against Protestants, French that were put on trial without evidence and so on and so on. So we get a principle of a presumption of innocence formulated towards the trial phase. And that was a huge step forward. Marcus Gabriel, a journal of today, calls that moral progress, but it is important to understand that this moral progress is an eternal development, and that perhaps we can go a little bit beyond the trial phase, and then we can talk about those machines that categorize you. So I did a lot just to warm up, and I'm going to show 30 slides in 7 minutes. But for those that like books, and especially books written by law and technology scholars, this is an impactful one. It's a Leuven scholar, Nicola who investigated the consequences of AI on the rule of law. And she goes around the world and has smart things to say. And he's especially warning all of us, also the criminal lawyers, that are reading the AI Act. And she calls that plainly insufficient. a missed opportunity for the EU to regulate technological development in its broader consequences. And for instance, what is so limited about the EI Act is that it's looking at a technology where all the problems arise with us using that technology unfold. So that's just a bit. I mean that she's a philosopher, and what I like about her is that she uses a rule of law definition taken from the conditionality regulation, where they actually put forward substantive criteria to bring this notion of rule of law to the floor, legality, legal certainty, prohibiting executive arbitrary power, effective legal protection, equality before the court, separation of powers. That's the EU understanding of the rule of law. Very concrete, and what Suhail does is very simple, looking at what those things mean, how they interrelate, and what happens to them when governance is based on AI. And there's a doom scenario, techno-rationality will prime, the coding of the engineers will introduce legal bias or will replace law. There's a danger, very important, of legalism, blind rule following. So this is a tendency amongst law enforcement officers that do not have a high salary, often have very little private life, and then fall into bureaucratic traps like blind rule following because they didn't sleep well enough because of an agenda of the Human Resources Department, and it's inhuman. And many more of those things are explaining why the rule of law is indeed under threat. And when you listen to the presentation, especially the examples of the Dutch child care benefit scandal and the post office scandal in the UK, it is often about how AI targets the innocents, and the innocents do suffer. And this is about, and it has to do with either being on purpose or being unthoughtful. And let's, for one moment, assume that it's thoughtful and not on purpose that we're doing that. It's not a European phenomenon. This is a Brazilian study showing exactly the same. The increase of the number of automatic denials is significant once fraud systems are based on AI. Yeah. So we have to understand that us playing with technology for efficiency reasons has an impact on the innocent. And and nothing, we haven't come up with good solutions. Okay, the Dutch government felt it immediately was re-elected and continued doing exactly what it was doing, relying on AI blindly to manage the state. And it's a problem for the left, it's a problem that wants to save the welfare state, and it's of course a problem with the right, everywhere that wants to do better and relies on techno-millionaires. So anyway, you don't read this one, but I wanted to suggest that there's a lot in it, and that I do think that it's it can be related to fundamental rights, to human dignity, it can be related to defense necessities, but it's very much rule of law related in its substantive damage. So for theoretical underpinnings, we have a wealth of theories. Now, just because I was sensing that we would all end with some doubts, the geopolitical that is not looking very trustworthy, some doom, European too. Just a couple of things that have to do also with this theme. I never liked Kafka. Never could stand his stories. I hated it. And then I read in the biography that for him they were meant to be funny. And so you have to imagine Kafka going home, reading aloud his doom stories, and the whole family laughing. And for me that is still very hard to digest, and I still hate it. I still don't like it. I do it because it looks intellectual and all. And so in all these stories, there is a message against law. And the more you expect from the law, the more you will suffer. And so it's, in short stories, before the law, the trial, the castle, all of the problems of our law, people are not even sure if there's a legal system. So there you have Kafka, a brilliant legal scholar, doing emancipatory work too, but writing these dark things about law that just at this moment is not what I really need. And this is the eye-opener for me. He explained why nobody got Kafka, because the lawyers were reading it in silence, and all the human, and all the linguistic and philosophical commentators were reading it as non-lawyers, they're not understanding. But so, in essence, there is a strong message about modern law failing in Kafka. And Litovich is wrote a PhD on Kafka in the States. Even Litovich has problems with it, but he does admit that there's a lot of strange things happening in the US. And these things made me even more unhappy. These are all facts from the last 10 years, but there are mass arrests, the discretionary stops, there's domestic spying, people are put in black sites, there's wiretapping of innocence, there's technology, everything. I don't know what that is. Yeah. So, and there's a lack of access, if you know how many lawyers there are in the US. So, even a person critical of Kafka does admit that the doom of modern law and the failure of modern law, the unkept promises, that the message is not one of the Bohemian region 100 years ago or more. No, it's today. And so, is Europe doing better? I found this one, the ghetto package of the Danish government, just singling out areas where people were put under an arbitrary regime, houses were confiscated, and punishment was allocated differently, twice as hard. There's now some action at the legal front against the Danish ghetto package, but it's 10 years old, and it has been implemented for 10 years, and we're institutionally reacting only now. So there are probably many more things in the past. I wrote about police accountability and the choice between crime control and due process. We all teach this. We think it's an American choice, and we have chosen in Europe for due process model. But if you look at the police laws as they are in Belgium, you find a very subtle balance between due process and crime control, with like the prohibition to use violence, the very due process formulated, but all the others asking for identity cards, looking inside cars, all bodily searches, formulated in such a way that independent judicial review is zero, impossible. The judges cannot do anything with these provisions. And if after 40 years of existence you have no case law on those intimate things and those harsh, traumatizing police interventions on people's security, then that is a sign that things are not working. Now, and what is the main weakness of these things is the level of suspicion required for police and law enforcement authorities to act. We don't like that. We like truth, and we like to make truth finding doable. And so what Stefan said is true. We have hints towards levels of suspicion. We actually use that as one of the safeguards, but it's poorly developed. And I think Europe is fighting with that too. I read this interesting, difficult week of Sachou Lido, discussing European Court of Justice hesitations with regard to the suspicion that you need to trigger law enforcement action. So I refer to that and all the scholars today and tomorrow to clarify that a little bit, but at least this author thinks that also the European there are many shortcomings. And for me, this has been, especially the last quote is very important because requiring a threshold of suspicion is more evident, says Soikova, a person I like a lot, I find very fascinating, in the Anglo-American legal tradition, but it's less evident in civil law systems. So that is the cloud. We're on the continent, there's a Brexit, so we're really continental, and Germany is a world leader now of the free world and also continental legal developments. But how are we doing with regard to this aspect of the presumption of innocence? And I think it can be made stronger. And I always, if I compare the Fourth Amendment, I have that. So you have my bed, my pillows, and then there's the Fourth Amendment. There is no European Convention in my room because I just cannot stop rereading the Fourth Amendment. It is very rich. And of course, in this context today, I just want to single out the problem of cause ID. So I think that's where we should go to in the context of the digital tool. But remaining within the criminal law sphere, I think we can regulate truth and we can improve truth. And I would hope one day to see that appearing more clearly in the context of our European Convention. Now, coming back to Kafka, I've been reading for 15 years critical Enlightenment literature, throwing a philosophical line on Kafka. A classic is McIntyre, saying we're all lost, we're all blindly acting, and we are all role-playing, we have managers, we have the state managers, and we have the lost citizens, and we have the free market guys. And if the citizen doesn't like the market or something else, they turn to the government. The government doesn't know either where to go, what to do, because we're all blinded, and implements often its own agenda rather than satisfying the request of the citizen. So McIntyre brings a very dark picture of where we are, one that better explains than Enlightenment the American series of problems that I just showed on the PowerPoint. So human rights are fundamental, but as fundamental are the four liberties of the European Union, the agenda of giving us a greater union, and things like efficiency and innovation. We see that in the digital, with Ursula now announcing a review of the GDPR because it hampers innovation and those. So that is a reality sketch of where we are. Conflicting values, uncertain outcomes. Is there anything fundamental about fundamental rights? Yes, but there is more fundamental things, and a closer look reveals that not much is fundamental. So, and I still like to reread Annette Alby's critical analysis of the Court of Justice judgment in the sphere of criminal law, where she shows that the Court of Justice then, because the article is old, is actually implementing an institutional agenda of €1 billion, prioritizing it, and defense rights and so on second or the very good to not to forget that before we declare one court as opposed to the other as a moral saint. So it has an impact on my work that became less and less optimistic, that became less and less skeptical, but I now try to be looking the other way, and I turn to Marcus Gabriel. I have him in Dutch. He's the youngest full professor of philosophy in Germany. And he boasts an agenda of the new enlightenment. And it's a good read for all of us. I don't like a lot of specific arguments in the book, but I do admire the tone setting and the drive. So if we are looking for a message of hope, I think it's in that book. And it reminds me a lot of what Voltaire. It's this believing progress in a very straightforward way. So if you're gloomy about Europe, would you rather be trialed in Brazil? That's the kind of question they would ask, and that is Marcus Gabriel is asking. Yeah? So if you are going to hell, is there any better place? That's, for instance, so, and what Marcus Gabriel does is calling for resilience, and he goes to the extreme in a neo-Kantian way, insisting on universal values that exist everywhere, that have existed all the time, and that are non-negotiable. So that's very strong language. But it's good against the kind of mysticism and relativism that is being pushed in our minds through all the media. This is way too much text. So, but it's also the bottom line is that where McIntyre says we are lost individuals, we're lost society, we have no priorities. Marcus Gabriel is okay with that, but proposes to reconnect with moral values. So it's a step further. It's an interesting step, and the state is in our continental understanding of enlightenment is a partner in that, and we can and do expect moral progress and moral behavior from the state as opposed to the US system, where the state is looked at differently. So very interesting conception, and also plea for Europeans to move forward with the instruments they have. So I kind of like that. So what does he actually say? There are things that are good, there are things that are neutral, there are things that are bad. Yeah? Yes? And those are the three values, and they're universal. And we judge things in the light of good, neutral, and bad. And but sometimes we misjudge. Yeah. And that is because we are badly informed, and that is again this enlightenment touch, often about non-moral facts. So we don't see the misery that unjust intervention of the police with the life of the citizen does to citizens. We don't see the effects of that simple intervention on the trust that people have in the legal system. Today we understand these things better. So there's moral progress possible because we have a better grip, not on the values that are always there, but on the non-moral facts that we now made more transparent. It's a difficult thing. And so abortion 2,000 years ago, famous philosophers thought you were born as a little human being from day one. Today we know there is a process of self-development and so on. And so we are not born as a little mensch, we become a little mensch. And that allows moral progress because we don't want to commit murder, which is an act on humans, because this self-development does not create humans right away. So difficult, complex argumentations to show the kind of mental moral exercise that Gabriel wants to do, bringing in the picture non-moral facts, but understanding that there are moral facts. So that's his strength for me. Pushing a little bit against scientificism that only sees hard sciences as being able to produce moral facts. And one of them is, he proposes a methodology that's there. I'm going to give the PowerPoint to Liga and so they can do with what they want. But the thing is, we need to transpose ourselves in the other. In this case, it would be to the enforcer, to the law enforcement apparatus that is using bad AI or bias code AI and all these things, to police officers that have not slept well and then ask identity documents of young migrants at the age of 7, so they're so we actually create citizens that distrust governments. But we can listen to those people, but there's a limit, says Marcus, to the acceptance of their views. So there is no no license for value relativism in this. And one of the moral facts that he singles out is the fact of arresting innocent people. So there we are. For Marcus, this is a moral fact that has existed always, and that does exist everywhere. And but there can be new questions with moral facts. So if we're not allowed, because this is clearly evil, to break into the lives of innocent people, what about AI that categorizes people, taking implicit the risk of error and interventions in the life of innocence? So that's a new question with regard to a moral fact, caused by a non-moral fact that is AI. You get it? Am I losing you? Yes. I kind of like this distinction between moral facts and non-moral facts. And so, I should have given this list earlier just to make you all new Kantian, but this is the strong Voltairean formula. If somebody disagrees with this list of moral facts, then Marcus Garvey would have it. So there's more morally self-evident than we think. And we see no problems. We understand that authoritarian regimes will use AI in a very brutal way. We understand that Trump will let AI be used in a very discretionary way to please big tech, so to value. But Marcus is very straight. Annoying innocence is a moral evil. And so these exercises are good because we had 3 decades of philosophy that was value pluralist, value relativist, and I myself have too much of that. So for me, this was it's like listening to my father or something. Yeah, and so protecting the innocent is a moral fact, and I repeat that one reflection. The digital is new, and so is our use of models, profiles, and AI in general. They are not perfect. They include consciously error rates, and so is the government that is using these technologies. So we need a new moral conversation. And what I want to go through is a little bit away of law literature solutions. These, for instance, again, her broader recommendations to open this discussion, public oversight, public monitoring mechanisms, and the introduction of procedural rights for societal dimension. This is very there's a deliberate attempt behind this program to go beyond the individual and let it be that the criminal trial is very much individual focused. So the solutions that are proposed are often meta criminal law solutions, but have to do with management of criminal law, criminal justice systems. Now, I'm not happy with that, of course, because I think that criminal law, and that's what we here can play its specific role. And there's a lot, I even gave the numbers to show very learned. But let's look at the Fourth Amendment and try and see whether we can learn something about it, also understand why all these atrocious police actions in the US, as shown by Licorice, are possible in the framework of the Fourth Amendment. Let's look at the Belgian police law and others with an indifference towards the innocent and a clear privilege for wide discretion for police officers in many regards. And let's get the principle of innocence out of its trial focus and let it be our vanguard to look again at the pre-trial phase that is on the continent the most important one with regard to the evidence collection. And so and again, Stoikova is inviting us for that. She's showing, she says this kind of reflections are compatible with the European Convention on Human Rights and Fundamental Rights as living instruments that should have something to say about the society today. So this invitation of Marcus Gabriel to sit down and think about the 21st century is a moral call, but it's also a fundamental rights call to be made in this. And what Stoikova also brings to the fore, which I found important, that the realization of this idea of presumption of innocence in the pre-trial phase will be different than its realization in the trial phase. And so, but that doesn't mean anything. It has to be guaranteed all over, but we need to look for specific guarantees. So I'm going to end there. The last slide is horrible, with even more text. But I want to go towards that. I think we're in the context of the principle of innocence. We have panels on the burden of proof. That is very much trial focused. We also need to address the triggering points of criminal investigations and law enforcement actions. That is so what I call the burden of suspicion. It was mentioned before. Stefan, you captured it well. We are accepting a suspicion-driven society, and it is not for this. But Gabriel helps us to get out of it. Thank you.
Thank you very much, Professor. And with this very interesting presentation, we conclude the opening session of our conference. There's no formal discussion for this session. Actually, we have to make very tough decisions to be in time. We already break our schedule, but it's okay. It's time for our first coffee break, and after 15 minutes we will continue with the next session, and there will be a place for discussion as well. Thank you.
Presumption of innocence, modern trends and contemporary challenges. Let me start by really very warmly thanking Professor Christine Rosenberg. I'm sorry for pronouncing maybe not in the correct way your family name, for inviting me to this very interesting conference and also to let me to share this, this session on the scope and limitation of the presumption of innocence, and with all these very distinguished speakers which are sitting this, in this table. Let me wish me to somehow introduce the session, trying to somehow to put on the table all the many topics. Some of them have been already mentioned in the introductory session. The many topics which are now, say, also the challenges concerning the scope of this principle. Because all the previous presentations actually have very clearly expressed, let's say, the crucial relevance of the principle of presumption of innocence. It is to say that these principles expresses, it marks the position given to the citizens, to the individual, in front of the state, whenever criminal law responsibility is at stake. We saw that, clearly the focus of the principle is that until proven guilty, essentially by the prosecution, the person shall be considered innocent. And this implies a series of guarantees that must be considered as enrooted in the principle of presumption of innocence, and in fact have been the object of a well-established jurisprudence by the European Court of Justice under Article 6.2, and in line with that also of very well-established jurisprudence by the European Court of Justice, and also some aspects are covered by Directive 343 of 2016. Now, at European level, we are very used to, refer to the presumption of innocence as a defense right, the right of a suspected person to be presumed innocent. However, I think it came out very clearly from the introductory session that the presumption of innocence is much more than a defense right. It is a fundamental principle which is meant to enlighten and feed the entire criminal proceeding. The presumption of innocence is meant to provide, for example, the way to gather proof, the rule according to which the burden of proof as a matter of principle is supported by the prosecution, and also, for example, the rule of non dubio pro reo, or the, the specular principle of the criminal standard of beyond any reasonable doubt. And this is probably why also the European Convention on Human Rights and also the Charter of New Fundamental Rights distinguish, so provides for different provisions concerning the right to be presumed innocent, which is in Article 6.2 of the European Convention, Article 48.1 of the Charter, from other defense rights, Article 6.3 of the Convention and 48.2 of the Charter. Somehow quoting the Article 12 in Directive on European Investigation Order, the presumption of innocence can be considered as, I would say, the cornerstone of all fundamental rights which are recognized at European level. This is the fundamental of the fundamental rights, we could say. And saying that, while the directive, we see it also during our session, while the directive 343 of 2016 proposes common minimum standards, because that was actually criticized by some scholars because of this minimum approach, and we know that the well-established case law of Strasbourg Court clearly goes much farther, because according to the European Court of Strasbourg, Article 6.2 also protect, and this I think was mentioned also by Stefan Braun, individuals after acquittal or discontinuation of criminal proceedings against such proceedings. And moving further, the Strasbourg Court stated that it is not compatible with the presumption of innocence, a situation where an accused person is obliged to bear the court costs and compensation when, for example, the decision constitutes a consequence and the concomitant of the substantive criminal proceedings. And even with respect to the relation between criminal and tort procedures, such as compensation procedure for damages, the European Court of Strasbourg found that an acquittal does not preclude the establishment of civil liability in relation to the same facts. However, if the national decision compensation contains a statement imputing the criminal liability to the respondent party, it could overstep the bounds of the civil form. Looking at the comparative perspective, which will be also dealt with during the session, if we look at the constitutional rules of most of the EU member states, in most of them, the presumption of innocence as a constitutional ranking, as was established. This is the case for France, Germany, Italy, Poland, Spain, even if it is not sometimes explicit, as in Germany, or even in countries which are not EU members anymore, where a written constitution is missing, where the Directive 343 is not legally binding, it can be observed that the presumption of innocence is an essential feature of the legal tradition, a fundamental principle of the law. So focusing now on the, I would say, on the main topic of the session, that is to say the scope and limitation of the principle presumption of innocence. I think it is worth mentioning what happened in recent years, more or less, concerning some decisions by the European Court of Strasbourg that have somehow revamped the debate about the connections between the presumption of innocence and the principle of fault or guilt. I mean, it's quite difficult to choose between these two terms. And the possible interpretation of Article 6.2 in a way that it also holds at least some aspects of fault. And the question arises, the question is not a minor one, because the question at stake is the possible recognition of the principle of fault, or the principle of guilt, or at least of some aspect of this principle, as a fundamental right and the consequent possible binding contents for the member states or the state parties of the convention. We know that, I mean, looking at the legal order, the requirement for a subjective element of the mens rea to be established in order to consider the criminal offense as established, so as an essential element of the offense, has been recognized in many judgments. In addition to that, the requirement for a subjective element as an essential element for any punitive sanction, so a punishment according to the Angular criteria, was recognized as a general principle in the system of EU administrative sanction, as is the case for regulation of competition and also the regulation of administrative sanction of 1995. However, the principle of guilt is not mentioned in the EU Charter of Fundamental Rights, and it is not mentioned in the European Convention neither. However, some very well-known decision by the European Court in Strasbourg dealing indeed with Italian provisions on confiscation of buildings resulting from the offence of unlawful land development have relaunched and put under the spotlight the focal issue of recognizing the principle of fault, or at least some aspects of that principle, as a fundamental right under the European Convention of Human Rights, something that would have evident repercussions also on EU order because of the role of the European Convention in the EU legal framework concerning the fundamental rights protection as established in Article 2 of the treaty. We all know that this question, this point, was already, say, handled by the Court of Strasbourg in 1988 in the Salviaco case, where, I mean, the court has decided that the presumption of law or facts were at stake in that case, and so the criminalization on the basis of purely objective facts without requiring intent or negligence was not in violation of Article 6, provided that it was kept within reasonable limits, taking into account the importance of what is at stake and maintaining the rights of the defense. So the conclusion that can be reached, apart from the merit and the limit of this acknowledgement, is that according to the court, the specific aspect of presumption of fact or law did fall in the scope of the presumption of innocence. And in the same line, also the Court of Justice in the Hansen and Son case reached the conclusion that the Danish law implementing new legislation concerning driving times, rest and rest periods, and establishing strict liability on the company whenever one of the drivers from the company had infringed EU rules does not clash with EU law obligations. So indeed, strict liability is regarded by the European Court of Justice to be possibly efficient and also deterrent under certain conditions. And I will just stop by saying that a quite radical change in this approach seemed to have been inaugurated by, again, the Court of Strasbourg in 2009 in the case of Fondi, where the court, after qualifying the confiscation of the buildings and plots of land resulting from the offence of unlawful land development as a criminal sanction according to legal criteria, reached the conclusion that Italian legislation did infringe the convention when imposing confiscation after that offence of unlawful land development was set apart, and the court did so by referring to Article 7 of the convention, assuming that the rationale itself of the punishment and the notion of guilt in European Convention Article 7 must imply a subjective element of consciousness and will and must be imputed to the person of the to punish him. So, while the argument was not very clear developed by the Strasbourg Court, the fact that the sheet, I would say, from the reference to Article 6 to the reference of Article 7 did have the relevant consequence to consider the topic of presumption in the framework of the legality principle, which is among the non-legal rights. However, the reference, and this is the reason why we still are here discussing also about these topics in a conference dealing with the presumption of innocence, the reference to Article 6 came up again in the legal reference of the Strasbourg Court to deal with forms of strict liability in the GM case in 2018, again dealing with Italian legislation on confiscation of buildings. And indeed, in the previous case, in the Barbara case in 2014, already the court has somehow, watered down a bit its position of Fondi, saying that Article 7 does not explicitly require any psychological, intellectual, or moral link between the substantive element of the offence and the person. So the the court does not exclude compatibility with the Convention of Forms of Strict Liability required in order, in any case, a finding of liability. And this conclusion was confirmed in GM, where, however, the Strasbourg Court also referred, in addition to Article 7, also to Article 6, when it concluded that Italy indeed had infringed the convention because the applicant was found guilty in the sense that was applied with the measure of confiscation, notwithstanding the fact that prosecution for the offence in question was time-barred. And this was considered by the court as to be contrary to Article 6, so the presumption of innocence. So the main reaction to this judgment, also some following ones, show that a final position on this point was not achieved so far. And then, I mean, as it is the nature somehow of the ever-evolving interpretation of the convention by the court, I think that, I mean, we have a lot to discuss in this, I mean, this section that will cover several aspects. The case law of the two European Court, the comparative approach concerning possible limitation, legitimate limitation to the presumption of innocence, and also the specific focus on Directive 343 of 2016. And I'll give the floor to Mrs. Ineta Zimele. I don't know if the name is, I pronounce it correctly, which judge at the Court of Justice of the European Union, but is also a Riga Graduate School of Law of Latvia. Thank you. Take the floor. Well, yes, hello everyone, and first of all, thank you very much to the University of Latvia Faculty of Law and Professor Strada Rosenberger for this very kind invitation. I am very happy to share with you, let's say, some of the experiences that I've had, not only in the Court of Justice, but also previously as a judge of the European Court of Human Rights, and also in between the two European courts as the judge of the Constitutional Court of Latvia. And so it is indeed a very judicial perspective and very much an insider's perspective. It's going to be rather technical. Unfortunately, I cannot embark on discussing very important, in my mind, conceptual matters, and I'm grateful to the first panel for having done so. Now, the aim of my presentation is to compare and distinguish how the European Court of Human Rights and the Court of Justice of the European Union approach the presumption of innocence, which is a fundamental premise of the right to fair trial in our European legal space, but I indeed subscribe to all those that mention that actually it is part of our value system and of our European identity, which might be eroding. I will come back to that point. Now, first of all, in my mind, it is clear that thanks to the case law of the European Court of Human Rights and the development of the European Union law, a consolidation of the understanding of the presumption of innocence is taking place among European states. In fact, the question of how much room has been left for different national traditions in this process is a very interesting one. And since it was mentioned at the beginning that this conference should inspire some more research, I think this is the point, the theme to really study, just how much different national traditions, conceptual and practical, there are remaining. And as I said, another topic indeed that merits a fundamental academic debate is the one mentioned by Professor Brown,
that is, are we in the epoch of erosion of the understanding and the scope and the limits of the presumption of innocence? Now, having said that, what I would like to really emphasize is the following. It is true that typically in academic debate, in legislative debate, we refer to the two European courts. Now, the two courts operate very differently, and they impact national law, national conceptual debates in very different ways. And I think for your future reflections, for the discussions that will follow, this is very important to bear in mind. Now, the two courts also have, because of their different competences, because of their different sort of modus operandi, they have very different impact on different legal institutes, such as the presumption of innocence. Now, it is always important to keep in mind that the primary role of the Court of Justice of the European Union is to indeed ensure and achieve a uniform understanding of what the EU law actually provides for, because what we are building is the common European legal system, common to 27 member states. Now, it is very different perspective, the one that the European Court of Human Rights takes, which has an individual case which arrives at the European Court of Human Rights at the end of the proceedings with the final judgment from the national highest court, and where, in fact, the European Court of Human Rights pronounces actually on that law, on its interpretation, on the facts in this individual case. Now, for us, in the Court of Justice, we actually enter the picture while the proceedings are pending at a national level. We are answering to the questions formulated by the national courts. We can, of course, streamline those questions, which we do. Those of you who follow closely know that. But our sort of reformulation is also rather limited. So we're rather bound by the way the national judge sees the issue. And we are there to help the national judge to apply own national law, but in a way that is in conformity with the European Union law. So we do not assess the facts. We do not assess the national law. And so we are interpreting the particular EU rule, of course, in the context of those facts and national law, but it is the EU rule that we explain to the state concerned, and it has erga omnes effect across the European Union. So it is therefore that sort of our function is just so very different. It extends across the European Union, crosses the borders, while the Human Rights Court actually, and the Article 6 of European Convention on Human Rights, is applicable in every individual case as we speak. All of the proceedings, all of the litigations right now in Europe, the judge has to be aware of what the Article 6 standard is and has to sort of keep that in mind. while whether or not there is any EU law matter, that is a different, story. So that oftentimes in research, in practical, in industry discussions, these fundamental differences tend to sort of blur away, and that should not happen. Now, what concerns the interface between the EU law and national criminal law and procedure, I would really like to start with Title V of the Treaty on the Functioning of the European Union, entitled Area of Freedom, Security and Justice. And Article 67, paragraph 1 in the Treaty on Functioning of the European Union states, just to remind ourselves, the Union shall establish an area of freedom, security and justice, respecting fundamental rights and the different legal systems and traditions of the member states. That's a very interesting research subject, as I mentioned. So one of the essential features of this area, as we all know, is mutual recognition of judicial decisions in criminal matters, cooperation and coordination between the police and the courts, and approximation of criminal law as it may be appropriate. And I would like to stress that recognition, cooperation, and approximation are based on principles of loyalty and mutual trust between the member states, as provided for Article 4, Paragraph 3 in the Treaty on European Union. So mutual trust is that basis which allows for the recognition and the enforcement of a judgment of the judicial decision adopted in another member state. Now, that requires that we, within the EU legal space, are actually certain that we have similar understanding of the purpose of today's conference, the presumption of innocence. You know, the fact that we share the understanding is fundamental for the functioning in one of the key areas of the European Union, and that's why what you are discussing today is so very important. I mean, for us, then, the judges. Now, Article 83, Paragraph 2 of the TFEU is the basis for the competence of the European Parliament and the Council, the EU legislator, to adopt directives laying down the minimum rules for the implementation of mutual recognition and cooperation in criminal matters. Now, it is spelled out in the treaty that this concerns, so there the legislator, the member states have given the competence to the EU legislator to legislate on issues such as the admissibility of evidence, the rights of the individual in criminal proceedings, the rights of victims, other specific aspects of criminal proceedings if the Parliament agrees to the Council's actions in this respect. Now, the traditions of the member states are respected, and the right to set a higher standard for the protection of persons, broader understanding of the presumption of innocence in a country is actually in the constellation. If you look at how we would interpret the treaty, these articles, you would see that we would allow for a higher protection of an individual if sort of the tradition calls for it. Now, there are two comments at this stage as far as comparing and contrasting of the ECHR and the EU law in this regard is concerned. Now, firstly, the European Court of Human Rights has said that it does not, in principle, assess the nature and admissibility of evidence. unless, of course, a complaint has been made that they were obtained in breach of Article 3 of the Convention, the very famous still Gafgen against Germany case. That reminds us of that complicated debate in the Human Rights Court. I was part of the composition at that time. The interesting discussion, the fruit of the poisonous tree, and the European approach to that is different from the American one. So that's another interesting discussion we might have. Or, for example, as in a case Baltinch against Latvia, where the conviction was based on the investigative experiment, such investigative experiment that actually triggered the committing of a criminal offense. Now, in any event, it should be noted that Article 83, paragraph 2 of TFEU goes beyond the European Courts of Human Rights case law approach and opens the door for EU legislative action, because I've said admissibility of evidence is one of the areas specifically spelled out in TFEU. So you already have here sort of different, it's the parallel certainly cannot be drawn. Secondly, the legal act which regulates the EU common standard in this area is directive. That's specifically provided for in the treaty. Now, that means, as we know, that directives are binding as to their objectives, but they will be implemented again by national means in accordance with national traditions. And so thereby, the directives normally would not provide an individual with a justiciable right. However, it is imperative, according to EU law, if the individual, suffers a violation of individual rights because the objectives of the directive have not been properly complied, there must be a right to an effective remedy in a form, for example, of a compensation for that right. So you again, you see how systemically the two European sort of systems impact the national discussions and debate. Now, for today's reference, the EU legal act of particular interest indeed is the Directive 2016/343 on strengthening certain aspects of the presumption of innocence and the right to appear in person at a trial in criminal proceedings, also already mentioned by Professor Strada Rosenberg. And I would really like to say a few words on the directive. Now, from the perspective of a judge, to simply show you how we look at the directive, what we start with. First of all, it is important to underline that the scope of the legal relationships covered by the directive is limited. According to recital 11 of the directive, this directive should apply only to criminal proceedings without prejudice to the case law of the European Court of Human Rights, and I'll explain what it means. This directive should not apply to civil or administrative proceedings, including where the latter may result in sanctions, such as proceedings relating to competition, trade, financial services, road traffic offences, taxes or surtaxes, and to investigations carried out by administrative authorities in connection with such proceedings. So when you look at Articles 1 and 2 of the directive and you read them in conjunction with recital 11, it is clear that the directive only applies to the rights of an individual in classical, if I may say so, in criminal proceedings. And that is also very clear in recitals 13 and 14 of the directive. So unlike the case law of the European Court of Human Rights, which under Article 6.2 embraces situations such as, for example, where one and the same person is a subject of criminal and administrative proceedings, which is a very relevant situation for the presumption of innocence, And so the court assesses whether the presumption of innocence has been violated as a result of such parallel proceedings. And we would have the formulas from the European Court of Human Rights. The directive clearly does not apply to such parallel proceedings. Now, I'm not saying that there are no problems in practice. It is, and that they should not be addressed as a matter of constitutional law, as a matter of human rights law. All I am saying is that this does not fall within the scope of the directive. And so that the expectation should not be more and should not be less. For example, in one of the interesting cases, European Court of Human Rights, S. Honkulov case against Russia, the European Court of Human Rights viewed a question of presumption of innocence in relation to administrative proceedings for the extradition of a person, and viewed the proceedings against that same person, criminal proceedings, in the requesting state, and in fact found a violation given the language used in both sets of proceedings that undermined the innocence of that person, prejudged already the person's guilt. Article 4 of the directive imposes as one of the first obligations of the state an obligation on public authorities not to mention a person as guilty in their public statements and in judicial decisions that do not establish the person's guilt. By the way, Latvia, one of the first cases in the European Court of Human Rights against Latvia was exactly the case about public statements in criminal proceedings where the judge pronounced herself and where the ministers pronounced on the guilt of the person. And that was the case Lavens against Latvia, some of you may know. So we learned it hard way many years ago. Now, as far as the directive is concerned, it is extremely important to understand, as I mentioned, the effects of the directive, especially in relation to such Article 4. Does the Article 4 establish a subjective right to an individual if, in case, public officials have pronounced on the guilt of that individual? Now, in fact, as far as Article 4 is concerned, there is no pronouncement of the Court of Justice on the direct effect of that particular provision. Sometimes it does happen, the directives. But as I said, if there is a problem at the national level as concerns public statements of the officials, then under the directive, there should be a possibility for such a person to say, if no protection exists, that the directive requires at least the proceedings in damages. It is also relevant to mention in that context another human rights court case against Latvia, Kangaris against Latvia, where the court found a violation of Article 6.2 of the Convention because of two parallel proceedings in which this person was accused person. In this case, the Human Rights Court pointed out that the presumption of innocence precludes a finding of guilt for a particular offence outside the applicable criminal proceedings, irrespective of procedural safeguards in parallel proceedings and irrespective of general considerations of expediency. Thus, to consider in one proceeding for a particular offence that the applicant has committed another offence which is being dealt with in parallel proceedings is contrary to the applicant's right to be presumed innocent of the offence. Now, this example, why do I bring it in the context of Article 4 of the directive? Because this example makes me think of the court's public statement of a person's guilt in unrelated proceedings, which is under Article 4 of the directive, an impermissible behavior. And so here, I just sort of draw your attention that we might have an interesting constellation while the directive does not deal in principle with parallel proceedings. It really focuses on criminal proceedings. It does prohibit public statements largely speaking, on a person concerned. And you may have, again, a little bit of asymmetries because of the two European sort of systems applicable. And one has to be, those who apply law nationally have to be very careful. Now, the issue of obtaining and establishing evidence and proving the evidence is, of course, a central theme in criminal proceedings. Well, as we already discussed, not least for the purposes of the presumption of innocence. And here is a very interesting point. Now, according to the Human Rights Court's case law, the burden of proof evidently lies on prosecution. And Latvia traditionally belongs to the tradition of accusatory process. However, if you look at recital 23 of the directive, which states that in the various member states, it is not only for the prosecution, but also for the judges and the competent courts to seek both corroborative and exculpatory evidence. Member states without an adversarial system should be able to maintain their current system, provided that this, of course, conformity with sort of the other principles of the directive and the EU law. Now, Article 6 of the directive places the burden on the prosecution to prove guilt, but at the same time, it does respect distinctive traditions. It says that this is without prejudice to the obligation of the judge or competent authority to seek corroborative and exculpatory evidence, nor the right of the defense to present evidence, etc. So you see that there are traditions in which the courts, and we know them, play more active role than, for example, in the other traditions. And that, according to the EU law and the directive, such diversity in traditions on the role of the judge is perfectly acceptable. Now, at the same time, the European Court of Human Rights in Pandy against Belgium case has set a very strict standard for judicial pronouncements. In that case, the court said that judges are subject to a stricter test than the statements of the investigative authorities. So here again, I would like to point out to you that while within the European Union, because of the nature of the Union, national traditions, well, we need to respect them as well. At the same time, when you look at the matters of the criminal proceeding, specific criminal proceeding, in a sort of vertical sort of perspective, you see that the judge has to behave and cannot pronounce whatever comes to his or her mind. So there you have, again, an interesting sort of contrast and comparison. Now, a very interesting case from the Court of Justice from Bulgaria, BK case C-175/22, where the court decided that union law obliges a criminal court to inform the accused person of a new envisaged legal classification of the criminal act in due time. And the Bulgarian law contradicted, in this case, Article 6.4 of the directive. Now, the court in this case emphasized that communicating legal classification is of decisive importance for the effective exercise of the rights to defense. So there again, it is linked, of course, and that's why the presence at one's trial in the directive and the presumption of innocence are the two aspects that are linked together, because the presence in a trial ensures that through effective exercise of our right to defense, you protect your innocence. And in the case, in this particular case, which we had from a Bulgarian court, in fact, it was possible for the Court of Justice to say that the judge, in the line of the highest standard for judicial behavior, the judge cannot just in the middle of the game change the classification of the criminal offense without informing the accused person of what is going on. And that is also linked to a particular point in EU law, that the trials in absentia are in principle prohibited under the particular directive. Why it is so? Now, I go back to the Treaty on the Functioning of European Union. Because in the European Union, we have created a common space, legal space, without the borders. And indeed, people freely travel. And that, unfortunately, may stimulate evading from criminal proceedings. Now, in the European Union law, and the Court of Justice has oftentimes emphasized, if you look at the judgment, you will see that there is a perspective of a victim in the judgments. And you will also see that we certainly cannot interpret either the directive or the primary law in a way that would assist in creating a space of impunity in the European Union. And that is why trials in absentia are sort of prohibited, but there are specific standards, knowing that people evade. And according to the directive, what the legislator has decided, in case you have to go ahead with the trial, it is important that there is a guarantee when the person learns of the judgment that the person can request the reopening of the proceedings. Now, my final point indeed concerns Article 48 of the Charter, its relationship with the European Convention on Human Rights, and where we are with that. Now, the first point that I will make is the following, that the Charter of Fundamental Rights cannot give rights independently. It only works together with primary or secondary law, and that's oftentimes forgotten. It's not the perspective of Article 6 of the Convention. That's the difference. Now, the Charter provides for a minimum standard. European Union law, because of the particularities of the common space of security and justice, European Union law may provide for a higher standard that may be in the interests of mutual trust. And there are areas where indeed we do so. While the directive does not apply, for example, to competition law, if you look at many judgments in competition area, the Goldman Sachs Group judgment in the General Court comes to my mind, just because it's a very known story. The Goldman Sachs, there was a question earlier what to do with presumption of innocence of legal entities. In the EU law, legal entities have presumption of innocence. The General Court assessed the claim of Goldman Sachs that their presumption of innocence was interfered with, given the way the competition law works, notably the presumption of actual exercise of decisive influence, which characterizes the competition law. Now, the General Court assessed and stated that, in a way, a more fundamental presumption of innocence against which the particularities of competition law are assessed, that, in this case, withstood the test. So to finish on that, I would say that for those who apply law, it is extremely important to verify whether there is relevant, well, EU law legislation and the case law of the Court of Justice, because it might, just in the areas of EU competences, provide for a higher standard of protection than a national law provides, or the European Court of Human Rights. And one should be also very careful how symmetries and asymmetries between the two systems sort of appear. And finally, the wish to the network and to the conference, I really think that theorizing about the presumption of innocence, as we have seen already so far today, is a work in progress. And especially, well, these days, in times of threats to our democracies of different character. And in my mind, there is absolutely no question that there is a need for this academic debate, because it is this type of debate, I can assure you, that the judges follow. I know in both European courts, being the very different, we do follow and we do get a lot of inspiration for better adjudication of the cases that come. And I thank you for your attention.
Thank you very much for this very comprehensive overlook of the European standards on presumption of innocence, also for stressing, I would say, the complex dynamics which lies behind this progressive setting up of what Professor Rosenberger called a piece of a EU common legal culture. Now I ask Professor Conway from the Brunel University of London to take the floor. He will present a speech on the formal and informal or de facto limitations of the presumption of innocence and a comparative and European perspective. You have the floor.
So, let's find a bit short. This one? Yes. How do I move? No. Is this one too? Probably walk. Just on that. Right. Thank you. Hello. My name is Dr. Gerard Conway, and I teach at Brunel University of London. And I'm going to speak today on this title, Formal and Informal or De facto Limitations on the Presumption of Innocence, a comparative and European perspective. So what I'm interested in doing for the presentation is to consider different ways in which the EU directive on the presumption of innocence doesn't include all aspects of the topic. And when I researched this issue, it was clear that, I think Professor Strada-Rosenberg mentioned earlier, that the international instruments contain a bare statement of the presumption of innocence. And when you research the topic, you can see how many different aspects there are to it and how many different ways there are of formulating the same basic idea. So that's kind of the issue or the theme that I'd like to address. The different aspects of this basic principle, which in its essence is clear and is widely known. I think it's one of those legal principles that almost every citizen would have some sense of. I think citizens on the street, so to speak, would know what the presumption of innocence means and would be able to invoke or appeal to the presumption of innocence in a way that they might not be able to do for other legal concepts. But there's a lot to unpack in the principle, and one of the practical issues with the implementation of EU law is how much to unpack at European level, and how does this relate to how each member state has unpacked or reflected or expressed the principle in its own legal system, and how the European Court the European Court of Justice should approach the question of the enforcement of a directive or the interpretation of the adequacy of the implementation of a directive at national level. Okay, so as I say, the basic idea of a presumption of innocence is quite clear. I think everybody has some sense of the essence of it. But it is actually quite technical. And one of the points that I suppose conveys that there's more to the detail of it is the distinction between the actus reus and the mens rea, whether the presumption of innocence extends to both those elements of an offence. So at its minimum, at its core, you can say that the presumption of innocence relates to the actus reus. There's no debate or doubt about the requirement to prove the actus reus. And then there is some difference of approach about the extent to which the mens rea is equally subject to the presumption. But in general, you can say that the same logic would apply to mens rea, and that there may be some qualifications or exceptions to it without undermining the basic application, the basic general application of the principle to mens rea. How the presumption of innocence is implemented is a matter for national law. I'll discuss in a slide in a minute the main EU treaty provision on the competence of the EU in the area. But the proof of the guilt or innocence of a suspect and the law of evidence is, as matters stand, mainly a matter for national law. We've already had a presentation from a judge of both courts, which on the European experience. But one of the points that comes across in this area of the law is that EU law has, at least in one respect, gone further than what Strasbourg requires. And that's concerning reverse burdens and that sort of limited, not so much reverse burdens, but on the right to remain silent and inferences that can be drawn from silence. There is a difference of approach between the two European systems on that point, but both systems have addressed the question of reverse burdens of proof and broadly adopt a similar approach. Okay, so EU competence is set out in Article 82 TFEU, and in that provision, specifically in Article 82.2, it refers to the establishment of minimum rules at European level. But the subject scope of those minimum rules is quite broadly stated. So mutual admissibility of evidence, the rights of individuals in criminal procedure, the rights of victims of crime, any other aspects of criminal procedure which the Council has identified in advance by decision. So the subject matter scope is potentially very broad. So a practical issue with the interpretation of that provision is, what does minimum rules mean, given the breadth of the subject matter? So there is a large potential for European rules to develop. Okay, so Directive 2016-343 is the main instrument to date at EU level, as we've already heard. So I'll just very briefly refer to its main provisions, just for ease of reference for the rest of the presentation. So Article 3 refers to the presumption of innocence itself, and it refers to both the accused and to suspects. And that itself reflects differences of approach across national systems. Not all national systems have traditionally accorded the same level of recognition or protection to suspects. Article 4 addresses public references to guilt, and that's an area where there's quite wide divergence of regulation at national level, when there is in fact regulation at national level, which there often is not in a very systematic way. Article 5 in the presentation of suspects and accused persons in court, for example in handcuffs or in chains or in a glass box. Article 6 on the burden of proof, and Article 7 on the right to remain silent and the right not to incriminate oneself. So it's essentially 5 articles of the directive that are on the topic of presumption of innocence. Just to highlight some features of the directive. Firstly, that it distinguishes between the presumption of innocence and the burden of the prosecutor. And that's not something that's often or always done at national level. National regulation tends to treat one as the corollary of the other. And some national systems express the presumption of innocence in terms of the burden of proof. But there's a potential to see these as sort of two different principles under the directive. Secondly, there's a somewhat similar distinction between the right to silence and the right not to incriminate itself. In national systems, those two can be seen as corollaries of each other rather than, if you like, distinct principles. But they are sort of highlighted in a more explicit or direct way in the directive. As mentioned, the application, the clear, unambiguous application of the directive to suspects is also something that's not always seen or hasn't always been seen at national level. I mentioned one difference between the two European systems in this area. That's concerning the right to silence and the drawing of inferences from silence as part of the final conclusions about guilt. And Article 7.5 of the directive is quite unambiguous and clear that in ruling out the drawing of negative inferences about guilt from the exercise of the right to silence. And that's not something that's seen as emphatically in the European Court of Human Rights. So that's an interesting example of how EU jurisprudence can go beyond provide more protection, if you like, than the minimum standard in the ECHR. In 2021, the Commission evaluated the implementation of the directive in national systems, and it's quite a careful and circumspect document because it doesn't name any member states when commenting on the evaluation. But it does say that a certain number of member states have done this or have not done that. It noted that the biggest issue or problem with implementation was as regards statements of guilt in the absence of conviction, which is prohibited under Article 4 of the directive. An important practical issue when thinking about implementation at national level and in, if you like, approaching or, if you like, reading the Commission's reports on evaluation is how to measure what is conformity, what is implementation at national level. Directives of their nature leaves the means of implementation to the national legal system, unlike a regulation. To what extent is it expected that national legislation should mirror more or less exactly the wording of the Directive 343? Or is it enough that either in practice or in case law or in legislation, the results sought by the directive, the content of the directive is reflected one way or the other in the national system? And the Commission's evaluation report sees that issue a bit. Sometimes it seems to envisage conformity can be achieved through case law. Sometimes in part it seems to suggest that a lack of explicit recognition at national level might itself not be considered fully in conformity with the directive. But that remains to be seen. How the Commission approaches its enforcement role. I understand from what I know that there's enforcement action against, for example, Sweden at the moment concerning the directive, but I haven't seen the actual letter of notice or reasoned opinion. But that's one issue that could arise with Sweden, because Swedish law is quite minimal in how and sort of a bit diffuse in how it implements the concept of presumption of innocence. One, if I briefly to mention in relation to ECJ case law, is that, I think it's the case mentioned already, a Bulgarian case. It's easy to relate the presumption of innocence to the concept of fairness of a trial overall. And you can have a kind of a slide in thinking about, that the presumption of innocence is about the whole process of establishing the guilt or innocence of the accused. That's probably a bit of a risk, at least from an academic point of view, that the whole topic then sort of mushrooms into a general consideration of the concept of a fair trial. And there's some hints of that possibility in the 2022 judgment. But at least for the purposes of my presentation, I want to concentrate on the specific issues specific to the presumption of innocence, and that wouldn't otherwise fall under, if you like, the general concept of a fair trial. So I said the title of the presentation is about formal limitations and informal limitations. So what could be considered a formal limitation on the presumption of innocence? Well, one is a reverse burden of proof. And a complete reverse burden of proof is hardly ever or never seen in national systems, but it's not at all unusual to have some limited reversal of a burden of proof for some specific aspect of a criminal offence. So, for example, I think this has been mentioned earlier by Rosaria, there can be cases where once an act has occurred, some related element of the offence then falls to the accused to rebut to some standards. It's usually called an evidential standard, although it's not always clear what exactly that means. So, for example, presumption of if a person is found to be in possession of an illegal item, then the burden of them might fall on them to explain how they came across it, or how it is the origin of it. And the general approach in European law is that these kinds of qualified or limited reversals are acceptable within limits, within reasonable limits. But it's not always clear exactly what reasonable limits means. I think one author, Caterini, for example, has commented on this point. In particular, I think you could say about it that there are different approaches to the idea of reverse burdens, and there's different terminology used, not always clearly, but what exactly is the burden? It's not a burden to prove beyond a reasonable doubt. It's basically a more limited burden that then shifts back to the prosecution the overall burden of proving the case. So it's a sort of a mini sort of phase within a trial. The defence have to prove to some extent sometimes in order for the trial to resume back into the court of the prosecutor. So is it a prima facie case that the defence must illustrate? And would that be different to describing it as an evidential standard in the balance of probabilities? And the terminology is not always clear. And there's a recent Irish case where it was put in this way by one judge in the Supreme Court: is the burden on the defence is to raise a doubt, is to make some reasonable claim that that just raises a doubt, which is not the same as saying to an evidential standard, which is on the balance of probabilities. They're different. So that's an unsettled point at EU level. So the case I mentioned there is CWV Minister for Justice and others in the Supreme Court, which had to do with an issue I was already mentioned. There is a presumption of knowledge of the age of a person in the context of sexual offences. Inferences from silence are another example of formal restriction, and there are very different approaches to that across member states. But here the directive is actually quite clear and unambiguous that inferences from silence cannot be drawn, negative inferences from silence cannot be drawn relative to guilt. And so Ireland has not opted into Ireland is an opt-out the area of freedom, security and justice under the Treaty of Lisbon, and Ireland has not opted into this directive. But if it had, Irish law would not be compatible with the directive in this point. Okay, so what about informal limitations? And this is an area where you could consider that there's scope for a reformulated or directive to expand on the kinds of rules that are the kind of subject matter that's included within the concept of the presumption of innocence. So a general point that might be made is about the absence of specific evidence thresholds within many of the legal traditions of the member states. So in quite a lot of continental states, there's a basic principle of the free evaluation of evidence, which is something that seems to have sort of occurred in the 19th century especially, through a kind of mutual influencing of different traditions on each other. And you could say that, okay, you start off with the presumption of innocence, and at the starting point of the proceedings are considered to be innocent, but that the free evaluation of evidence has the potential, because it suggests some completely discretionary approach to the evaluation of facts, to kind of undermine the principle inherent here implicitly for the rest of the trial. It's a nice place to start with that you're presumed innocence, but if there's no particular standard by which your guilt is adjudged, does that not feel like negate the starting point? An example of this this general principle of the free evaluation, the free evaluation principle, section 261 of the Code of Criminal Procedure in Germany. There's a similar provision in Sweden. And A second informal limitation would be the use of opinion evidence. In Ireland, for example, there are some legislative provisions that allow weight to be given to the opinion of a Garda, a police officer, or a police officer of a certain rank about a certain matter. So, for example, membership of an unlawful organisation. But the weight to be given to that opinion is not stated in the legislation. And there's an ambiguity there as to what weight should be given to it. And the courts in Ireland take the approach that because it's not stated to be conclusive, it's up to the court to decide, and it's just one piece of evidence. But at the same time, there isn't a corroboration requirement. So it's sort of left hanging there. It's evidence, but it's not formally stated to be conclusive. A third example of an informal limitation would be prejudicial publicity on it, and its effect on a trial. Many legal systems have rules about this issue and about the prevention of a trial or the cancellation or suppression of a trial on this ground. Now in Ireland, there's quite a strict test for invoking the idea of prejudicial publicity as a ground for the term used in Ireland is to quash a trial. That it's up to the accused to establish that there is a real risk that by reason of the circumstances claims that, in other words, the publicity claims that he or she would not obtain a fair trial. So establishing a real risk is considered to be quite difficult in Ireland, and it's considered to be quite a difficult test to satisfy and not to be reached very often. Quite a lot of member states have rules on this issue, but there's nothing in the directive on that. Whereas it could fall under the concept of presumption of innocence. So there's just scope for a proposal on that. I need to finish, but I wanted to say something about the comparative part of this, a bit more about the comparative part, very briefly to finish. I mentioned Sweden earlier, that Sweden doesn't have, if you like, one place in its laws where it sets out, if you like, in detail, the concept of the presumption of innocence. And it's not expressly stated in Swedish law such the way it is in French law. So I've mentioned French law, that Section 9 of the Declaration of the Rights of Man, there's a clear statement of the presumption of innocence and the influence of the Enlightenment on kind of establishing this idea, in contrast to the previous inquisitorial history of European criminal trials, where it was almost the opposite. It was almost a presumption of guilt. There's no equivalent in Sweden. But there's a quote here from a recent Supreme Court case, MA and AS. Now, a bit earlier in the judgment, the court was a bit actively expressed view in the rules of judicial procedure or legislation on how criminal guilt is to be established. The court notes that this, however, has been addressed in case law. So this is an example I should mention at the beginning. So currently, enforced action will be brought against me. One of the reasons for the Commission's findings is citing its grounds of inadequate implementation. But could be the way in which the principle of presumption of innocence is implemented through case law and through its provisions is something that should be how to make nothing like just earlier about how much space should be given to member states to take the role of which is not the event of the result.
Thank you so much for this very enriching presentation. Sorry for the timing constraints. And now, give the floor to Professor Adam Latsowski from the University of Westminster. It's going to be the last meeting before that. She will make a presentation on the Directive 2016/353 on presumption of innocence at the European Union.
Thank you very much indeed. I can wait for multiple issues, knowing that I'm living standing between you and lunch. Thank you for coming by the chair for fundamentals. So I'll be brief. Someone might still be interested in academic research. I have my watch. I'm sorry, I'm not sure that the chair has a note saying much. Right, first of all, many thanks to the organizers for having me. It's my third time here, but for the first time in academic capacity. Previous 2 times I was actually Latvian judges. Different aspects of EU law, including, I guessed it, the European Arrest Warrant. Question number 1, what is the topic of my presentation? Well, obviously, presumption of innocence, the European Way, Directive 2016/343. Now, please don't worry, I'm not going to read it for you. And as the previous 2 speakers covered quite a lot of the directive itself. So what I will do is I will basically focus on the big picture. Look at the genesis, the scope, some aspects of the scope of the directive, and the issues that have been rising since the transition period has expired. What does it matter? Well, we've already heard this morning that presumption of innocence has a particular constitutional role to play in democratic societies. And if we go through the jurisprudence of the Human Rights Court in particular, but also the emerging jurisprudence of the Court of Justice, we do see that things are not exactly hunky-dory down on the ground, that we should not take this principle for granted. Or as Professor Stefan Brown mentioned in the morning, it's a very vulnerable principle. Let me start into the subject area with the following story. Imagine you are a judge in one of the EU member states and you are dealing with a request for surrender to another member state under the European Arrest Warrant. That's not original, that's a classic scenario, isn't it? But you are quite familiar that the country that's requested the surrender for the purposes of criminal prosecution and sentencing is on not speaking terms with the rule of law. That judges are not independent, that there's quite a lot of fake judges sitting on the bench, and there are various issues, for instance, with detention conditions. And then it's brought to your attention, most likely by the lawyer representing the person that is to be surrendered, that the Minister of Justice of that country, who by the way is also chief public prosecutor, has just given a statement to the national media saying, this person will not commit more crimes. This person is a criminal and needs to end up in prison for as long as it's possible. Now, this is not a product of my wild imagination. This is exactly what happened in the case that I'm sure we all know, the case C216/18 LM, which is also known as the Tilburg case. Now, this example shows us 2 things. First of all, something that Justice Miller already mentioned, that, how easy it is for, in this particular case, for politicians and then that's reported by journalists, to undermine the principle of presumption of innocence. It shows, again, what Professor Brown said, this is a very fragile principle. But also, in the context of the European Union, it shows us how this may undermine mutual trust. Because you, as Irish judge in this case, thinking, well, clearly, the Minister of Justice is not on speaking terms of the presumption of innocence. Perhaps I shouldn't be sending that person to Poland. There is, of course, more than that, and the Commission, in its impact assessment, highlighted the issues that emerge down the ground. I'll come back to this later. Now, it also shows us that EU legislation on presumption of innocence actually serves 2 masters. One is the fundamental rights and democracy. Second is the area of freedom, security, and justice, and mutual recognition. It's a bit like, it's a far-fetched comparison, like EU competition. It serves consumers, competitive process, but has one more master, internal market. So, same as here, it serves the area of freedom, security, and justice. Now, one may ask a very fair question, a couple of questions. why did we actually need a piece of secondary legislation on presumption of innocence in EU law? Isn't that enough to have Convention Article 6.2, whether we like it or not, and Article 48 of the Charter? Well, if you want to sound a bit more Brexity, you will say, why does the EU deal with presumption of innocence? It's not their business. Well, as Justice Simila said, the Charter only applies when a member state acts in the scope of law. And even with very generous state interpretation of that particular provision of the Charter in France, you will have areas where Charter will simply not apply. And the second thing to bear in mind is the fact that the Strasbourg system has not only benefits but also weaknesses. You need to get through all national remedies to eventually submit the case to Strasbourg, and not all cases will go on the journey for obvious reasons. And this is all happening ex post. Not to mention that the Strasbourg Court is struggling with the amount of cases in its docket. So, secondary legislation in that case comes in handy. Also, bearing in mind that it's a piece of EU law, it's already been explained that it's a directive, and that it can produce direct effect in national courts. Also, it can trigger public enforcement. So you can have a commission chasing the member states, forcing them to comply fully. I'll come back to this in the last part of my intervention. So we have a directive, but it didn't come out of the blue, obviously. It took years of work. In 2006, the Commission published a green paper on presumption of innocence. This is pre-Lisbon world that many members of the ECLAN network remember very well. At that time, out of 25, only 11 member states were actually interested in participating in those consultations. And also independent experts, practitioners, who were pointing out to erosion of the principle of presumption of innocence and underlining that there are issues on the ground. Fast forward, we stopped the program, and the European Council sort of tapping the Commission on the shoulder saying, why don't you come up with something? And then, big picture, of course, the defense rights directives. We have the directive for translation, interpretation on right to information, and right to access to a lawyer. So the Commission eventually in 2013 conducted proper consultations. Again, it's 2013, so it's quite a few years after the initial paper, what to do. And it received over 100 responses. The general response was, well, it's not too bad, but you could actually fix quite a number of things and address in secondary legislation. Key problems: insufficient protection against, again, public references to guilt by law enforcement and judicial authorities. Insufficient protection of the principle that the burden of proof lies on the prosecution. Insufficient protection of the right not to incriminate oneself, including the right not to cooperate or the right to remain silent. And so it goes. This impact assessment, for those of you who are not familiar with the story, is part of the proposal that the Commission put on the table for the Council. So you can really see a lot of background information, what was happening on the ground. Now, the Commission presented 4 options here. So it's not that it was blindly rushing to have secondary law. It said, well, option 1 is status quo. We basically do nothing. But then the consequence of that would be no improvement of mutual trust, and therefore potential threats to mutual recognition. Option 2, non-legislative instruments. So you see the Commission starts actually from a very modest approach. We do nothing. It's not that they jump to the guns straight away. They say, well, we can organize training on good practice, sharing information about good practices, improved monitoring. But again, the Commission says, and I fully agree, there's a very low incentive here for the member states to do anything, because there is no legislation, you can't enforce anything, especially if nothing happens. And then the Commission gives three versions of option 3A, a directive which confirms the minimum rules established by the Human Rights Convention in court. There will be possibly increased mutual trust, fewer delays in judicial cooperation, and so on. And the second option, sort of 3B, a directive that sets higher levels of protection where that is available than the ECHR. And then the proposal lands in late 2013. Now, this proposal paid 7 visits to the Council negotiation. I checked the whole story, how this travelled. And as a matter of fact, well, of course, it was debated in the European Parliament. And what is interesting, if you compare the original proposal and the actual directive, the directive became more detailed than the proposal. And that's interesting in itself, because very often it's the other way around. So the Commission comes out with more ambitious proposals, and they will be watered down by the member states. Here you can see that, for instance, Article 1 is much more specific than the original proposal of the Commission. 2 points of order. First of all, the member states had 2 years to do something to adopt domestic legislation or implement the directive. Second point, all 3 opt-out countries decided to opt out. And that, of course, included the UK. That's not surprising, I think. The Commission had to present a report by 2021, and I encourage you to take a look at it. It's a very interesting, albeit short read. The Commission had to proceed basically on the basis of legislation that was made available to it, because the member states were not really willing to cooperate and tell the Commission what exactly is happening. Now, one thing to add to what was said earlier, the scope of application, it applies to natural persons. It doesn't apply to legal persons. This was debated, and what is interesting is that the preamble, recitals 1415, explained why. It says, and quote, "It is premature to legislate in the Union about that." And it adds that the presumption of innocence with regard to legal persons should be ensured by the existing legislative safeguards and case law, watch out, the evolution of which is to determine whether there is a need for union action. So we may come back to it when the time is right. The directive is fairly short. It's just 10 provisions, including a very generic article, Article 10, which says that member states have to provide adequate remedies. But of course, as we know from the jurisprudence of the Court of Justice, the Court knows how to make use of such generic clauses. It is general sometimes, it is limited in scope, and that's for a number of reasons. One of them is the fact that the EU is for the very first time dealing with this particular aspect of criminal law. It's stepping on a very thin ice of different national legal systems. And like in other areas of law, if we go back in time, historically, where the EEC or EC or EU were getting into new areas of law, we're doing it gently. I know it's easier, as Justice Zimmer told me through chatting, but it's easier to deal with consumer protection law. But that's exactly what happened in the 80s and 90s. The early directives are very, very vague and basic, and then they become more and more detailed. And the second reason for that is something that we haven't mentioned. This is the area of shared competence, and therefore the principle of subsidiarity. And the Commission has to make this assessment, and then the Council makes this assessment, and ultimately the Court may be asked to do so. So now what? Except for the fact that we're heading upstairs for lunch. The directive is in place. So all eyes are on the implementation. And what is interesting is that it is, if you go on Eurolex and check national implementation measures, you have a typical scenario of a legal act in the EU, which is kind of horizontal in nature. So you can see that you have a long list of national rules which the member states treat as implementation. This is not a copy-paste material. It just doesn't work this way. So that's the first thing. What we do see, and what we actually see from the report of the Commission, is that some member states changed the law. Some member states did absolutely nothing and said, well, our law is already implemented. And that's, if it's justified, that's perfectly standard practice when it comes to transposition of directives. Sometimes simply you don't have to do much if your legislation is already following certain standards. What we do see with this directive is that we see the dividends of the Treaty of Lisbon. So first of all, we have infringement procedures which are now available to the Commission. And yes, not a single case to my knowledge has reached the Court of Justice. And that's, again, something very typical. Most of infringement procedures do the job and work at the early stages. You had the first wave of cases after the expiry of the transposition period, and now you have the second wave of cases where the Commission is using the microscope and checking what exactly is in national law and how it might not be compatible. I counted this morning, we have 16 cases which are open, all 16 at the stage of the letter of formal notice, which is the first formal document that the Commission has to produce to kickstart the procedure. And all of those cases triggered in 2023, 24, 25. So watch this space. You can see, once you click on the database, what exactly is the problem. The second thing is, of course, private enforcement. Again, framework decisions could not produce direct effect, and we know kind of problems. For instance, we have the arrest warrant and very strict case law of the court in Poplavsky 1 and 2. But we already have several judgments of the CJEU saying, for instance, that Article 8, paragraph 4, which deals with the right to be present at the trial and trials in absentia, and right to have a new trial, in case of trial in absentia, Article 9, that these provisions produce direct effect. Now, that not only gives the rights to those who submit pleadings in national courts based on those provisions, that also triggers the Cimental mandate. That means that the national courts, as a last resort, need to set aside national law and proceed under the directives. We have other remedies as well, indirect effect and potentially also state liability. So overall, this directive, I believe, is an important step forward. Like any piece of legislation, be it national or EU, is not perfect, but for the time being is the best what we got. And as the Polish and Ukrainian saying goes, if you don't have what you like what you have. Thank you.
Thank you so much for having that. Very useful to stress also how Laurens was to reach his minimal approach in the directive was very much criticized, and how sensitive, in general, but especially is how sensitive is the question of the full correct implementation at the national level of the directive because of the strict connection with the mutual trust, which is the foundation of the common area of freedom, security and justice. I think this is important to stress also because of the ongoing high-level group on the, on the new strategy, I would say, concerning the common area of freedom, security and justice. Under the direction of Professor Cristina Estrada Gozemerda, I think we run out of time, so no discussion, time barred. Probably the discussion is postponed, I don't know, maybe later in the night. Then there is, the lunch break. So thank you very much and see you back. Sorry, at 2? Okay, at 2. Bye-bye.
proof in the context of the presumption of innocence. And so it is my great pleasure to introduce you the first speaker, because unfortunately, our colleague Katia Schumann-Stufs could not join us, but we are very lucky and honored because we have Miha Hafner from the University of Ljubljana with us. And so Miha is contact point for Slovenia in our network. And so he will be speaking about standards of proof and their relationship to the presumption of innocence. Miha, the floor is yours.
It's very nice to be here. Thank you so much. But instead of me here, should be standing Katia Schumann-Stufs, and who mentioned. As some of you know, she was one of the founding members of ECLAN, so she was really devastated. She could not come here today. Unfortunately, she broke her ankle a couple of weeks ago, so she could not travel. But she made me promise 3 times that I will send her regards to everyone here and sends her best regards for the conference. And also this presentation was largely developed by Katia, and I've only added a couple of thoughts of my own to it. And in that way, to start this presentation, or to start thinking about the relationship between presumption of innocence and standards of proof, is actually to start outside the realm of criminal law. And innocence is such an abstract concept that it's really hard to define it without including the guilt into the definition. So the simplest definition would be the innocence is the absence of guilt. And when lay people are thinking about innocence and guilt, lawyers think about that in non-legal terms, we know that we don't understand that as a binary concept. We kind of ascribe blame or we ascribe guilt in a sort of a continuum, in a sort of a scale. And psychological research mostly confirms that. So people ascribe blame, they think about them being responsible in a sort of a gradual scale. And also when we ourselves feel moral emotions such as guilt, shame, embarrassment, we feel more or less with this emotion, not just a binary category of right and wrong. So in a way, criminal law forces us to think in these binary categories, which is a bit alien to us, if we are not from the legal sphere. And that concept, the binary concept, is of course a direct consequence of the presumption of innocence. The defendant can be either innocent or guilty according to criminal law. And other consequences which we already heard this morning are, of course, that innocence is always presumed and guilt needs to be proven, and that is, of course, shifts the burden of proof to the prosecutor. And that also means that the standard of proof for conviction has to be set very high in order for us to avoid false convictions. And it also means that because of the law, this high spectrum of probabilities between innocent and guilty mostly translates into innocent. And I think a very useful way of thinking about this concept, or like a nice illustration, is illustration with colors. So if I ask you now whether this color is blue or green, you should give a definite answer. So you cannot just say, well, this color is somewhat blue, but it's also a bit green. And so the criminal law demands from us the question, is the defendant guilty or is he innocent? And if I continue this analogy, if we have this presentation of blue and green, and blue represents innocent, whereas green represents guilty, it's really hard to define where this picture breaks from blue to green. This cannot be objectively identified, so we have to arbitrarily set this margin. And in criminal law, of course, we set it very high. We come to the standard of proof, which is usually called beyond reasonable doubt, because probably here in this room there are still some people who say this color is still blue. So a really high standard of proof is again here for us to avoid those false convictions. However, the space in between, it always translates into innocent. And that's the interesting thing about criminal law. And if we move to the concept of standards of proof, what are they? So the simplest definition would be that they indicate the level of the burden of proof that the prosecutor needs to satisfy. Another way of looking at evidentiary standards is also that they
reflect the probability that the criminal offense was actually committed, or that the defendant is guilty of this particular criminal offense. So they are set on a scale of probabilities. We work with probabilities here with the standards of proof. And again, that became the third way of looking at evidentiary standards is that they reflect the degree of the court's conviction about the case. So the intimate conviction of the judge whether the defendant is guilty or not. And this could be represented with this kind of a graph. So this is, of course, just a model. It's a model how, in theory, scale of evidentiary standards should look like. And of course, we've heard as well from Professor Conway that states and jurisdictions have very different approach to regulating evidentiary standards. They have different levels of evidentiary standards. They would set the bar very differently for a particular evidentiary standard, and they would also name them or term them very differently. We know of them such as reasonable suspicion, background suspicion, probable cause, and so on and so forth. So in this model we have four steps of evidentiary standards, and they will serve as a model, the ideal regulation of evidentiary standards. So what is the function of evidentiary standards? Well, basically, they should perform two functions. The first one is that they kind of represent the stress code for us to move from one phase of criminal procedure to another. So the idea behind this is that the later the phase of criminal procedure, the higher the evidentiary standard. And the other role they perform is they set us the benchmarks for the burden of proof that the prosecutor needs to satisfy for us to impose some measures against the defendant, or for us to interfere with the defendant's rights. And if I explain that a bit more in detail. So we see that with the evidentiary standards, we apply the principle of proportionality to criminal procedure, and this is a classical consequence of that principle. And if we first focus on the phases of criminal procedure, well, the idea, of course, behind this gradual approach is that if we expose the defendants to the pains and unpleasantness of the criminal procedure, for a longer time, we need to be more certain that the defendant is actually guilty of that criminal offense. So in other terms, if we want to restrict his presumption of innocence, for a longer time or more, we need to be more convinced that he is actually guilty. So in this model criminal procedure, at the beginning, when we have no innocence, the state must simply let leave a person alone. Then for the phase of police investigation, or pre-trial investigation, usually quite a low evidentiary standard is required. And then if the prosecutor presses charges, if they file an indictment, they would usually be with higher evidentiary standard. And this standard will be then tested at some point by the court. And then again, it will be a higher standard of proof. And quite uniformly across jurisdiction, then the final standard is called intimate conviction in civil law jurisdiction or beyond reasonable doubt in common law systems. And this one is required for the judgment of guilt. And if we use the same logic with the measures taken against the defendant, we also see that, again, if there is no suspicion, the state must not interfere with any of the person's rights. Whereas the relatively low evidentiary standards is allowed for some mild police investigation measures, such as police interviews, police gathering some information, citizens and so on. Whereas if we are for house search, we are freezing assets, we are imposing some converting investigative measures, we will need again with higher probability of defendant's guilt. Even more so if we restrict someone right of personal freedom with pre-trial detention, and again impose a criminal sanction, we will need the highest potential standard. And again, in an ideal system, the legislature would have a very clear idea how certain rights are ranked hierarchically in a constitutional system. And they would place high burden of proof for the rights that are obviously more important, that are ranked higher on this scale of rights. Or in other words, if the infringement, the state's infringement of someone's rights is more intense, the state would require a higher evidentiary standard. And finally, this gradual scale of probabilities, this spectrum of probabilities, seems at odds with our first concept when we said criminal law basically sees innocent and guilty as a binary concept. So it seems strange that we're introducing this gradual cascade system of evidentiary standards. But in fact, they are very compatible with the presumption of innocence. Why? Because they are more of an evidentiary tool, a epistemological tool that helps us establish at the end whether the defendant is indeed guilty or innocent. So it's not that we presume the defendant more or less innocent or guilty. Criminal law is still very serious about the fact that the defendant was all the time either guilty or either innocent. We just need this tool to establish this final conclusion. So another useful way of looking at the evidentiary standards is understanding them as small presumptions of innocence. Like a little partial presumption of innocence that the defender, the prosecutor needs to kind of overcome step by step to finally overcome the final presumption of innocence. As a little battle that the state is citing in order to come to the final whole presumption of innocence that prosecutor will hopefully overthrow, and if not, of course the defendant will remain innocent. And to make this one maybe even more clear, there's actually a lot of similarities between final presumption of innocence and this little presumptions of innocence or evidentiary standards. A lot of procedural or criminal law concepts apply equally for both of them. For example, the adversarial principle of decision making, usually both parties need to be heard in order for us to decide about the evidentiary standard. A nice example is pre-trial detention. Typically, both parties will be heard before the court will decide on pre-trial detention. The burden of proof in both cases is on the prosecutor, whether we are establishing evidentiary standards or whether we are deciding about the guilt. The same goes for the privilege in self-incrimination, which protects the defendant in both cases. Usually, the court is not allowed to decide on whether a particular standard of proof has been fulfilled or not ex officio. It always needs a motion of a prosecutor to do that. In most cases, we've heard, of course, some exceptions to the reverse burden of proof, but in principle, that is the case. And usually, the decision whether the evidentiary standard has been fulfilled or not precedes other questions in a particular matter. Again, if we look at the case of a pre-trial detention, the court will always first establish whether there is enough evidence whether the evidentiary standard is fulfilled before they would jump on other questions such as if there is risk of preventing obstruction of justice and so on. And that, of course, is the case with the final presumption of innocence. We need first to establish whether the defendant is guilty before we are talking about the criminal sanction. And in both cases, as well, indubio pro reo applies. Very briefly, we see that we can actually look at evidentiary standards as partial support presumptions of innocence, and they're very much in accordance with the presumption of innocence and its whole logic. And they basically follow the same purpose. The purpose is to protect the defendants, find the presumption of innocence, to protect the integrity of the defendant, and to reaffirm judicial legitimacy. And of course, with both these systems, we try to avoid the arbitrariness inside the system. Thank you.
Thank you so much, Nina, also for having respected the time. It was very interesting, very clear, and full of knowledge. So thank you so much for this. Now the floor is yours, Leandro. So we are very honored to listen to Leandro from the Edinburgh Law School, representing the United Kingdom in the ECLAN network. So thank you very much, Leandro. If you could also speak for 15 minutes so that we can keep 5 or 10 minutes for discussion.
Good afternoon, everyone. Thank you, Anne, and thank you, Chair, for this invitation. I still remember your presentation, your slides last year, confidence in how we meet with the animals. It was really, really fantastic. So, trying to stick to the time limit that have been allocated, I will offer really some sketches of what the presumption of innocence consists of in the law and how that potentially be deployed. And to start with a perhaps slightly provocative hypothesis, I would say that actually most of the interesting things that have been happening in EU law in relation to the presumption of innocence are very little to do with the presumption of innocence directive. I'll try to maybe substantiate that claim in a few seconds. And to look at this, we need to zoom out somehow, and like Durga said, sometimes sign improves with the distance. So that's what I'm trying to do here, and looking at the different dimensions that the presumption of innocence has in the law. And I identify 3 of them: the constitutional dimension, the criminal law specific dimension, and the cross-cutting dimension. The names are not great, to be very honest, I couldn't come up with anything better, so there you go. Before we delve into each of these dimensions, a working assumption, something that has been already stated in the previous panels. The presumption of innocence is a cornerstone of the right of the trial. It relates to both procedural burden and the standard of proof. And importantly, is both an overarching principle, so comprising a number of non-specific safeguards, including the right not to incriminate oneself, the right to remain silent, and is also connected inextricably linked to other defense rights, such as the right to information in criminal proceedings. Proof of this is that if you look at Article 48 of the Charter of Fundamental Rights of the European Union, you have in the first paragraph presumption of innocence, in the second paragraph safeguard of the right to defense and property. So you can't have one without the other. So the constitutional dimension, very broadly, especially if you're looking at the constitutional case law of the Court of Justice of the past few years, the EU as legal order seems to move or rest on the interaction between 3 main building blocks: the values, the principles, and the objectives. And more specifically, the principles are there to ensure that the objectives of the EU are pursued in line with its values. Okay, so this is a really, really general sweeping statement. So let's try to have a look at how that works in relation to the presumption of innocence. The presumption of innocence is expression, or can be linked to several of the EU values: rule of law, respect for rights, justice. We also know that the Union aims to build an area of human security and justice with respect human rights and the diversity of the national systems. So we've got the values, the objectives, and we've got the presumption of innocence as a principle, broadly speaking, as an overarching category, that plays a role in making sure that we build this area of security and justice in line with its values. Okay? And so we might say, oh, well, then that's where the presumption of innocence stack plays its role, but actually there is more to that than meets the eye. Because we have seen Article 48 deployed, particularly at the constitutional level, with Article 19 EU. Article 19 EU, which obliges member states to provide remedies sufficient to ensure effective legal protections in the fields covered by EU law. And the combined use of Article 19 EU and Article 48 of the Charter has really been groundbreaking in limiting or fighting back rule of law backsliding in several member states. And this is just one of the several examples. When it comes to, for example, the independence of the judiciary in Poland, we have seen most often the Court of Justice referring to the second paragraph, so the right to defense, the second paragraph of Article 48 of the Charter. Whereas in some judgments, like the one that I have been referenced here, there is mention of Article 48 more broadly. So the combined use of Article 19, so an obligation for member states to establish an effective system of remedies in combination with Article 48, has allowed the court to make inroads in areas that were apparently the preserve of national law, such as the organization of the justice system. There is no apparent connection with EU law there, but this is the, to an extent, revolutionary use of Article 48 and Article 19 to ensure the protection of the values of the Union. The second dimension, moving on quickly, the criminal law dimension. Here, two main points of constitutional interest that are also relevant for criminal law specific. First, we have observed actually that the Presumption of Innocence Directive has shown the full force of the constraint represented by the obligation for the EU to legislate the minimum rules. Often we say, oh yes, there are the requirements in the legal basis in law when it comes to criminal law, but then there is always a way, you know, if there is a political will, there is a way to go past, around it. But actually, the presumption of innocence in the legal case, just as an example, there are more such cases, show that actually the opposite is true. Because, yes, the presumption of innocence directive governs a number of situations, but there are other situations not governed by the directive that are, however, inextricably linked with the specific situation that the directive covers. And so the member states, courts, have been asking questions. Okay, so the directive doesn't explicitly say anything about this aspect, but it does govern situations that are inextricably linked or very closely linked to other things. Can we use then the Charter, Article 48, and maybe in combination with other articles such as Article 6, the right to liberty, to amplify the scope of the Presumption of Innocence Directive? And here I list a number of such situations that have come to the attention of the court, and the Court of Justice said, no, essentially. And which is very interesting because you don't often see the Court of Justice engaging in such a way. This is one of the case studies actually where this has happened very, very lately. The Court of Justice has drawn the line very forcefully saying the Presumption of Innocence Directive does not govern these situations, even if you are trying to say that the Charter of Fundamental Rights is engaged because there is the Presumption of Innocence Directive, forget about it. So the amplifying function of the Charter wouldn't really work here. And the second aspect concerning the criminal dimension relates to the connection between the presumption of innocence and other rights also governed by EU law, such as the right to information in criminal proceedings. And here we've seen situations where, for example, in national proceedings, some persons have been informed of their right not to self-incrimination after they had received self-incriminating statement to police officers. So not particularly helpful. But in those cases, the Court of Justice has followed closely the approach of the European Court of Human Rights in saying that we must look at the overall fairness of the prosecution in these cases. So, in the negative, this situation has happened, and what I found most interesting, EU law actually does not preclude a national law prohibiting a court from raising of its own motion the illegality of a situation of, for example, proceedings where such statements were taken in breach of the presumption of innocence, where the person had had the opportunity to raise that question themselves, which is apparently straightforward, not necessarily problematic, although I do find it interesting that this isn't the case, but that way it's reference from French court, and that the Court of Justice was perfectly fine with national law preventing the national court from raising this point of nullity on its own motion. Thirdly, the cross-cutting dimension. For people familiar with European law, we all know how other unexpected policy areas of law have played such a pivotal role in shaping what European law is today. And we can see it reflected in the second paragraph of Article 20 EFU, where criminal law is really there as an instrument to ensure the effective enforcement of areas where there has been harmonization of regulatory market, mostly the internal market. But we also have seen this on a procedural level. Think of the Berlusconi case. Now a classic of European criminal law, a case that was, in the end, let's say, broadly speaking, the internal market, that established a fundamental principle at the level of the EU legal order of criminal law, such as the legal activity of all lenient penalties in criminal law. And that has now found basically reflection, or has been translated years later in the Charter of Fundamental Rights of the European Union, in Article 49. And this is something, this is a principle that has been established by the Court of Justice in the early 2000s, in the area of through a ruling issued in the area of internal market. And this is not just history, this is something that keeps happening. Yes, actually, this is my last slide. And this is something that keeps happening. And one of the most recent examples is to do with the right to remain silent in the context of punitive quasi-criminal proceedings. In this case, conducted by the Italian Financial Market Supervisory Authority. So there was a case in 2021, the House case, where the Court of Justice was faced with the question about Italian law, transposing the law by the way, which penalized the lack of cooperation from natural persons in the administrative proceedings for insider trading conducted by the Italian Financial Market Supervisory Authority. And the Court of Justice said that the right to remain silent is applicable in these proceedings, because these proceedings can lead to the imposition of administrative sanctions of criminal nature. This is very interesting for a number of reasons. Firstly, because of the context that I have just set out, that we see the development, the advancement of procedural safeguards outside criminal law strictly understood in the new legal order continues. So it's not an established legal tradition now. Secondly, the cross-fertilization between EU law and ECHR law. Clearly, here there's a reference to the case law when we talk about sanctions law that are administrative, formally, but that are criminal in nature. But also, I think the most important finding of the whole judgment is that, but actually, even if the proceedings will not lead to sanctions that were criminal in nature, the right to remain silent will apply nonetheless, because information provided in these proceedings could then be used in parallel investigation. And that's also why then that this judgment has drawn so much attention from different corners of the scholarship, constitutional, criminal law, internal market, and so on and so forth. And so in that sense, there's certainly a progress and advancement in this regard, and there are still many questions about the entitlement of the legal person, because this proceedings concern matters. And so the entitlement of legal person to the right to remain silent, and what about the right to remain silent in the context of constitutional law, for example, and this is where the Court of Justice has remained so far quite actually cautious, even in general, in this case, drawn very distinction between natural and legal person, say, no, it doesn't. Legal person, conventional law is a different beast. Okay. These are probably questions that we keep turning down. But hopefully this sort of way overview has provided a bigger picture of the complexity and the sort of multi-layered element of consumption of innocence in Europe beyond the active state of Thank you.
Thank you so much, Leandro. So for this also very interesting and very structured expose. So very interesting to listen about the constitutional dimension, criminal law dimension, cross-cutting dimension, to see, of course, that on some instances the court is showing self-restraint, but on the other side, as we saw during the last minutes, that it can also more progressive approach. So we will now switch to the European Court of Human Rights, but also to, well, a national approach. So it's my pleasure to introduce you Oskar Skulmanis from the University of Latvia. So you will speak, Oskar, about developments on the burden of proof and standard of proof in case law of the European Court of Human Rights and the Supreme Court of Latvia.
Dear colleagues, it's a real honor to be here. Thank you very much to the ECLAN community and, of course, Professor Christine Rosenberger for this opportunity. And today I'll be talking about the whole idea we've been talking about today, how the presumption of innocence is emphasized in the case law of the European Court of Human Rights and in how we get down to certain cases of Latvian Supreme Court, the Criminal Department, and two of their cases. This principle, I think it's a bright light that shines down on every criminal case. And I'm really interested to find out how this presumption works in certain facts, how the enforcement institutions and the court sees how this principle works and how it shapes the whole case. Okay, so it goes. My speech will be dedicated to cases regarding money laundering, and an important part of this criminal offense consists of finding whether actions considered as money laundering are carried out with funds that are of illicit origin. Latvian criminal procedure system recognizes two scenarios. The first scenario is that there is a predicate offense, there is an indictment on the predicate of offense, and also on money laundering. But there is a second choice, where there is an indictment only on standalone money laundering. Therefore, the question arises, what to do with such a case, how to look at the assets in question, and could they be presumed as of illicit origin. I will move to the European Court of Human Rights case law, but I'll get to the details since basic idea on the standard of proof and that's been talked about before. What I would like to say that the European Court of Human Rights has emphasized that in a situation in the prosecutor has substantiated where suspicions that the assets are proceeds of crime, the burden of proof is shifted to the person. The person has to discharge their part of the burden of proof by refuting the prosecutor's substantiated suspicions about the wrongful origins of their assets. There is a specific case I would like to talk a little bit about. It's case Melandri versus San Marino. It's a case of 2024, in which the European Court of Human Rights examined the situation in which certain assets were confiscated after the person had been found guilty of money laundering. The indictment referred to a series of predicate offenses. On the proportionality test, the European Court of Human Rights accepted the approach of national courts that the fact regarding the illicit origin of the property doesn't need to be proven beyond reasonable doubt. Domestic courts at both instances considered it to be derived from a crime and found that the applicant had not been able to demonstrate that those sums had had illicit origin. Therefore, the European Court of Human Rights accepted the use of standard of proof on a balance of probability of illicit origin of the property. I'll move, respecting the time, I'll move to the Latvian case law. I'll talk about two cases. First of which is regarding to facts that in indictment it was written that the person was charged with money laundering of the sum of 25,000 euros. This sum was laundered by buying two Volvo S80 cars. One was worth 7,000, the second one was worth 8,000. And a purchase of an apartment that costed 10,000 euros. The Court of Appeal found the person guilty of money laundering, but the Supreme Court wasn't on the same page with the Court of Appeal and mentioned several very important facts that were crucial for the outcome of the case. The Supreme Court found, looked in the case file, in the assessment of the case file what the Court of Appeal had done, and the Supreme Court found out that the Court of Appeal hadn't examined very important information regarding these purchases. There were very important aspects. For example, the cars that were bought, they were bought after the person sold two of his previous cars. The Court of Appeal didn't examine these facts, and also the Court of Appeal didn't examine the fact that the apartment was bought after the previous apartment was sold. So there were differences in sums, and the Supreme Court mentioned that the criminal origin of the property by which the laundering activities were carried out shall be determined. The Court of Appeal based its opinion on the presumption of fact that also, after the money laundering actions were done, after those actions, the person did another predicate offense. That was after the acquisition of the property. And the Supreme Court mentioned that this fact is not relevant in the case. This case shows that it's possible to presume the illicit origin of the assets, but the evidence regarding the origin of property must be assessed in scrutiny. Every detail of the case, also the statements of circumstances of the purchases, can be important for the outcome of the case, and determination of value of funds of presumed illicit origin. The causal link between predicate offense is also of particular importance, and it must be justified with evidence. And another case I would like to talk about. This case is about a very hard-working electrician that also illegally sold some tobacco. This case regarded money laundering of almost 100,000 euros. And in this case, the Court of Appeal acquitted the person of money laundering charges by saying that there is no predicate offense for the origin of the assets, and also the Court of Appeal mentioned that there has been no intent of the person to hide the origin of the assets. Therefore, there is no subjective side of the crime. The Supreme Court found out that the Court of Appeal hasn't examined the whole evidence that the prosecution used to demonstrate that the origin of the assets might not be legal. The prosecutor used facts that they see during control of the communication of the accused person by telephone tapping. The report telephone tapping suggested that person had communication with several persons related to the sale of cigarettes. The evidence also showed that person has money transfers in his bank account. After asking questions to persons who sent the money to the accused person, they said the money was for the cigarettes they purchased from the person. And the statements of the accused that he also sold the cigarettes, he said that in his statements. And printouts of the accused bank accounts contain information regarding the regular cash payouts in London City Locals, which was the place where the accused purchased cigarettes for the storage. And of this offense, the person was accused as a predicate offense too. When the Court of Appeal examined the intention of the person, it said that the person didn't have the intention because it was possible to see where the money funds went, and it wasn't proven beyond reasonable doubts that the assets were illegally obtained. The Supreme Court said that the origin of assets doesn't need to be proven beyond reasonable doubt, that the standard of proof, balance of probability can be applied to this case, and the Supreme Court quashed the acquittal and sent the case for retrial again. And the Supreme Court also mentioned that it's not of particular importance that the predicate offense actually generated a little bit over 10,000 euros because it was visible from the case file that accused person did systemical. His main income was the systemical sale of tobacco, and therefore the sum of laundered money can be bigger than the sum that was received from the predicate offense. It could be presumed. And the Supreme Court acknowledged that opinion of the Court of Appeal does not comply with the requirements of criminal procedure law regarding justifying
court's rulings. This case indicates that the legal sums obtained by predicate events could be smaller than the actual sums that have been loaded. The larger sums of funds could be presumed if the nature of the criminal activities and the evidence in case law justifies the possibility that the funds are more likely of illicit origin, and these facts must be assessed together with the explanations of the accused person on the legal, income, and other relevant case facts of the case. Before moving on, I've thought about one insight of this Latin Supreme Court. This insight goes usually regarding person's intent. The Supreme Court has used it a lot in the case law that the person's intent can be understood from the actions of the person. This thesis makes me wonder, could the actions of a person in money laundering case also show that the assets in question could be of illicit origin? For example, if large sums of cash are carried in the trunk of a car, for example, $1 million or €1 million, why is a person carrying so big sums of cash around? For example, if the cash is hidden in between coffee, as it happens in practice. And for example, if there are cash transfers based on false documents, that begs the question, would that be an economical, would that be a legal economical work with the cash, or it actually means that there is money laundering happening? I hope that this assessment will show up sometime in a court practice. That might be important if the case material shows that certain person has laundered certain assets. If there is also link with predicate offense, I guess it is possible to work with money laundering here. Indictment of money laundering declared that there has been money laundering. I have some conclusions regarding court practice of European Court of Human Rights and Latvian court practice. If I have a minute, I could reiterate again. The unlawful origin of property in money laundering cases can be proven beyond reasonable doubt. This standard of proof is relevant only in cases when there is an indictment on a certain predicate offense. It is possible to write an indictment in money laundering cases if it's a standalone money laundering. In such situations, there will be mentions of predicate offense, but the predicate offense won't be proven beyond reasonable doubt. Only the assets, question regarding the origin of assets will be emphasized for money laundering case, and the origin of assets can be proven with standard balance of probability. And of course, when we move to money laundering charges, we are working with the standard which comes from the presumption of innocence, and it is beyond reasonable doubt. What I can say about that case law practice that goes through the Supreme Court, that the court practice has mentioned several requirements, and they differ from the nature of the indictment. And the famous requirements regarding rights of the accused person are respected. Thank you very much.
Thank you very much, Oscar. So thank you for having shown the case study of money laundering. And so this has allowed us to go through, of course, the one case, one concrete decision by the Court of Human Rights, but also the two very interesting cases you mentioned from the Latvian Supreme Court. So I think we have three very complementary perspectives with Leandro on the first on the standard group, then a broader picture with Leandro, and some very interesting remarks about the Court of Justice, and then a case study on money laundering and decisions by the European Court of Human Rights and the National Supreme Court of Latvia. So I think we have some minutes for questions and discussion. Don't hesitate also if you have any questions on the morning session. We have still some speakers of the morning session here with us this afternoon. So the floor is open for questions. Yes, please.
Okay, my question goes to Mikhail, but maybe anyone else can join me. What do you think, are there any differences with regard to the presumption of innocence before one final judgment and after the one final judgment? That's my very short question.
Are there other questions? We can maybe gather a group of questions and not for the moment. We have.
Yes, you're probably referring to the that last slide when I was saying there are many parallels between the violent. Yeah, there could be some differences. I would say, for example, it's very clear, like if you look at the comparative law, this last standard is beyond reasonable doubt, intimate conviction. I think this is quite uniform in many, let's say, all jurisdictions. So what, or at least in theory, what suffices for this standard. Whereas in lower, smaller presumptions of innocence, I think it's still very different situation, very different convictions. And also there's no kind of consensus what should be, for example, the probability for prosecutor as a child, impossible to have so yeah, in practice there are differences, but in theory I think there are parallels. I'm sure that's okay.
Thank you. Gerard, please, and then
thank you for the presentation. So the question is maybe for Leandro, but maybe the else to come. I was interested in you mentioned about informing the case 6-21 form use of the right to remain silent, from the suspect of the right to remain silent. Do you connect that with, how directly do you connect that with the directive, the directive against suspects and to the accused? That's informing them what the right to remain silent may be a suspect. So maybe you can say a bit about that, and that's at that stage, sort of the standards, the standard rules of national law, and you say to a suspect or prosecution authorities say to suspect kind of applies. And so to what extent I think that that stage of the procedure is connected with the record.
So, just make sure I understood the question. You were asking the case where of the right to remain silent was linked to the right to receive information.
Well, it was case 1621. You were about informing the accused.
Yeah.
And how do you how much do you connect that to the directive? Because I think people generally take the directive advice to the more to the later stage of criminal proceedings. Is it specifically going to correct inside of the sense that could be taken directive is engaged more generally that there is a procedure? What would you say about that?
Yeah. So I think one of the, so an interesting thing of the judgment is that actually, if you read the conclusion, the public justice is providing an interpretation not of the presumptions but of the right to information in proceedings. Which is why I mentioned the case, because they see the network of rights and procedural safeguards. It might also actually be a good example of perhaps the downsides of the step-by-step approach to approximating procedural safeguards at the level of the EU, because then you see this patchwork of legislative instruments, and yes, to an extent they talk to each other, but they are not coherent in the code. And so that you see that actually you have a situation where it's critical what's happening, but you don't really see the instrument talking with other like dovetail sense. And so that's a broader consideration, and I think it's important to remember the question, because actually this is about the right of the information rather than actually directly some kind of awarenesses and applying to plain silence. And then, so on the question specifically, like what kind of stage? Yeah. Yeah. Okay.
Thank you very much. There were two other questions. One there. Yeah, please.
Thank you. Thank you. Kind question to Mr. Kulmanis. So, could you please specify, as far as we know, the Constitutional Court of Latvia has recently adopted or decision or ruling concerning confiscation in money laundering cases. So, could you please, what is your opinion about this decision?
Thank you for the question. I'll be honest with you, it's still the judgment of this Constitutional Court still lays on my table, and I haven't heard it. But I understand the principle they work with. Those are separate proceedings. The Constitutional Court had to analyze, and it's much tougher in those proceedings because, as far as I know, the money laundering charges never get to trial. The proceedings always get terminated because the assets have been confiscated and the case ends there. But the cases I mentioned, there is usually something indicating a predicate offense. So it's much easier when there is, for example, there's been a phone tapping that clearly shows the person has, for example, sold tobacco or sold drugs, and his only income has been like illegal. But in those cases, especially if they go beyond the borders of Latvia, as far as I know, it's a lot regarding Ukraine and Donetsk and all those separatist regions, and it's really hard to get evidence from there regarding predicate offenses. I have no idea how the investigative authorities get evidence to show this causal link. I think it's really tricky there. But it's a masterpiece if they manage to show that the assets in question are linked with, for example, corruption or other crimes. And they at least can state that there's been corruption, this money is through corruption or fraud. Because the Melandri case I mentioned in the European Court of Human Rights, it emphasized that there is certain crimes mentioned in the indictment, but the person hasn't been found guilty of them, but it worked. So the Supreme Court said, I'm sorry, the European Court of Human Rights said that it's enough if you know at least some kind of crime. But you're not going against that crime, you just go against money laundering. Yeah, it's hard. And on the other side, as long as I worked in the Supreme Court, I never had such cases. I'm glad that we have money laundering cases with indictments, not only on the confiscation of assets.
Thank you.
Thank you. Last question by Pedro. And then we will have to stop for our coffee.
Absolutely. Thank you all for your presentations. Actually, it's something that maybe all of you touched upon it because of you spoke about standards of proof. And it's probably Oscar's presentation that was more acute in that sense, more sharp. It's an issue that I've always struggled with, and should we try to establish a distinction between the objects of proof and the standard of proof when it comes to money laundering and confiscation? Because those are two separate things. One thing is what we have as a requisite for money laundering. What do you have to prove for both money laundering and confiscation? Probably we'll come back to this issue tomorrow, but still, I think today could be a good day, a good moment to start a discussion. One thing is, what do you have to prove? Do you have to have a full crime with all the features of the crime, or is it enough that you have some features, like it's unlawful, it's paternalistic against the law, or do you have to have more features? That's what you have to prove. But then, a different question is, how convinced, how persuaded must the court be to say this is a money laundering offense, or you have to confiscate? Because I think many times the two issues, even in the decisions of European courts, are somehow mixed and not distinct enough. I would like to, if any of you wants to address the issue.
If there is, and like I mentioned in the case law, if there is an indictment regarding money laundering, first thing is assets of illicit origin that can be presumed. If it's a standalone money laundering case, they can be presumed. Then we move to the money laundering offense itself, and we work with the standards beyond reasonable doubt. That's from the presumption of innocence. So it's a mix. But the previous question, what I had from these confiscation proceedings in Latvia, they only work with the presumption, that was probabilities, since they only work with the confiscation proceedings. And it's absolutely different approach, because in those proceedings, in separate proceedings, they go only against the assets, not against the person. So they actually never trigger this, how to say, suspicion on the person, at least suspicion. And they only go for the assets. And in the end, as the European Court of Human Rights has said, this confiscation proceeding that happens, it's a question from the civil rights, it's from the civil level. But when we are talking about indictment, when we have a money laundering case, and the person who's charged, the assets in question that have been already laundered, it's a different story. It's the outcome of the criminal case, and this confiscation happens after the person is found guilty of money laundering, of the assets that are unlawful. It's a very tough, very big mix of presumptions.
Thank you very much. I think we can also continue the discussion when drinking our coffee. So thank you so much to our three speakers. And so let's go to the door next room. And at what time do we? Okay, yeah. So 15 minutes from, so 25. Okay? Thank you very much.
arrival. I'm very grateful to the organisers for asking me to chair this panel on the challenges related to presumption of innocence in the prosecution of legal persons and in simplified forms of criminal procedure. So, a number of technical topics being discussed in the previous panel. I'm going to ask the panelists to be relatively quick and stick to approximately 15 minutes of speaking time. First up, without further ado, Robert Kurt from the University of Economics and Business in Vienna on the topic of diversion and the presumption of innocence.
Thank you for the kind introduction. Yes, it's right. I will come to a more technical point now. I would like to focus my presentation on the challenges in relation to instruments of withdrawal of the prosecution or discontinuation of proceedings after the accused has taken certain measures or fulfilled certain obligations. Only short, but I think it's important, what do I mean with diversion? In most countries we have instruments which are called sometimes diversion, sometimes they have other names, but are the essential features. Diversion in this context is understood as an early termination of criminal proceedings by the public prosecutor or in some countries also by the court without a judgment in less severe cases, and instead there is a diversion to various informal settlement types. The judicial authorities do not carry out a formal criminal proceeding aiming at the conviction, but there is no conviction and no verdict of guilt against the accused. However, in most of the cases, diversion is not only the decision whether to indict or not to indict, or whether to convict or not to convict, but before the withdrawal of the prosecution, in most cases, a diversionary measure has to be taken by the accused. The public prosecutor or the judge offers a diversionary measure to the accused, and if either the accused refuses to accept the offer, if he or she does not fulfill the obligations in time, or if he or she requests the continuation of the proceedings, the normal criminal proceeding is continued. Such instruments, as I said, are not always called diversion, but I think most of you know such or similar instruments in their legal existence. Diversion does not mean decriminalization of offences if the offence committed is still a criminal act, but the response is less formal and often more socially constructive. This preemptive termination avoids a formal proceeding, or at least a conviction. Since there is no conviction, there is no registration in the criminal records. However, in most countries, also a diversionary settlement is registered in some internal records which are not public, but which are used by judicial authorities. Normally, or in most cases, this withdrawal of prosecution is made dependent on the provision of certain services, the fulfillment of conditions or directions. For example, the payment of an amount of money, community services, participation in victim-offender mediation, or
a kind of probation with certain obligations. The requirements for such diversional measures are different, but there are common elements which we can find in mostly systems. Mostly there are limits regarding the seriousness of the offences that are subject of the proceedings. Some national laws provide that offences should not have caused the death of a person. In most countries, the degree of the offender's guilt is relevant for the decision whether a settlement under the condition of a diversionary measure is possible. For example, the guilt must not be severe, or a low level of guilt is acceptable. Mostly, there are some special or general preventive aspects which also influence the decision on diversionary measures. Such instruments are necessary and mostly useful. They not only shorten criminal proceedings, the main benefits of such measures lie in the possibility of ordering, above all, socially constructive measures instead of traditional fines and custodial sentences. This makes it possible to react more effectively to criminal offences to avoid negative effects, which are combined with classical penalties, especially with custodial sentences. And they avoid punishment, they avoid criminal records, and should facilitate the offender's resourcialization, and thus meets an important crime policy objective. But are such instruments of non-prosecution combined with certain measures in line with the presumption of innocence, and if yes, under which conditions? What is the problem? It could be said that if the offender is not convicted and no penalty is imposed on the offender, that it is not a problem regarding the presumption of innocence. This could be argued if actually no sanction in a wide sense would be imposed and no other disadvantages would be combined with the settlement of the proceedings. However, as I said, such instruments are often depending on certain measures as payment of money, rendering community services, fulfillment of victim offender mediation. Even if all these measures are not criminal penalties in a narrow sense, they are measures which constitute a burden for the person concerned. And this burden is imposed without a conviction, and thus without proving that the person is guilty. Especially constitutional lawyers have seen it as a violation of Article 6, paragraph 2, that ACHR, that in this way a punishment is imposed on mere suspicion. According to the guarantee of presumption of innocence, it is necessary to ensure that suspects and accused persons are presumed innocent until proved guilty according to law. The presumption of innocence would be violated if public statements made by public authorities or judicial decisions other than those on guilt referred to a suspect or an accused person as being guilty for as long as that person has not been proved guilty according to law. Such statements and judicial decisions should not reflect on opinion that that person is guilty. Can this be said if a sanction is imposed but there is no conviction? How can this tension be resolved? If there is a tension between diversion and the presumption of innocence, in diversion proceedings, a formal determination of guilt is deliberately dispensed. This means that the presumption of innocence still is maintained. The state continues to regard the person concerned as innocent despite of the diversional measure. One reason in the argument of those who see a violation of the presumption of innocence in diversional measures lies in the understanding of diversion as a penalty and the public prosecutor's decision to discontinue proceedings as a conviction. Although diversional measures are sanctions within the context of criminal law, they are not penalties resulting from a court's conviction or a conviction by the public prosecution authority. In opposite, it is a fundamental purpose of diversional measures that a conviction of the accused is avoided. The imposition of diversional measures does not imply a finding of guilt. Rather, the accused voluntarily accepts the burden of the diversionary measure in order to avoid a possible conviction. Therefore, diversion constitutes a procedural option in his favor, which puts him in a better position compared to criminal proceedings that would otherwise be conducted against him. The objections raised in doctrine primarily due to the fact that the diversion proceeding is not seen in the overall context of criminal proceedings. The accused cannot waive the presumption of innocence, however, can accept the diversionary measure without being considered guilty as an alternative to an indictment. However, it is clear that voluntariness in diversion proceedings is always limited, as the accused has to decide between accepting a diversion offer and the risk of the continuation of criminal proceedings and, in consequence, the risk of being convicted. However, this risk of the underlying criminal proceeding essentially corresponds to the normal risk which we have in any criminal proceeding. It is essential for the fairness of the proceedings that diversion does not increase this risk and bring additional disadvantages. This is guaranteed, in particular, by ensuring a voluntary decision. Also, the Court of Human Rights also sees the prospect of criminal proceedings being conducted could have an influence on the willingness to reject and accept an offer of diversion from the public prosecutor's office. The pressure that this exerts is compatible, according to the jurisdiction, with the ECHR. It is important that judicial authorities do not apply additional pressure on the person concerned. Otherwise, you do not have this voluntariness. The onerous nature of the performance expected of the accused therefore does not result from the fact that the state body would impose a measure on him against his will. Rather, the accused submits to it voluntarily. The offer of the public prosecutor, therefore, merely opens up an additional procedural option for the accused. He also has the option of requesting the continuation of the criminal proceedings at any time. Saying this, it is important, or it is an important requirement of such a termination of the proceeding that the accused really voluntarily accepts the burden of the diversionary measure in order to avoid the possible conviction. Diversion requires voluntariness. However, even if the accused is free to accept an offer of diversion or to enter into criminal proceedings, the accused will often lack sufficient knowledge of both the relevant facts and the legal issues to be able to reliably assess the chances he would have in a criminal proceeding. In case of doubt, he will therefore usually accept a diversionary offer which leads to the discontinuation of proceedings. In this respect, problems could arise if the facts of the case are not sufficiently clarified. The person concerned must not be burdened with the risk of a lack of clarification of the facts and an unclear legal situation. The purpose of diversion is not to avoid investigations, even if a conviction is dispensed with, the same high standards must be applied to the investigation of the relevant facts, as in the case of an indictment. The application of diversionary measures requires that the facts of a case are sufficiently clarified. Just one short note. What about public reflection on diversionary termination of criminal proceedings? There is a risk that the withdrawal of the prosecution is made public, and in public there is the impression that the person concerned who accepted the diversionary offer has been convicted and is regarded guilty. In most cases, this will not be the big problem because these cases are not so public, but if, for example, well-known persons are concerned, this problem, this risk can appear. In such cases, judicial authorities and the media have an obligation to make it clear that such a judgment does not constitute a finding of guilt on the part of the accused. The presumption of innocence requires that the accused, apart from measures and instructions which must be fulfilled for the termination of the proceeding against him, does not suffer any other disadvantages. That means no registration in criminal records, and even if there are internal records, it is not allowed to publish this information and to use it against the person concerned in criminal proceedings as aggravating circumstances. Moreover, that's my last point, diversionary measures must not lead to disadvantages in annex proceedings under administrative law. For example, a diversionary measure may not be used as a conviction as the starting point for a driving license withdrawal, or also in asylum law and or immigration law. In the same way, this termination of proceedings has no binding effect on subsequent civil proceedings. Well, on this slide we only have my results, which I think I have already said. Therefore, I finish here and thank you for your attention.
Thank you very much, and thank you also for perfect management of time. Our next speaker will talk about a more national perspective, Romanian. Nelu Bloiu comes from the University of Oradea and also the Supreme Court of Romania.
I'll try to be short in a few minutes. So I have a short introduction to the presentation in a sense because all the speakers that we heard today confirm me that in all the European countries is the same vision about the presumption of innocence. In essence, the presumption of innocence consists in two main categories. It's a procedural guarantees and also is a substantive civil right. Why is a procedural guarantees? Because it's very closely the burden of proof and standard of proof, the impartiality of the court, the separation of judicial function, and mainly on the active role of the judge in ascertaining the truth during the criminal proceedings. But also, we have to think about the presumption of innocence as a substantive civil right. Because of the suspect accused, because it has to be respected by all the person, both the legislation and judicial body for the third parties, and also must be protected allowance. So, having in mind this common understanding of the procedure of the presumption of innocence, I will shortly present two simplified procedures that are drafted in the Romanian Criminal Procedure Code. But mainly I'll highlight some common points with the Italian and the German legislation regarding simplified procedures. And also, in the final, I will draw attention on the nine important features or guarantees of the presumption of innocence. So, the first simplified procedures is the abbreviated trial procedure in case of the declaration of guilt. The trial upon admission of guilt represents an abbreviated procedure concerning the facts set forth under the criminal charge that is conducted mainly on the basis of the evidence gathered during the criminal investigation, which has been previously considered by the pre-trial judge as having been lawfully obtained, evidence that are not contested by the defendant regarding its credibility or reliability, and which is considered by the trial court as sufficient for the reconstruction of the truth in the just resolution of the case. So, we'll have an abbreviated procedure in which the judicial inquiry is limited only on the evidence gathered during the first phase of the procedure, the investigation phase. And also the procedure in front of judge is abbreviated only to the documentary evidence. In this procedure, the defendant has the possibility personally or by an authenticated written document to admit and the facts described in the indictment are not always the juridical qualification of the facts, and to ask for the courts that the judgment will be made only on this procedural circumstances. The procedure is not mandatory because in the first hearing the court has to inform the defendant about his rights, and also the court will take care that the procedure will be admitted only if there are sufficient evidence in opinion of the court that can consist a serious case, and the procedure has not been overturned during the first phase of the procedure. So, allowing the procedure, it will be placed in the criminal procedure trial after the hearing of the defendant, in which the court has two possibilities: admit the request when the conditions are fulfilled, or reject the request for the trial according to the abbreviated procedure. When in this case, the procedure will continue on the ordinary procedure. The second, I will shortly take the second procedure in the abbreviated procedure, that is the plea bargain agreement. The plea bargain agreement constitutes the referral of the case to the court concluded between the prosecutor and the defendant within a specific special procedure when the defendant intends to admit the fact on which he or she is accused, and their legal qualification and agreed during the discussion with the prosecutor the manner of individualizing the sanction treatment. So we have 6 main conditions. The defendant must have been heard before mandatory legal assistance. Also, the penalty has to be fine or imprisonment up to 15 years. Sufficient evidence gathered by the prosecutor investigative body from which we can see that the existence of the act for which criminal proceedings were instituted and the defendant guilt result is sufficient described. And also the case prosecutor and the defendant agree on the object of the agreement. The object of the plea bargaining agreement are 3 main objects: the unconditional admission of committing the acts for which criminal proceedings were instituted, the acceptance of the legal qualification of the act for which criminal proceedings were instituted, and the type and the quantum of the penalty. During the procedures, the courts can admit the plea bargaining agreement or reject the plea bargaining agreement in 3 hypotheses. When the plea bargaining agreement is illegal, when the plea bargaining is legally drawing out, when the court considers that the solution agreed upon between the prosecutor and the defendant is disproportional with the scope of the penalty, and also when the court considers that the evidence has been gathered illegally during the first investigation phase. These 2 procedures, also with the vision, the divided vision of all the presumption of innocence in the procedure, guarantee or civil rights, raise the problem of the guarantee of the nature to ensure the effective procedure protection of the presumption of innocence. So, not only in the Romanian criminal procedure, but if we analyze the German law, the Italian law, the French system, and all also the American way of thinking about plea bargaining, we can find some important guarantees that make the presumption of innocence compatible with the disappropriated procedures. So, the first guarantee, I think, is the optional nature of the simplified procedures. The second guarantee, I think, is the detailed information of the defendant regarding the factual or legal ground of the accusation. The third important guarantee is ensuring an effective disclosure of the evidence gathered in the criminal phase. The fourth guarantee of the presumption of innocence is the necessity of a voluntary expression of the will by the accused to admit the accusation and follow the abbreviated procedure. The fifth guarantee is establishment of the limits of the access to abbreviated procedures. For example, in Romanian criminal procedure, the abbreviated procedure cannot be admitted in case where the defendant is accused of committing a crime sanctioned by life imprisonment, and the plea bargaining agreement cannot be settled if the penalty is about 15 years of imprisonment. The sixth guarantee is that the obligation of the prosecutor to conduct an effective investigation that supports the accusation. The seventh guarantee is the establishment of a mandatory measure of the legal assistance in case of plea bargaining agreement. All these procedures, or these guarantees are made to make compatible with the legal presumption and the principle of the presumption of innocence these simplified procedures in which the defendant voluntarily admits the guilt as the guilt is settled by the indictment act or other acts issued in accusation by the prosecution. So, even in the procedural situation in which the defendant admits the guilt, the presumption of innocence is not suspended. He is also, we find guarantees until the final decision is made, guarantees that enforce this presumption even in situation in which the defendant admits the guilt. So, I think that these two procedures that are a speedy procedure to resolve the case and in which the costs are less than in an ordinary procedure, are fully compatible with the presumption of innocence only if these seven guarantees that I mentioned before are respected in the criminal perspective. Having this in mind, I will notice also that not in every country and not in the common jurisprudence of the national courts, we find common understanding not in position of the presumption of innocence, but also on the presumption of guilt. So I think that if we have a common understanding about the presumption of innocence, I think in the future the attention has to be allocated also on the legal or judicial presumption of guilt and the compatibility of this presumption with the right of the fair trial. Thank you very much.
very much, and thank you for making such an effort to keep your presentation brief. I'm sure there will be questions that will allow you to elaborate further. Our last speaker on this panel is a practicing lawyer, a bit of a change for many of us, and a welcome change. Violetta practices law here in this country, and she'll be talking about the presumption of innocence for legal persons.
Good afternoon, dear guests, dear ladies and gentlemen, colleagues. I'm greatly honored to be here to present your high level of technical personality, and great thanks to Professor Christine Rosenberg for inviting me, because I'm not now I'm not an academic anymore. I used to be, but now I'm only practicing as a symphony. So I'm a bit like outsider who is sneaking into today's your big event. But anyways, I'm glad to be here, and unfortunately my presentation will not be presented, but it was very short, so not a problem at all. I think with that I will try to stick to my paper so to be as precise as possible and to say, to present what I want to say. And my task for today's presentation is to elaborate, rather brief, in such, I would say, judicial matter as a question whether the presumption of innocence for legal entities is a real guarantee or whether it's a kind of false presumption or just an illusion. Stepping forward to the end of my conclusions, I can say, at least from the defense and from this perspective, that first, from the Latvian law perspective, this presumption of innocence for legal persons, from the law perspective, if we interpret and look into the law correctly and carefully, is totally a real guarantee. Still, when you continue to elaborate from practical angle, they find as a principle would rather say that there is a bigger room where to work and to elaborate in our law practice and judicial practice will grow. So now let's stick to the details on how I went to these conclusions and what are my thoughts from the practical point of view when helping clients, which are mainly corporate clients, in white-collar crime cases. So, in the criminal law of Latvia, companies cannot be held criminally responsible on their own. However, for the past 20 years, Latvian laws have been allowed to use coercive measures for any crime prescribed by the criminal law. For more than a decade, the concept of holding companies responsible in Latvia didn't really work. This was likely due to a lack of understanding, knowledge, skills, or of this responsibility. In 2013, the law saw significant improvements. The lawmakers recognized that many laundering, tax, and corrupt crimes were being committed from the beginning of companies. As per legislators' view, often only the individuals directly involved in the illegal activities face consequences, while companies benefit. Over time, there was even greater willingness to initiate legal proceedings against companies, especially in cases of mentioned type. These cases often proceed almost automatically, without careful consideration of whether the crime truly served the company's interest or whether the individuals involved were insufficiently supervised. As a defense attorney in a corporate law firm, I often represent specifically companies accused. These are typically international, long-lasting, and reputable businesses. It's shocking for such a company when it falls under an investigation due to possibly illegal action by its employees or management. On the other hand, there are also cases targeted to investigation of so-called shell or other companies, which are typically created for committing crimes. However, my experience primarily involves well-respected, successful companies that have no intent of engaging in illegal activities. When criminal proceedings are initiated against such a company, the impact can be devastating. Banks may refuse to work with them, business partners might end their relationships, and employees would leave. The situation can even lead to companies' losses or even bad impact to its reputation. In these cases, the presumption of innocence becomes particularly important. This is especially noticeable when the reasons provided by the investigation are unclear and general, typically simply presuming a connection without having solid evidence. I will later provide some specific examples of how a company might be linked to a crime. However, I want to emphasize that in such situations, the idea that the companies benefit from the presumption of innocence can often seem irrelevant. Still, when the plaintiff is a liar, we strive to demonstrate their innocence. Often, this requires more effort than what would typically be expected in a criminal case involving a natural person. Next, I will share some insights into how we proceed when defending the company's innocence and demonstrating that the presumption of innocence is a procedural guarantee for the identity for real. First, here to speak about is an understanding of the presumption of innocence for companies. In Latvia, like in any democratic country, the presumption of innocence is a fundamental principle generally accepted for individuals. However, its application to companies is not straightforward. This may be due to a lack of clear guidance in the law regarding how this principle applies to companies. So, here we come to the question, how can we determine if this principle applies to businesses? We need to follow a multi-step approach. In step 1, we refer to the directive which was mentioned here for several times, which is Directive 2016/343 of the European Parliament and the Council. As we know, the only EU law focused as a tool the only tool which ensures the concept of fair trial, including this concept of presumption of innocence. But in practice, as we know, that is directly applied only to individuals. Here it's worth remembering that back then, in 2016, it was recognized that the legal framework for companies was not yet developed enough for such legislation which could be set specifically applied to legal persons. In step 2, we emphasize that the directive states that the presumption of innocence for companies must be upheld through existing legal guarantees and case law, both at national and international level. Thus, we need to examine Latvian law and particularly how it's interpreted in legal practice. Article 19 of the draft Latvian Criminal Procedure Law states explicitly that no one can be deemed guilty until their guilt is proven accordingly to the law. Furthermore, the Latvian Constitution refers to fundamental human rights, which includes the idea that everyone is presumed innocent until proven guilty. While this wording might seem to imply that this guarantee only applies to individuals. Legal literature and portfolios explain that anyone may refer to both individuals and companies. The Constitutional Court has repeatedly stated that the rights and freedoms outlined in the Constitution also apply to private legal entities where relevant. It is emphasized that the fundamental principles of criminal procedure apply equally to both individuals and companies. In step 3, we look at the EU case law. Their companies' rights are often derived from competition law disputes. The Court of Justice refers to the Charter of Fundamental Rights of the European Union, where Article 48 states that every accused person, including companies, is presumed innocent until proven guilty. For instance, in the case 2021 case of Hamilton versus the European Commission, the Court stated that the presumption of innocence is a general principle of EU law. It must be considered alongside the legal frameworks, including rewarding legal entities. In other cases, the Court has confirmed that the presumption of innocence applies to legal entities facing penalties for violations of competition laws and other types of laws in different fields of law. To summarize here, it must be concluded that with the legal framework, the presumption of innocence is a valid procedural guarantee for companies. Although the law may not be entirely clear, the legislature has chosen to treat companies with the same procedural guarantees as individuals. However, if the law were clearer and didn't require a multiple test to determine its meaning, it might be simpler and safer for the company's defense. Next, we confront another significant question which is more of a problematic nature. It is to find whether the presumption of innocence for companies is a truly existing guarantee in practice. I believe that's quite predictable that if investigators and defense attorneys express their views on this matter, we will hear rather highly different opinions. As an attorney with experience representing companies that have long-lasting and successful businesses, I can assure you that this is a very important and problematic issue. Imagine the impact on a reputable company if it receives a decision from an investigator or prosecutor who usually limits the connection to alleged crimes with the following more confident assumptions which I have borrowed from real criminal case law. Like, the legal entity has failed to take measures to prevent the crime. That's it. Second, as a result of the crime, the taxable income has decreased, suggesting the crime is committed in the interest of the company. That's it. An employee acted in the interest of the company, taking advantage of insufficient internal supervision and control. That's it. And that's the material which we work on as a defense attorneys when representing and defending legal entities. In most cases where the investigator and prosecutor bear the burden of proof, legal entities may feel they can rely on enjoying the innocence of guarantee and wait for these assumptions to be proven false. This is quite true since the law, legal doctrine, and case law have established specific requirements regarding the establishment of liability of legal persons. First, this is the requirement to establish the relationship of a legal person with a criminal offense, including that the offense was committed on the behalf or in interest of the legal person. Second, this is the requirement to establish the link of a natural person to a legal entity. This includes that the individual who committed the crime advantage of weak internal control. Proving these connections requires an evidence-grounded assessment of whether the legal entity implemented adequate supervision and controlling measures. Yet, real-world experience shows a stark contrast. If a legal person relies solely on the presumption of innocence and takes no proactive steps to demonstrate his innocence, it's highly likely to face a court conviction and confiscation of assets and other measures which can be taken according to the law. In effect, this can transform this presumption of innocence into a presumption of guilt based on the investigative narrative, which I said before is quite narrow and highly limited to wordings and details of these accusations. As a result, it has become commonplace for legal entities to engage in proactive measures by conducting internal investigations. That includes in-depth analysis of companies' policies, analysis of fulfillment of specific tasks and duties, and performance of specific transactions. These findings are then presented in criminal proceedings with the hope that the decision makers will accurately evaluate the evidence and not confuse the presumption of innocence with presumption of guilt. What is the outcome of the case after doing this, including internal investigations? This is a matter of concern since the approach and results differ from case to case. However, in conclusion, I would like to highlight the top 10 red flags we usually address during internal investigation. We usually find it relevant to the scope of the investigatory object, where the accusations of corporate crime are addressed to a legal entities. Not going into details, I present to your attention to highly important corporate government risks, such as, and here I will mention only 3 of them, but in my slide there were all 10 of them, but the most important I find the following. First, ineffective corporate structure, which as a risk helps conclude whether the company has sufficiently outlined and divided responsibilities. Next, insufficient compliance policies. Here, I find worth mentioning that having or not having such procedures is not often the deciding element. One major question here is whether these procedures are up to date and whether they really work on a daily basis. So, we may continue here with many other risks or red flags. However, I will emphasize here one highly red flag, which is the overrating of trust. I won't elaborate deeply on this issue. I just find it necessary to mention as one of the dangers within strong and equitable businesses. To conclude my as a defense attorney's opinion here and findings today are, and returning to what I started here, is that first, the presumption of innocence of legal entities is a real guarantee from the law's perspective. However, to reach the key and beginning of investigations, there is a rule in its development. Thank you for attention. I'm happy to go brainstorming and answering some questions. Thanks.
And let's start our session with the presentation of Arthur Bush, Judge of the European Court of Human Rights, and our University of Patent.
Good evening. For the ones who have survived so far, have thanks for everybody who is still here and who have to be all day and could imagine the discussions. First, I would like to say thanks for Edward's community for inviting me, Christina Strada-Lotterman, my dear colleague, also for inviting. When first I got an invitation and I thought what would be the topic, with my background, I'm a judge less than a year in this Strasbourg, so it will actually have many changes. It might bring some changes also, I suggested in case law. Oh well, we already should, because one third of the judges have changed. I would say in the last this year. And I immediately thought about premature statements, because this was one of the topics, because my background is more international human rights law, media law, that's where I would see cross between the presumption of innocence and freedom of expression is. In my presentation, I would like to address three things, and I would only shorten up some things to our short time limits. First, a little bit looking at the language used by courts for some misstatement conclusions we might mistakenly derive from it about freedom of expression and presumption of innocence. Second, about subsequent trials and also caution the judge should have subsequent trials. And last but not least, about statements by public officials. And if presumption of innocence is violated, what kind of remedy we should use, criminal, civil, or both. And yeah, as I said, the court basically has identified various situations where presumption of innocence can be violated, can be reached. Statements by trial court, for example, some of you already, Christina mentioned Laden's case, which is one mentioned. Statements by judicial authorities in subsequent proceedings, Episcopal versus Italy is also mentioned already today, and statements by public officials, which is Latvia. So, because I'm the judge, especially elected or in respect of Latvia, that's why I call you Latvian cases, but also because they have some broader considerations. So we have, at least for two of these lines, we also have some Latvian cases in Strasbourg. One thing that I wanted to start with is that actually not with the judgment of the Strasbourg court, but as I said, the way how we treat freedom of expression and presumption of innocence when two rights collide and this is a statement from the Court of Cassation, the chamber, where the French Court of Cassation said the normative value of the right to presumption of innocence and I like the freedom of expression is the same. And it's up to the judge to weigh these rights against the interests at stake and favor the solution that best protects the most legitimate interests. And in this case, the Court of Cassation refers to the law versus Switzerland. I mentioned the judgment, and I'll come to that in a minute. But this raises for me an issue. Can we really say that should we really weigh or balance, right? Can we really say that presumption of innocence has the same normative value as freedom of expression? And is really weighing or balancing really appropriate language or tool when we talk about presumption of innocence and freedom of expression cases? Can, for instance, conclusions that expressions have influenced the conduct of criminal proceedings be overridden by the right to public to receive information? And so I think we have to be very cautious the way we approach when these conflicts arise and the way we treat them. Why I'm looking to the Grand Chamber that now is Switzerland, it was a broader issue basically about, some of you I guess know this case, very well known. It was brought to the article then, the draft report where journalists basically publicized the materials of investigation, basically secret materials about the case, which had very big discussion in Swiss society about the driver being run
crowd, 3 people died, and so he publicized the information about what kind of information, what kind of questions investigative judge asked, what were the answers. So I should say it was also a bit controversial result, because the chamber general level, it was 4 to 3 decided that there is no daily violation of Article 10, while grand chamber in I would say 15 to 2 basically decided that there is no violation of Article 10. It's true that in this case the court stated that when the court is called upon to adjudicate on a conflict between two rights that enjoy equal protection under the Convention, the court must weigh up competing interests. That's true, but you have a finding like this in this judgment. At the same time, I would say, as I said, if it should not be interpreted in a way that freedom of expression should be balanced if we find out that the presumption of innocence actually has affected the trial. I mean, if we conclude that, come to the conclusion that the impact of the statements were of such nature as to have an impact on a criminal proceedings, that it affected criminal proceedings, I think in that case, I don't see the place for balancing the freedom of expression. However, if we say that the statements which were expressed have no effective criminal proceedings, then of course the presumption of innocence will be intact. But I think the language of balance is probably in older sense, but still we have to be very cautious in that regard. But otherwise, we start to relate more about how different situations may arise under the presumption of innocence and how itself is concentrated complex one, where the situations might be very, very different. But just as one of my concerns about methodology and also magnitude by court. Second issue is already raised, and I will probably not go so much on this. It's kind of very well known that the court has repeatedly emphasized national courts have to exercise particular caution when they formulate the grounds for the judgment in a single case following the termination of criminal proceedings. And what is important from last year's also grand chapter in Maryland and Colin versus UK, the court made it very clear there's no distinction if the person has been acquitted or there was discontinuance of the proceedings. So, regardless of that acquittal or discontinuation of proceedings, the person should be presumed innocent in those cases. That should be, because from time to time we do have cases where due to time bar, for example, proceedings have been discontinued, and then involving civil proceedings, the judge prefers to treat the person as guilty, to say just because of the time bar proceedings were discontinued, you were not acquitted. This is certainly a violation of Article 62. And what else, of course, I mean, one example to mention is and we already mentioned the case of Episcopal versus Italy. We will have more discussion tomorrow on the substantial relevance of the confiscation. In Episcopal, the court of first instance convicted the person and ordered confiscation of proceeds of crime. The proceedings were discontinued in the second instance due to the statute of limitations. At the same time, the court decided to national court, they oppose the confiscation of the property, concluding that the evidence found by the court of first instance proving the person's guilt was not ultimately doubt, and that if the proceedings had not been terminated due to the statute of limitations, the person would have been found guilty. And the problem here is very clear that namely the national domestic court
did not limit itself to assessing the criminal origin of the property, but expressly stated that the person was guilty of committing a criminal offense. Of course, Article 6 does not preclude the national courts in subsequent proceedings from engaging with the same facts, as were decided in previous criminal proceedings, as long as they don't constitute criminal liability. So, and the third question is stated by public officials, and what kind of remedies are effective or should be considered by effectively remedy presumption violation of the presumption of innocence. Should it be criminal proceedings? Should it be civil? Or both? And I would say the court's case law is somewhat, I would say, open on this. If you look at the case law, which, I mean, an old case law, you can see very clearly that there was a preference for criminal proceedings. The court said quite clearly, and I refer to this in slightly as there was this referral to the previous case law, allegations of breach of presumption of innocence were normally raised in the course of the criminal proceedings against the applicant in order to give the criminal courts an opportunity to place the applicant as far as possible in the position he or she would have been at the requirements of Article 6 being disregarded. The court has also held in several cases that the civil claim for damages could only be related with the alleged violation and sufficiently barred. So you cannot handle the fully the situation. You cannot put the person back in the same situation he was in a criminal proceeding. So you cannot fully remedy the alleged infringement. At the same time, if you also say, in this case law, and there are a number of cases where court has found that the civil law remedy may be an effective way of addressing a complaint relating to judicial statements made in respect of ongoing criminal proceedings, either alone or in combination with the criminal law remedy. So, if I would say then, you see that the time basically the court's case law is somewhat open to this question, but I would say it very much depends on the factual circumstances. And also on the domestic case law of countries, and compared to the EU, where you have 27, here you have much more. You have 46 jurisdictions. That's also important to remember that the court is dealing with much more states than it is, for example, in EU. You don't have one EU country. So, therefore, I would say when we look at that, we have to remember that we don't have to generalize, but have to make these conclusions taking into account the facts of the particular case, and also see these conclusions in light of it. However, last but not least, we had a number of cases where defamation proceedings have been used. So even if I would say there might be cases where civil remedies are the right ones, can and should be used, can defamation proceedings be regarded as an effective remedy? And you can see there is a certain overlap between presumption of innocence and defamation. The court has addressed, for example, that you don't have criminal proceedings, but somebody is accused person was appealed also criminal proceedings, then defamation proceedings are not what you should not use. Also, when it's a media, for example, unless there is a media campaign, it's a private person, private entities, then usually you can use defamation proceedings. Also, in GN versus another versus Italy, also the Grand Chamber stated that when the criminal proceedings have been concluded, the person's reputation and the way in which a person is perceived perceived by the public, so there is a certain overlap between Article 6.2 and protection under Article 8. At the same time, I think it's important to remember that these are two distinct points. And while they may overlap in certain situations, they serve different purposes and principles by also different dates. And principles by used by the draft reports, for example, defamation cases, not necessarily are always the same ones when we want to analyze if the statements have affected, for example, integrity of the trial. For example, one of the crucial criteria for 6.2 would be to analyze how the expressions influence, if they influence the conduct of the criminal proceedings. For defamation cases, this is not relevant. You would not look at this criteria. You would look, of course, content, public interest, and different other factors, which, but for presumption of innocence, I would say this would be very crucial. Therefore, I would say defamation proceedings, I would be again reluctant always to say that they are effective. However, there might be situations again where you actually, for example, you have expressions as the president of the country, or member of parliament, that have an immunity against the criminal law. So what type of expressions you can use, what kind of procedures you can use in these type of situations. So there have been situations when that type of context also defamation proceedings have been acknowledged as an effective. So situations, as I said, are very different. To conclude, I would say the course of national courses of the Strasbourg Court, of course, has to be very cautious in using the language of balancing when it goes to presumption of innocence. And, for example, always with right to freedom of expression, rather than to use the language of balancing, I would say we have to look at the practical effects of the expressions and whether they infringed on the criminal proceeding. Second, the court should be very cautious in the seeking civil proceedings, not to refer to persons guilt, and it doesn't matter whether the person was acquitted or is seeking for a continued time bar. And last but not least, as I said, the court case law, by the way, placing preference for criminal law remedies that left open doors also to both criminal and civil law remedies in cases of violation of presumption of innocence. But these court findings have to do with the factual circumstances of each respective case. And also, what was the content of violation of the presumption of innocence and remedies available under domestic law in such situation. Therefore, before making some general conclusions, it's worth always looking at specific solutions. So with this, I will conclude, and thank you for listening. And I think for this topic, I would say that is definitely able for future discussions and debate.
Next speaker will be Zlata Jurdevic. She is a professor of criminal procedure in Zagreb University. Zlata, please, the floor is yours.
I would like first to thank Professor Strada for inviting me to this wonderful conference, and also Professor ECLAN for these events, which are very enlightening, and it's always nice to see you all. So if you have thought that the presumption of innocence is a very complicated subject, now you will see in this session, I think you have seen that already from the previous speaker, that's even more complicated yet you have thought about. Because it really touches not only to the criminal procedure and the human rights, but also to the rule of law in democracy. And that's what we are going to try to find this connection between between the publicity of the proceedings and the perception of innocence. In my presentation, I will talk about one very case important for Croatia and the whole Europe case, which is Pesha against Croatia. Then about the position of the state attorney and the presumption of innocence, something about publicity and criminal proceedings, what does it mean, and what types of publicity or secrecy we have. What is the purpose of secrecy in pre-trial procedure? What are the conflicting values that we have then with the secrecy investigation, which can prevail sometimes? What is the public interest exception? Something about defense rights, victims' rights, and the risk of political abuse. First, about this famous case, it's a key case for Croatia. It was a key case also at the time for European Court of Human Rights. Pesha was the former vice president of the Croatian Privatization Fund. As the Croatia was a socialist country, we have a lot of socialist property, which belongs to everyone, the state, the society, and we have to privatize this. So it went all to this privatization fund. Of course, as we are a country with high level of corruption, there was corruption also in this fund, and the state attorney office started this operation, so-called Big Maestro, that he actually charged several persons from the Croatian privatization fund and some other ministries, and also Pesha, who was the president. He was arrested on the 16th of June 2007, detained on the 18th of March 2009. So you can see almost 2 years he was detained. And he was convicted in 2011. Before that was the decision of the 2010 decision of the European Court of Human Rights. What happened immediately after his arrest? So he was arrested on the 16th of June, and already on the 17th of June, 21st of June, and 22nd of June, the chief of the police said to even sit down for a coffee with them and be allowed to participate in the deal, you have to pay 5,000 euros. 50,000 euros, sorry. The chief state prosecutor said publicly in the newspaper, they demanded 50,000 euros just to hear you out. The Prime Minister, the President of the government, said, what happened in the privatization fund was organized crime. And the President of the Republic, who is very, likes to make very jokes all the time, at the time he was the President, he said, Operation Maestro is just one line of action, and there will be more. The melody is known, and it's being tuned, and the score is already set. The 3 tenors will get an orchestra. One of the tenors was the president of the privatization fund. So you have these statements of the highest politicians and highest officials who are just after the arrest giving these public statements. So the European Court of Human Rights, of course, found in the violation of Article 6, Paragraph 2 of the Convention, with regard to the presumption of innocence, it was breached by public statement of the senior government official shortly after arrest. So let's see what are the legal principles and democratic practices which came into play in this judgment. So what was actually enacted there in Croatia, and since then it was applied, is that what are the duties of the public authorities in case of such a politically high-profile criminal case. So they have a duty to inform the public about, but they have to protect presumption of innocence. There is a line between the public transparency and prejudicial communication. So their communication, they have to inform, but they have to be very cautious about the language and the prejudice that the person is guilty. They must refrain from prejudging guilt of the public statement, and it is really crucial in the high-profile and politically sensitive cases. And since then, in this judgment, we actually didn't need any reform with regards to the criminal justice systems or with the law, but we needed to reform the mindset of the political officials, especially in high position was required. And I must say that this didn't really happen. Why do we have this, and why do we need this caution? Because these politicians have very large influence on the public, and there is a danger that they shape perception of the guilt outside of the courtroom. Public statements can, of course, undermine defense rights and judicial independence and integrity. This is the point of questions, whether the judges who have all these guarantees of independence can really be influenced, but the European Court of Human Rights has taken. There is also, we can ask ourselves why they have given all these statements. What was the reason for their activity? What was the politics? There was a politicization of the investigation. They have to get some political points. And it's obvious that then political investigative powers can be misused for the political gain. However, I think that we have to look closely to the position of one of these officials. If you remember who were they, there was a chief of the police, chief state prosecutor, prime minister, and president of the republic. So two of them are politicians, prime minister and president of the republic. The chief of the police is also part of the executive. However, the state attorney, he is not a politician, okay? He is more judicial figure in Croatia, probably in most of the countries. And what is his role in the criminal proceeding? His role is he is responsible for proving the guilt, for collecting evidence. He can initiate proceedings only with reasonable suspicion. If he doesn't believe that the person has committed a crime, and didn't commit evidence which are enough for reasonable suspicion, he cannot start the proceedings. So actually, his duty in the criminal proceedings is to override, to rebut the presumption of innocence. So the one can ask, can he be responsible for this statement? Can he breach actually the European Convention on Human Rights when he gives such statements? Because if he has any doubts, then he has to go further and further. So prosecution has to believe that the person has committed a crime. However, what is the general position is that the prosecutor's statement implying guilt outside of the courtroom and without proper context may violate the presumption of innocence. That's a bit controversial. We can, of course, discuss about it because he is not. That's his position, and of course, when he, for example, comes to from the courtroom and you have investigated journalists who are asking defense and who are asking the prosecutor, of course, that the prosecutors are going to tell that he is guilty and that they have done everything to prove his guilt. Okay. So I think there is a slight difference between the politicians and the chief state prosecutor giving such statements. Let's see what is the publicity in criminal proceedings. Probably we all know that this is one of the fundamental fair trial guarantee, which is guaranteed by the Article 6, Paragraph 1. So it's exactly there. Just after that comes the presumption of innocence. But everybody has the right to be tried publicly before the court. So the question is, what about the pre-trial stages of the criminal procedure? So that they are not public. What does this mean? Are they secret? And we can here differentiate between the scope of secrecy concerning the persons, the procedural acts, and offenses. As a procedural officer, I'm getting a bit technical now, but what can we do? So with regard to the person, the proceedings can be confidential for the parties and for the general public in complete secrecy. That's rare, and that's mostly at the beginning and the initiation of criminal proceedings, when you don't have reasonable suspicion yet, and even the defendant doesn't know that the proceedings are going on. Or it can be confidential for the general public only. And Switzerland, it was found out that actually most of the European countries have secret investigations with regard to general public, not to the parties which are participating. Procedural stages and investigative acts. So first we have these secret investigative measures, surveillance, interception, which are usually preventive, and of course that they are secret. That's the whole point, and they are as such provided in the criminal procedure. However, the pre-investigation, so that's, one can say, before reasonable doubt has been established, is usually secret. However, investigation, that's when we already have criminal proceedings, and the question is now how we can, and to which extent we can provide secrecy during the investigation. With regard to offenses, of course, there are some criminal offenses like national security, counterterrorism, and organized crime where you have maybe more secrecy in the proceedings, or you can have for all offenses also. And at the end, the type of publicity, it can be direct publicity and indirect publicity. So direct publicity is when there is a physical presence at the trial. The citizens can come to the trial and just follow them without any further requirements. If there is a physical space for them. However, the question is, what about informing the public about the proceedings, informing the media? So the question is whether, for example, during the investigation, the parties can inform the public about the content of the evidence. And also, it comes to my mind now that we can also the secret. What can be secret during the investigation? Is it just the content of the evidence, or also certain repressive measure can be secret? Can, for example, arrest be secret during the investigation, or search of apartment is secret during the investigation? I don't think so. So in a democratic country, the repressive measures towards the individuals cannot be secret. So what is then the purpose of secrecy in the pre-trial phase? Why do we have this consent in Europe that the investigation should be secret? The first reason is protection of the presumption of innocence. And when the countries are introducing like racial equality recently, complete secrecy of the proceedings, the presumption of innocence. The politicians are also have presumption of innocence. So we have to shield them during the investigation. Then we have the other reason is safeguarding privacy of the suspect, victims, and witnesses. So before there was a real indictment and we go to trial in public, if you are not sure that there will be indictment, you have to protect the privacy of the victims, witnesses, and suspects because of the huge burden which is put upon these persons during the trial. The most important reason actually why this exists is the integrity of the proceedings and effectivity for the investigation. So it is considered that the investigation will be more effective if it is secretive, if the public doesn't know that we have proceedings and what are evidence players content. Okay. However, there are also values and interests which conflict with these investigative secrecy. And in which in some cases, I believe in all countries, would prevail over the investigation. First, and most important one, is the public interest. So the transparency. I will say something about each of them. The second one are defense rights. The third one are witness rights. And the fourth one are accountability of the institutions. So the risk of political abuse which exists in every country, however we consider that we are a lawful country or and this especially is dangerous when the leaks come from the state officials, like police or prosecutors. This is very a problem. So first, the public interest exception, actually was explained already before, so I can go also quickly through this. So democratic legitimacy of the criminal justice system demands transparency. You are probably all aware that the right to effective investigation is one of the basic human rights, that the victim has the right to effective investigation with regards to Article 2 and Article 3 of the European Human Rights. And what is effective investigation? There are many characteristics, but one of them is transparency. So the victim and the public has to know what is going on with regard to investigations when somebody is murdered or when you have torture, when you have this birth violation of human rights. So the public has the right to be informed, especially in the cases of political corruption or systemic wrongdoing. So when you have investigation against a politician, that's public interest exception. Then we have investigative journalism, as we all know, which can expose failures or abuses in the criminal justice system or of the government. And this all, of course, contribute to the justice. They have this role of a watchdog, as we all know. The public interest exception also is protected under Article 10 of the European Convention of Human Rights. And it's even protected in the cases, these are some cases from the European Court, I won't go through it, but just to see that when the national security and intelligence data is disclosed in the media, and this is a politically sensitive, the Article 10 prevails. So the state cannot criminally charge these journalists. The other case is information is obtained legally, even if information is obtained legally, but it is politically, and that is very important, and that there is a public interest, that's Radio 3 versus Slovakia. Also, Article 10 prevails, right of the public to know. And the third one is this, Budkevicius. I was wondering if it's pronounced well, but probably because it seems to. And in Lithuania, I'm going to tell you something about this case. It was in 2002, fairly recently, and there was a secretly recorded phone call between the Prime Minister and the mayor. It's not the mayor of Riga, I checked that, so another signature. During the corruption investigation. And in Lithuania, what is really good and which we don't have enough things, in the case when the prosecutor finds that there is some administrative offenses or violations of law or regulation, but it's not criminal prosecution, it doesn't amount to criminal prosecution, they have to send this material to the parliamentary anti-corruption commission, so parliamentary committee, ethical committee. And during these proceedings in the parliamentary committee, they actually disclosed to the public these phone calls. And the Prime Minister was complaining to the courts because of the disclosure. And what the European Court of Human Rights said? It impacted the Prime Minister's reputation, but it did not affect the private life. So you see, like health of personal matters. And there was no violation of Article 8. Article 8 is a private life protection. Public interest in exposing political misconduct outweighs privacy concern. So there is difference here in this case with regards to the Vedal case, which the decision was different. And what is really important, and I congratulate the Lithuanian Constitutional Court for this actually saying, and it was cited by the European Court of Human Rights, they said that the action of the public officials related to the state and local governments are inherently public. And the media have the right to access and report on the potential misconduct. So even this was a private conversation on the phone, which was closed to the public. The European Court of Human Rights found out that the Convention was not the Convention was not violated, and the Article 10 prevails, and the Prime Minister doesn't have protection of the Article 8. Then we can talk about defense rights. So how the defense rights can go also against the secrecy of the investigation. First, defendants are often excluded from the early stage materials under secrecy rule, so they are not able to defend themselves. And that may prevent even effective challenge of some fundamental rights, like right to freedom of the detained, freezing of assets, right to property. And if actually there were some leaks or media are talking about this case, then the defendant has a right to correct misinformation. And he has a right to protect his reputation. So even if the investigation is secret, defendant in these cases can go to the public. Especially when you have, in some countries, it's the case, you have a rule of law reason, you don't trust to the institutions, you don't trust your judiciary. Right? So you're asking for the public oversight to get the accountability of the authorities. And especially in the case of so-called selective leaks by the prosecution of selective information. So that happens. I don't know whether that happened in your country, but in some countries, the prosecution and the police are the one actually who are leaking information. Okay. And in this case, of course, then the defense has also right to go to the public and defend herself or himself. Then the victim also can breach this, there's a legitimate interest of the victim to breach this secrecy of investigation. First, the victim has the right to effective investigation, as I already mentioned. And he can look for if he doesn't believe or there is a lack of institutional trust again, he can look for the public oversight. There was a case in Bosnia and Herzegovina, which happened very recently. There was a woman, Clara Bundic. She is the victim of the domestic violence in Bosnia and Herzegovina. The proceedings are going right now. She actually recorded audio of her husband's violent assault on her, and he was a very famous national handball player. This violence went for years, and she did not want to play anymore, so she recorded everything and let us know all, and he gave to the media. Actually, he was released after the arrest after 48 hours, and the trial that just began remained closed, although she said, I don't want to close the trial. I want to bring it into trial. But the court said, no, it's domestic violence, it's privacy, and you cannot decide about it. So you can see that's a case where the victim has rights to reach under the rule of law concerns. And then the other case, which is opposite to this one, we all have heard about it, that's Giselle Gréco from France, which was the victim of the mass rape, which lasted for 10 years, and there was a lot of perpetrators. So she, for the first time in Europe, at least refused secrecy for the sexual offenders, sexual offenses. All these perpetrators were examined during the trial, and this was all public. And actually, we can, after this case, we all can ask ourselves, do we all have these very patriarchal provisions in the criminal proceedings? If the court can decide to remove the publicity from the trial when the victim says, I don't want secrecy. There is nothing that I should be ashamed of. I don't want that you protect my dignity. My dignity was already destroyed by rape. So actually, that can reveal that the criminal proceeding and even in the prosecution, there are deeply rooted social norms that put the shame on the victims of sexual offenses. And the last one is the risk of political abuse. The secrecy as a procedure or a political tool when there are selected these leaks from the officials, police or prosecutors, or many government officials also, they can be targeted in the opposition, especially if you have some kind of election. They can shield the party power, okay, and then destroy election in this way. And this is actually the procedural battle for the political reasons outside of the court to get maybe some political advantages or procedural advantages. You influence the public opinion for the election, but also put the pressure on the court with hard results. And about remedy was already the talk, so I can only say that in the criminal proceedings we don't have really any remedy. There is no independent prosecution in most of the cases. In the case of the prosecution leaks, at least in Croatia and in many other countries, there is no oversight over the decision of the prosecution to prosecute. I think that we all should think about what about the prosecution and should there be some kind of oversight of the dropping out of the criminal reports when you don't have the victim, but the victim is the budget of the country. Or the victims are some political parties. So, and because there is no resource, we can maybe talk that this violent part of the key is right to effective remedy. And my conclusion is that the investigative secrecy that we all obviously have in our is not end in itself. It must serve to justice, so it must protect fair trial rights and investigation effectivity of the criminal proceedings. Criminal justice cannot be conducted by media, of course, or in silence, behind closed doors. Public interests exception overrides the public aspect of the presumption of innocence. And investigative journalism plays and should play a watchdog role, and the presumption of innocence should not prevent the journalists to this role. Defense and victims' rights also has to be protected, especially when they are undermined by the secrecy rules. And the risk of political abuse is real. It's not something what we think that it happened once upon a time. It's real, and secrecy and selectivity can be used to manipulate the public opinion, to pressure the courts, and to target the political opponents. Thank you for that question.
And final speech from Henrik Sørensen, representative of Southern and West. Please, Henrik, the floor is yours. Thank you. Thank you. I am an associate professor of law course at the University of Southern Denmark, but I'm also working as a judge, so I doubt and let me start with a confession. I'm a human rights violator. I have violated the presumption of innocence. There's no way to go around it. It happened. It was a quite nice day. I had turned up at the office, found some cup of coffee, found some music on very low level. I instructed my secretary not to bother me unless something really important happened. Everything was looking very, very good. It was going to be a nice day. Until the phone rang. When the phone rings, trouble comes. I answered the phone, of course, and it was the prosecutor. When the phone rings, trouble comes. When the prosecutor rings and calls you, a lot of problems, a lot of trouble will come. He told me that the police had arrested the guy. He had been shoplifting, and now they wanted to put him in custody. In Danish law, we put people in custody for 4 weeks as a standard. Nothing special is relevant to the case. And they wanted to put him in prison for 4 weeks while they were investigating this shoplifting. And I thought, well, that sounds a bit difficult because proportionality considerations could lead to something. They turned up in the garden, and it turned out that there was not only one type of shoplifting, he had something like 150 shoplifting indictments. All small shoplifting, 10, 20, 30, 50 euros, something like that. He was homeless, he had no job, he was on social welfare, but he couldn't work with the social authorities, so he was stealing because he was hungry. He was poor, he was hungry, and basically that was the crime that he was guilty. And now they wanted to put him in prison for that. And I looked at him and first I thought, well, should I put him in prison because then I at least can provide him with shelter and food for 4 weeks. But of course, prison is not for that purpose. So I decided to say no. I of course first heard the prosecutor's arguments. Then I asked this guy, should I put you in custody or what is your opinion? And he said, please don't put me in prison, Judge. Please don't. I give you my word, I promise you I will stop stealing as of right now. And of course, even though he is presumed innocent until otherwise, that was perhaps not the strongest argument, but nonetheless I decided to set him on free foot. Of course, the prosecutor appealed to the second instance, and of course the second instance, the court, second instance, the High Court, overturned me, so the police went out, found him again. It was not that difficult, he had been arrested 2 hours earlier with another shoplifting. So they came with him once again. And now, it was a bit difficult to say, no, I didn't want to put him in prison because the High Court had more or less instructed me. But of course, I hear his arguments again, and he says, I promise you, Judge, don't put me in prison. Don't, I give you my word, I will stop shoplifting right now. And, well, it started out as a quite nice day, so it was beginning to be a bit of a mind, this going to court outside. So I said to him, well, to be honest, your word don't count anymore. And then he went to prison. When I said at the office afterwards, I was thinking, well, that was perhaps not, speaking of there's limits to what the judge can say, that was perhaps not the most lucky way of putting it. So I went to the judge sitting next to me and said, well, you just got a new case, I can't do the case anymore. Which means lesson number one that day was that if you as a judge got a case that you are getting tired of, then the best way to get rid of the case is making some announcement of guilt before you get down verdict, then you hopefully will be fixed. But nevertheless, we have been talking about Article 62, there's no reason to go into that. We have Article 52.4 in the Charter, no reason to bother. Once again, we were talking about that earlier. Article 14 of the Charter is also put around. What is interesting here is, of course, the direction, because Article 4.1 says that member states shall take necessary measures to ensure that for as long as a suspect or accused person has not been proven guilty according to law, public statements made by public authorities and judicial decisions other than those of guilt could not refer to that person as being guilty, as we also heard about before. Then, of course, prosecutors and judges can say something. But Article 4.3 says that the obligation laid down not to refer to suspects or accused persons as being guilty shall not prevent public authorities from publicly disseminating information on the criminal proceedings where strictly necessary for reasons relating to the criminal investigation or to the public interest. And the basic point here is that I'm not sure that we have a full-fledged understanding of the presumption of innocence. So far until now, all day long, we've been talking about the presumption of innocence as a right for the person, the suspect, accused, the person that we might have done something wrong. It is a right not to be labeled as innocent before the verdict has been handed down. The question is, of course, whether this understanding is enough, because it's part of understanding, but there might be more to it. One of the things that might be true is, of course, the public dissemination of information on criminal procedures. Because public authorities have a need to talk about criminal cases. It's not a matter of labeling a person that they accuse of doing some crime in public as being guilty before the verdict has been handed down. But the public has a need to know that the public can rest assured that criminal offences are being investigated and prosecuted. It's not only a matter of curiosity or the need for sensation or stuff like that. As I understand, that is more a need to make sure that the public authorities is in a place where they can say, we have been informed about this or that illegal act, this violation of some law. Now we are investigating it. So citizens, rest assured, you can rest assured that we will uphold the rule of law. The state will do what needs to be done to investigate crimes so that you, citizens, can rest assured you will not be victims of further crimes because we will go and look for the person guilty. Of course, this is not just saying whether the evidence is there, but we need to make sure that public authorities can basically come down the public so that they can rest assured that the criminal offences are being prosecuted after a thorough investigation. But the directive limits this to strictly necessary reasons. So what does this mean? Well, if we go to the preamble to Recital 16, the presumption of innocence would be violated if public statements made by public authorities refer to a suspect or accused person as being guilty for as long as the person has not been proved guilty or is wrong. Such statements should not reflect the opinion that the person is guilty. We agree on that, no doubt about that. But the term public statement made by public authorities should be understood to be any statement which refers to a criminal offence and which emanates from an authority in order to criminal proceedings concerning a criminal offence, such as judicial authorities, police, and other law enforcement authorities, often another public authorities such as ministers and other public officials. It being understood that this is without prejudice to national law regarding enemies. So every time a public authority opens its mouth, makes a statement, then they have to be sure that they don't violate this. However, how can one go out in the public and say, we have, for instance, made a request, we think we got a man that has been breaking into your homes, doing whatever crime that has been talked about and legally. We have made a request, but we don't think it's guilty. That doesn't make sense. On the other hand, public authorities have a need to make sure that they can tell the people living in that neighborhood, well, come down. We think that we now have stopped the continual burden on the roads. It continues in Recital 17, saying that implication not to refer to suspects or accused persons as being guilty should not prevent public authorities from publicly disseminating information on proceedings. Well, this is important. This is strictly necessary for reasons related to the criminal investigation, such as when video material is released and the public is asked to help in identifying the alleged perpetrator of a criminal offence, or to the public interest, such as when for safety reasons information is provided to the inhabitants of an area affected by an alleged environmental crime, or when the prosecution or another country provides objective information on the state of criminal proceedings in order to prevent a public order disturbance. So the bar is set very, very high. It is basically impossible for the public authorities to say more or less anything about a criminal case before it goes to court. And if we open the newspaper, then we see that is not what's going on in real life, for good reasons, because we as a public need to learn, we need to be sure that we can trust the state will prosecute crimes. The use of such reasons should be confined to situations in which it would be reasonable and proportional, taking all issues into account. In any event, the manner and context in which information is disseminated should not create the impression that the person is guilty before he is proved guilty according to law. then it continues in number 19, that we should take appropriate measures to ensure that the person in suspect is not considered guilty before we go to court. What is the basic layout here? Well, we have articles in the ECLAN, we have the charter, we have the directive. We also have the limits set on public officials. They cannot talk about investigations, more or less. However, what is missing? What is missing is, of course, Article 10 in the Convention. We talked a little bit about it before, but I, as a citizen, also has the right to receive information. And when the public authorities is put on such a restraint on dispensing information, then that also means that I will not be given information that my neighborhood is not safe again. Of course, there's no reason to make it more stupid than we have to. There's also Article 8 that you have the right to respect for the private life. That goes especially for the person in question, that the person needs to be considered innocent. So, what is the difficulty here? We must respect the presumption of innocence when making public statements in different cases. Yeah. But as citizens also need to be able to rest assured that we investigate, while at the same time the person that is being investigated also has the need to have a respect for private life. So even though that we use the term watchdogs in relation to press and media normally, then one could also consider whether or not public authorities should be considered as watchdogs in this area. Because if we don't have them to tell us that the public can rest assured that offences are being investigated and prosecuted, then my right, according to Article 10, to receive information that basically my neighborhood is safe there, this right there would be violated. So, my problem is where is not necessarily in reasons of 18. And the question is therefore, of course, whether the pre-argument reasons of 18 to the directive restricts the possibility for public authorities to control the public about investigation and prosecution in a manner that may be in conformity with Article 10, or how citizens can rest assured that public authorities are the watchdogs that ensure the rule of law and thereby also entrust to the state, if they only can inform the public when it is strictly necessary. Thank you. Thank you very much. So we hear three very interesting presentations. Now I open the floor for discussion and questions. Please. Petra, please.
Yes, thank you. I was listening to the second part of Arthur's presentation. I wonder how would the European Court of Human Rights still make the specific provisions of Articles 14 and 16 of the Confiscation Directive, which we will probably also address tomorrow, when they provide for the confiscation of assets that derive from criminal conduct, which is an intentionally different expression from criminal offense. So the idea of Articles 14 and 16 is that you don't have to prove that some assets are derived or originate from a given offense. That's the whole idea of enlarged confiscation. And for example, take the second example. Suppose that someone is convicted because he has used some fraud, like phishing, and he has a bank account where the money is going, so people make deposits in this bank account. But in the procedure, you can only tie part of that sum to concrete offenses. So you cannot say that the whole sum in that bank account comes criminal offenses and fraud. According to Article 14, you can convict that person for fraud because you can prove that there was some offenses of fraud, and you can confiscate the whole sum or the rest of the sum if the court is persuaded that it comes from criminal activity or criminal conduct. And of course, Article 14 does not require that you make an imputation, an allegation that you committed this act. It is in your possession, but nowhere does Article 14 say that the court must make this imputation. The fact is, however, that you cannot prove the offenses from where that money comes. So you just are persuaded of that criminal origin. So I wonder, how do we assess this kind of confiscation of assets from criminal conduct in the face of the presumption of innocence? The Portuguese Constitutional Court says a slightly different provision. The Portuguese Constitutional Court has said, well, here you don't really make an imputation of facts because you are dealing you are not saying that the person got the assets from crime. You are just saying that they are in his possession, and there is a presumption in the Portuguese law. If you are convicted for some crimes, that if you have a disproportionate property in relation to your legitimate income, there is a legal presumption, a rebuttable legal presumption that this comes from criminal activity. Okay? And the Constitutional Court says this does not violate the presumption of innocence because you are not saying that that person has committed those crimes. You are just saying that that property comes from criminal activity, possibly from a third party, not necessarily from that person. I think this is debatable, and I would also like to hear your opinion, perhaps come back to court, but this point was raised by Arthur, so I think it would be nice to hear from you.
It's on. Okay. So first, when it comes to the director, I mean, since you referred the name for the Strasbourg, usually the courts of Strasbourg will also look how the Luxembourg court is interpreting it, because when you refer to Strasbourg as the director, that's what I say. So we don't have this dialogue with the Luxembourg court, when it concerns the EU law, we normally look what is either in the case law that the Luxembourg court obtained. It doesn't mean we cannot make it different, but something that has to be taken into account. But in a substance, I don't think I can give you an answer. So, to let me answer, I would say I have been more for 7 months. I personally didn't have case yet dealing with these issues. It was touched a little in Greek and but also I would say it was not the major issue of basically the way that the authorities approach the courts and expressed. So, well, that's why I'm also looking at for tomorrow. And see, you were with that also, in a way, a discussion, because I know that certainly such cases will come on my list for sure. And also, there is some case of the looking at Bulgaria. And again, you have to look how the Bulgarian system is kind of analogy to Portuguese or Latin. There is a certain case of Bulgarian cases online where the court has found violations. That's on spot here. So it's not that a concrete answer, but at this moment. Thank you. Yes, please.
Good evening, Dr. from University of Vienna. Thank you for the presentation. I'm interested in talking on Professor Ludwig and Professor Sørensen. What is your opinion about more prohibition of directly quoting of files in the case of investigative stadium or retrial stadium. If this should be more stricter, or how is it in your countries, and can this maybe also prevent, for example, to influence non-professional judges and they have to make the trial later. And I also think about you can inform the public that investigate against the law, for example, to make it safer, but you don't need to share the details of files, which sometimes happens. And I think there are different groups in the countries of the European Union, so what's your opinion on it?
I didn't really understand the beginning of the question. So what's to share what?
To share information of the files during the investigative stadium, during the pre-trial, when medias are quoted directly from files.
I think that during the investigation, if there are not specific reasons, why should you have secrets? So if there is danger of integrity of the evidence, or there is privacy issues, or there is, then I don't see any reason why the content of the investigation has to be public. The repressive measures that are undertaken during the investigation also has to be public. The question is the content of the evidence, and why it should be in the public only if there is an interest. I mean, the media is not publishing everything what is going on in all the trials. Only if there is some public interest. If there is a public interest, I don't see any reason why this shouldn't be shared. In my opinion, would not be shared here on the table. That's what I see, because the criminal proceeding is really the proceedings, the very repressive proceedings. And the criminal justice system has to also be in some kind of public oversight. If there is no overriding reason why we shouldn't share this information. Maybe you...
I think that in general, the police would be eager to keep at least some of the investigations secret, because they need to have details that nobody else than the perpetrator can know about. And also the investigation methods needs to be kept secret, so I think that there's a reasonable grounds for saying that at least some parts of the investigation have to be secret. I don't think it's necessary for the authorities to go out and explain every detail of what is going on. If the purpose of telling the public that they have made an arrest or they are now investigating in some manner, because if the basic purpose is to make sure that the public can have trust in the rule of law, then you need to look at a specific case and consider how much you need to tell the public in order to make sure that the public can rest assured that there is trust in the rule of law. We had a police officer that made an arrest years ago, something like that. And of course, a journalist then asked him, had you arrested the man that did it? And that is, of course, a bit of a difficult question to give the police officer, because if he says yes, then he has a problem. And if he says no, then the rest doesn't make any sense. So this police officer, he found a way through this question by saying, I think that we have arrested the right person. And that obviously makes it very clear that we may have the presumption of innocence as a guarantee for not being put on the front page as the person guilty before the case is presented in court. That is of course relevant. However, we need to have some way to make sure that the presumption of innocence can be upheld, while we also talk about the specific things that goes on in criminal cases, because the public needs to know that the presumption of innocence also means that we will not consider everybody innocent from morning till night. We will investigate whether there is people that needs to be brought to justice in front of the judge. So basically, what you you're asking for is some kind of way of saying that we have suspicion, and that suspicion is not the same as guilt, but we have a suspicion, and now we investigate whether or not this suspicion can be backed up by evidence that we can present in court. If not, then we will have to let it go. If we can find evidence, then we will present it in court and charge. So we need this, we need a way to handle this grey area.
Yes. Just as one addition, let's emphasize exactly you're also asking transgender in that as a system, and essentially where transgender cases is why it's considered serious or pre-value investigation that's so important for the integrity of the trial, fair trial rights, no presumption of innocence, and also in that case there's no overriding public interest.
So, on the right as a moderator, I want to say thank you for all speakers. And to finish this last session. So, Christina, your instructions for the nearest future.
Yes, thank you, and Moses, for our guests, all with the last presentation. And for me, I feel like I have to say something, or some words at this moment. Something very important, yes. But it's a very late thing that my mind is always aware of ChatGPT. Namely, Monday, my favorite character to write some words, and here it is. We are reached the end of today's agenda. Thank you all for showing up, turning in, and staying conscious. Your presence, questions, and polite nodding have been deeply appreciated. We look forward to seeing you again tomorrow, ideally caffeinated, slightly more awake, and ready to dive in increase fresh energy, or at least the illusion of it. So, anyone, representatives and speakers, please don't forget about the bus waiting for you. So we all meet in the ballroom, 6:30 or 55. But before we wrap up completely, for those interested, and now that at least one person is interested, there will be a very brief and spontaneous tour to the Faculty of Law. So if you would like, or also other, not only one person, please join us, and then we meet in the cloakroom, as I said, 6:30 or 6:30. Thank you.
Day of this conference. Thank you again also for the organizers. Also with this lovely reception yesterday evening in the other side of the city. This second part of the conference, the entire morning, we will dedicate ourselves to the topic whether and to which extent the presumption of innocence is applicable in subject matter of confiscation of criminal assets. This is especially also for my German friends, very interested and very much eager to learn. Therefore, in the next lectures, because in Germany we have a long discussion whether and to which extent criminal law, criminal procedure principles, such as the presumption of innocence, are applicable for confiscation. We have been a long discussion whether confiscation, which has been named in Germany with the odd name Verfall, which is not transparentable, is even a penalty. So whether the presumption of innocence applies. And the Germans have also been very reluctant to observe, as regards non-conviction-based confiscation, which is a very alien element. We have to deal with it because we have to transpose implement the EU directives. So from this point of view, I'm very much looking forward to the next session. I will briefly, or I will introduce the speakers subsequently, also 20 minutes breaks. We have 1 hour 15 minutes, including discussion, so 1 hour for the presentation, so I kindly ask speakers to hold their limit of 20 minutes, and I will give you a sign 2 minutes before the end of your time. First speaker is Vaisamis Villegas. All speakers, I would say, are very distinguished criminal lawyers, all also with leading positions in our ECLAN network. And I wonder whether I used to present Vaisamis, but I will do. He's a very distinguished, renowned lawyer in European and international criminal law. He's professor of European and global law and dean of the School of Law and Social Justice at the University of Liverpool. And he's author of numerous publications in European criminal law and also immigration, asylum, and borders, and he's part of also numerous networks and policy groups, and he was one of the leading persons who shaped European policy in the last years. So, you will deal with the topic going after the money towards a criminal law without limits. So, we will setting the scene, also diving a little bit into the new framework of mutual recognition of confiscation orders, and the floor is yours.
No, you can see me here. Thank you very much, Thomas, for this very kind introduction. Good morning to everybody. A big thank you to our organizers here. Well started as a Bernard, thinking of this wonderful conference. It's really a highlight of the ECLAN life, and it shows that the strength of our networks. It's really great to be here with colleagues working in this area. I didn't say how many years we've been working on European criminal law, but also meeting new colleagues and really discussing these issues. So what I want to do is really set the scene and look at how a European criminal law financial crime has been evolving and trying to link it to the conference topic of presumption of innocence by trying to show a number of instances whereby criminalization departs from the requirement of a criminal conviction. So, you know, the reach of the criminal law is disconnected, actually, with the requirement of a criminal conviction. And this has been a trend that has been an evolutionary trend in law as it develops in the context of an interrelation with international and global law in the field, where we have increasing demands to be more effective, if you like, in brackets, in the fight against serious and organized crime. And I will mention 3 dimensions, if you like, of this trend of departing from the requirement of criminal conviction. I will discuss the evolution of the criminal law on money laundering first. Then I will say a few words about substantive, if you like, confiscation. I'm not going to use the language of my wonderful friend and colleagues. We have, you know, distinct presentations in the field, and as Thomas said, you know, confiscation is still a mystery. We don't really know what it is, whether there is a criminal sanction. And I wonder towards the end of today whether we will agree or disagree about whether the principle of presumption of innocence is applicable to confiscation or not. You know, this is a very light discussion, I think, and quite divergent views. And then I want to say something about how the penal sphere is expanding the EU through the use of the principle of mutual recognition in confiscation orders, because there we have a situation whereby we aim at maximum recognition without really a very high degree of harmonization of the law, and as we were saying, diversity as to how to view confiscation. So these are the 3 things I would like to do. And I will start first of all with money laundering. And with money laundering, it is a very as you know, how the global anti-money laundering procedure started in the 80s and the early 90s. We had the creation of new criminal offense on money laundering, but linked very tightly with the process of specific criminal offenses. So, you know, remember the Vienna Convention of 1988, of the UN Convention on drug trafficking, and we started from the criminalization of the laundering of the process of drug trafficking. So, you know, so we have a very specific link between money laundering and the predicate. Money laundering is there to punish in a sense the predicate. So, you know, it is independent really on the predicate offense. Over time, we have seen a severance of the link between money laundering and the predicate offense. We see the criminal law of money laundering justified on the basis of serving different, if you like, legal interests or objectives from the legal interests protected by the predicate offense. And why is that? It is, especially in the legal order, this has been justified by the fact that criminal law money laundering is perceived, I should say, in order A, to protect the financial markets, and B, to protect security. The security in a broader sense than the interests served by the criminalization of the predicate offense. So, you know, so this has led to three developments which I think are worth mentioning. The first development is the move from specific predicate offenses to an all crimes money laundering basis. So, you know, I call it in the I've just finished the banalization, if you like, of the predicate offense. So, you know, so currently internationalism is increasingly requires states to criminalize money laundering irrespective of the predicate, or whether it's serious or not, or whether it's a specific offense or not. The second premise at the heart of my argument is really a very specific severance of the link between criminalization of money laundering and the conviction for the predicate offense. I do not have, I don't use part of the vocabulary. I wish I could use it because, you know, read out from you the 2008 directive on money laundering through criminal law, where the directive was for a money laundering conviction to be possible when it is established that the property was derived from a criminal activity without being necessary to establish all the factual elements of all circumstances related to that criminal activity, including the identity of the perpetrator. And the preamble states that the conviction should be possible without it being necessary to establish precisely which criminal activity generated the property, or for there to be a prior simultaneous conviction for the criminal activity while taking into account all relevant circumstances and evidence. So you can see here that we move to the system of expansion of criminal law, whereby you can convict for money laundering even if you don't know who the perpetrator of the predicate offense is. And we can discuss the meaning here for the presumption of innocence, in a sense, you know, and whether it's relevant or whether we can live in a world where, you know, we can totally distinguish between the predicate offenses and the money laundering offenses. And this is also evident in a parallel other trend that we see in international and European law on money laundering, which is the acceptance of the criminalization of self-laundering, which means that you can be convicted for the predicate, but you can be convicted separately for money laundering. And again, you know, in a number of domestic jurisdictions, you know, this was not accepted at the beginning, and even today, perhaps we can discuss, when they said that, okay, once you have a conviction for the predicate, the purpose of the prosecution has been served. So, you know, you don't need to be convicted for money laundering because, you know, you have one after the predicate offense. But this is no longer the case, and the legislative directive calls upon member states to criminalize explicitly self-laundering, and the Court of Justice, in the case of concerning the previous iteration of the law, said that self-laundering is justified in the law because the legal interest protected there is different than the one of the predicate offenses. The legal interest is the protection of the financial system. So, you know, so again, we have really the treatment of money laundering criminal law is increasingly separated, if you like, from the treatment of the criminal law of the predicate offense. And we can discuss what this means for the expansion, if you like, of the limits of criminal law. In terms of confiscation now, so in terms of confiscation, you know, the EU has been grappling for a long time to reach a level of adequate harmonization, and one is not, because as long as we have a lot of diversity, I think, in member states about what is accepted in terms of the state's power to confiscate property. I remind you something that we take for granted, the confiscation is quite an extensive, has quite an extensive impact on the position of the individual. You know, it involves the final kind of deprivation of property, and it brings into the fore a number of fundamental rights, such as the right, but also the right to property. So we have very good diversity in national systems in Europe, and we have had an ongoing effort, if you like, in the European Union to level the playing field. We have had 3 attempts towards harmonization, and in every single attempt that was followed by critique that the law is not enough. The latest one that we have is the 2024 directive. I'm sure as we talk about the implementations. But what this directive does is that it extends confiscation, it disassociates confiscation from a criminal conviction in 4 main ways. It provides for non-conviction-based confiscation, it provides for third-party confiscation, so you can confiscate the property of the third person, not the person who is involved. It provides for extended confiscation, and I'll come back to that. And for the first time, it provides for a formal unexplained wealth, or the EU style, in the field of unexplained wealth. So I will focus a bit on extended confiscation and a bit on unexplained wealth for the purpose of presentation, which we will hear more in the further presentations. So extended confiscation. Member states must provide for extended confiscation where belonging to a person convicted of a criminal offence, where the offence committed is likely to give rise directly or indirectly to economic benefit, and where a national court is satisfied that the property is derived from criminal conduct. The preamble to the expressly states that individual criminal offences do not have to be proven, that the relevant criminal conduct will consist of any type of offence. So you see here, although you need to have a criminal conviction, the criminal conviction is not directly related to the confiscated proceeds. So again, you have a severance of this game. Then we go to unexplained wealth, which is the innovation, if you like, and the unexplained wealth. I don't talk about this in detail, but just to draw your attention, so the confiscation of property identified in the context of an investigation in relation to criminal offence. Confiscated property which has been identified in one criminal conviction, or even before the conviction, actually. And when the national court is satisfied that the property is derived from criminal conduct committed within the framework of a criminal organization, and that conduct is likely to give rise directly to substantial economic benefit. So here, I think it will limits the harmonization in terms of the requirement of a legal organized crime and with the financial benefit. Some states get a broader confiscation regime, but I think here again we have a very clear move towards associated with confiscation from a criminal conviction. In some countries, including the UK, this is that kind of simple or other one. That's another question I think we can discuss. But for the purpose of criminal law, this is really another expansion of the criminal sphere. A very brief, because I'm conscious of time, mention also something we can discuss is whether these forms of confiscation, which are identified in the 2024 directive as expanded, meet the requirements of legal competence in criminal matters, or not the question about whether this is a sanction, the question of whether under Article 83 some of these forms are really criminal sanctions applied or that was in the past. So this is really a big question. The third aspect I want to talk about is the aspect of mutual recognition. So in mutual recognition in the European Union, we have a avant-garde instrument in confiscation because it takes the form of a regulation. The regulation, the institution of confiscation orders, and the regulation was adopted because it was felt that in spite of its legal diversity, it would just need some uniformity as to judicial cooperation with criminal. And this now we have very big issues here because we still have a limited harmonization of the playing field on the one hand, and we have situations whereby confiscation proceedings in one member state may be not allowed or even unconstitutional in one member state. And we have national confiscation proceedings which may be parallel proceedings or hybrid proceedings, which we are not sure whether the definition example, and I understand corrected by a number of colleagues in the audience who are much more expert than me on this, is the Italian system of preventive confiscation, which is not, which is a system that has some criminal justice elements, but it's not really directly within the criminal justice field. And Italy is actually lobbying, is always lobbying for expansion of the confiscation law, but also expansion of the scope of judicial cooperation. So what Italy achieved in the text of the mutual recognition instrument is to say that the applicability of the mutual recognition instrument will be within the framework of proceedings in criminal matters. So the elephant that we here that we need to discuss is how do we understand the concept of proceedings in criminal matters for the purpose of the application of this legislation. The text itself, and that was very interesting to me to read because we've both written about it. The text itself says that this concept is an autonomous concept of EU law. Most importantly, the directive itself, the regulation itself states that this concept is different from the concept of criminal matters in the European Court of Human Rights. And we know that the European Court of Human Rights, for all its inconsistencies, has said in many, many large cases that it do not fall within the court's definition of criminal law. That these are national civil proceedings, preventive proceedings, and a number of Italian preventive confiscation proceedings. The court said the third trial does not apply because the criminal law sector does not apply to the third trial because this is not criminal law. So here we have EU law that says no, our approach will be different. We will have a broader context of criminal law in order to be more inclusive, and we will see how this will work. If Italian colleagues and my dear friend and Rosaria's colleague Anna Maria Rogeri has argued that it is enough in the national proceedings to meet some criminal justice safeguards, even if they are not criminal under national law, for the resulting confiscation orders to be included with the mutual recognition system. But I'm not sure about that, because in that way, you extend European criminal law to include orders which are not criminal under the national. And I think it's a question really about how an executive authority which receives a confiscation order which would not be allowed under its own domestic criminal system, whether it would be applied to execute. And I think we have really the real prospect of double standard situation. We see a situation where the member states will not change their domestic law, so they will more limited, but they will execute orders from other member states which would not necessarily be compatible with their own domestic law. This is also in contrast to the European investigation order system, so it's very interesting incoherence in Europe here. The final point I want to make before I close on mutual recognition is that we have an interesting relationship between mutual recognition and harmonization. So you know, mutual recognition is broader than even the 2024 directive. But the Court of Justice itself, in a very interesting chapter called 1B, said that parallel proceedings, which can be criminal proceedings also, but which not exactly defined for guilt or innocence, do not fall into confiscation laws. So you know, so the court is saying that this is not only criminal law, it is something else. And the court is also saying that the harmonizing instruments are essential for the functioning of mutual recognition in negotiation orders. Yet the mutual recognition instrument, which is much broader, if you like, than the accepted harmonization in the field. So this is another example of issue where we can lack of clarity and the potential reach overreach of the law, and we have a very big question again for that almost what is criminal and what is not. Thank you for your attention to the forward of the presentation.
Thank you very much. I think I'm really astonished that this is really perfect. And also thank you very much for giving us insight into the trends that we have currently in European law and European law policy, both as regards money laundering and confiscation, as well as mutual recognition of confiscation. And also the second speaker speaker is Nico Paniero. Also here I think I do not need to use a lot of words for him because he's also a very renowned scholar in European criminal law and international criminal law. He's associate professor in the subject matter at the Faculty of Law at the renowned University of Coimbra in Portugal. He's also specialist in specific matters of European and international criminal law, such as judicial cooperation, etc. He has also been lead expert for the counselor for the government, if I rightly understood that. And he's also currently a member or leading the working group of the Portuguese Ministry of Justice in dealing with implementation of new criminal law policy, including the new directive 2024 on confiscation. So, really expert for this topic, and he will talk about the criminal conduct doesn't pay, the new responses to illicit and justified enrichment under criminal law. So, Peter, the floor is yours.
Thank you very much, Thomas, for this very nice presentation. I would like to start by thanking Christina Stratosberg for the invitation, especially for the fantastic organization of the conference, the high level of high quality of all presentations. It's actually been, I think, maybe in 2004, when ECLAN was founded, I don't know about either, but I certainly did not expect to be speaking in Riga in 2025. So thank you for all your effort and also your team. Well, I would like to bring the panel. I think it was Epicurus who said, when you are among friends, it's like being with God. And so the divine presence is also here in the ECLAN context. And I will now proceed with my presentation. There's a short summary here. I will try to understand and to analyze how the EU is trying to respond to the so-called dirty money or illicit enrichment. There is a peculiar history in Portugal regarding this matter because the Portuguese legislature has twice tried to criminalize unjust enrichment, and the two times the Constitutional Court has struck down the laws because they were against the Constitution, so in 2012 and 2015. Now we will see an instance where the EU legislature is trying to push again for this crime. I will start by everything goes back to the confiscation of crime proceeds. This is the first piece of the puzzle. Then we will go through some difficulties, some obstacles that jeopardize confiscation, which explains the mechanics of other institutions such as money laundering, and then again unjustified enrichment. And I will also try to draw your attention to this shift from what has already explained a bit, explained extensively. This in regard to money laundering, I will focus more on confiscation and unjustified enrichment, but how we are shifting from crime proceeds to unjustified wealth, and how the criminal offense is becoming a sort of ghost, a spectre. It's not there anymore, but you still invoke it for several purposes, namely for granting the competence of the EU to legislate thereupon. Also to justify some aggressive mechanisms and aggressive investigative techniques, but the criminal offense as such has basically disappeared from the horizon, and you have the name but you don't have the thing anyway. And then I will go to some questions, not really conclusions, because I think we are still very far from drawing conclusions. So, as I said, everything starts with confiscation, which is the first element. in this modern trends of the almost greedy state that wants to grab every kind of dirty money can lay his hands on. And of course, when we have profitable offenses that generate assets like every kind of trafficking, racketeering, and so on, and you have this, what does the state do regarding those offenses? He punishes the offender. Everybody knows, pursuing the aims of general and special prevention, retribution, and so on. But the state also wants to confiscate the proceeds from these profitable offenses. Why is that? Why do we confiscate the proceeds? In the first place, to give them back to their legitimate owners in case they are any. So we are applying private law here. But also to enhance this moral principle, crime cannot pay. And so by that principle, we want to prevent the pursuits of illicit profit, so inhibit future offenders, and also reinstate the legitimate property order. Well, this is very straightforward and very simple to understand, but the problem is that several obstacles can arise concerning this confiscation of crime proceeds. Now I will try to guide you through a journey of how these obstacles appear and what the state does to try to avoid them. In the first place, the offenders, the first thing they do is try to conceal or dissimulate crime proceeds so that they are not confiscated. No problem, the state comes with a money laundering prevention system, the so-called AML regulatory system, and imposes a series of duties to designated entities to prevent money laundering. So the idea is that money laundering does not succeed when you have these duties and when you implement appropriately those duties. In principle, money laundering should not happen. But if those duties are not enough, then you can criminalize money laundering, and you are protecting. And here, I do not fully agree with the view that you are protecting the financial system in this moment. I think you are protecting the state's claim to confiscation. So when someone dissimulates or conceals stolen assets or trafficking assets, what he's doing is avoiding confiscation, so he's avoiding a measure by the state. So when you criminalize money laundering, you are protecting the criminal justice system, which in fact, as Peter Aldrich has explained very appropriately, is autonomous from the regulatory system. You can have one, not have the other. There are two separate pillars. In second place, it can be difficult to prove all the elements and the features of the predicate offense. When did it happen, where did it happen, whether the offender was guilty or not. Probably we don't even know who the offender was, as Alessandro was also saying. No problem. We adopt the criminalization of money laundering, the crime of money laundering, and it's okay if you just prove that the assets come from an unlawful criminal act. Even if you cannot prove guilt, if you cannot prove that the fact is punishable, it's okay if you prove that there is a criminal act. Third obstacle, you can convict someone for some offense, but you cannot prove that other assets that he has in his possession, or even his own estate, come from that or any other criminal offense. So you are persuaded somehow that those assets are dirty, but you cannot prove a link between the offense for which you convict the offender and the assets. And that's why we have now extended confiscation under Article 14. I think Catalina will also address that. Or in Portuguese law, confiscation of unexplained wealth, which is a bit different mechanism. Article 14 relates to specific assets, a car, a house, and so on. In Portuguese law, it's a sum, it's a value. So they calculate how much is the estate of the person worth, and then there is a legal presumption that this value comes from crime if it exceeds the legitimate income of the offender, and it's confiscated unless it proves otherwise. The fourth obstacle, sometimes criminal proceedings terminate prematurely because the offender dies or because there are time bars or amnesties. Well, no problem. We can make criminal proceedings continue in some countries, like it's the case in Portugal now. So you have criminal proceedings against a dead person, which is quite bizarre, I would say. Or you can have separate autonomous proceedings, like it's the case in Germany and in Spain. I think Catherine will also address that in her presentation. Finally, you have no conviction and you have no evidence that the property derives from criminal offense, so you basically have nothing. And then, for these cases, you have civil recovery in some countries, but I can explain about borders. You can also have confiscation provided for in Article 16 of the directive, and this is for property derived from criminal conduct, not an offense. The directive is very precise in that respect. When it's in Article 12, for classic confiscation, they refer to criminal offense, and here is criminal conduct. And last resort mechanism, you can criminalize unjustified enrichment. So, let's do this same journey from another perspective. I showed you the obstacles that can arise against confiscation. Now let's look at the same problem, but from a different perspective, focusing on how the criminal offense is disappearing from the scene and how we go from crime proceeds to unjustified wealth. If you look at the original position, the original stance, you have a crime for which someone is convicted in a criminal procedure, and of course confiscation comes as a natural penal sanction together with the penalty that applies to that person. That's the original goal, that's the starting point. Then, with money laundering and so on and confiscation, you come to a second stage where you don't have to prove the crime with all the features that the crime implies. It's okay if you prove a criminal offense, which is already a particular form of crime, because you just have to prove, as the Germans would say, Tatbestandsmäßig, and there has to be that. So it's okay if you prove that it's an act described by criminal law and it's illicit, it's unlawful. In that case, you can confiscate the assets via criminal procedure. For example, if the person acts without guilt in the criminal procedure, they can acquit the person because he's not guilty, he is not culpable, but still you can confiscate the assets, or you can have an autonomous procedure, civil or administrative. In that case, you come to what's called non-conviction-based confiscation, right? Non-conviction-based confiscation, because the confiscation is not tied to a conviction of property. That's the same concept, criminal offense is the same concept that we use for money laundering to characterize predicates of offenses. And if you go to the 2018 directive, you see that although money laundering is, the offense of money laundering refers to criminal activity, then criminal activity or criminal conduct, I don't know, it's defined by going back to the specific offenses designated in Article 2, if I'm not wrong, or offenses punishable with some kind of penalty. So it's not a broad concept of criminal activity in general, it's a criminal activity that is defined regarding the offense or applicable penalties. Then, the third stage are the proceeds derived from criminal conduct, which can be accounted by convict or third parties, and not necessarily an actual criminal offense. The requirement here is that you are convicted for certain offenses, a catalog of offenses in Article 14 of the directive, and this is the first instance of what I call non-offense-based confiscation. This is different from non-conviction-based confiscation. Here, confiscation is not based on a criminal act, an unlawful criminal act. This is based on criminal conduct, and you see as how the criminal offense concept is going away. If this criminal conduct is committed within the framework of a criminal organization, you don't even need conviction. It's enough that you have an investigation for certain offenses, according to Article 16 of the directive. So why do we need an investigation at all here? Because the EU needs competence to legislate their requirement. Otherwise, the EU could not have Article 16 in the directive because it will not be a criminal matter. So the least that you can have is an investigation for certain offences, and this is the second instance of non-offence-based confiscation. Finally, we have this unexplained wealth confiscation when the wealth is disproportionate to legitimate income. It's spoken in Portuguese law. I told you there's a rebuttable presumption that this wealth that derives from criminal conduct. It doesn't have to be the contents, so it can be criminal conduct by other people, unknown people, but the assets are in possession of the content. And so you have again non-offence-based confiscation. Finally, we have no offence, no criminal conduct, but the property is inconsistent with legitimate income, and the person cannot justify that property, and so we come to the criminalization of unexplained or unjustified wealth. There are three explanations or three justifications for the criminalization of unjustified wealth. First, suspicion of offences in the past. And here is where the Constitutional Court in Portugal said this cannot be done because it's against the presumption of innocence, it's obvious. Secondly, you can criminalize unjustified wealth on the basis that you cannot justify the wealth, so it's a state. You cannot justify what you have, so it's unjustified state of wealth. And third, you can also justify it on the basis of false or immediate declaration of an increase in assets when there is an extra criminal law duty to declare to the authorities your assets. In the last two cases, we can raise the question of whether it's possible to confiscate not the proceeds, but the objects of the offense, because these assets of unjustified wealth are not crime proceeds. They are the object of the offense. And so can we confiscate that? And apparently this is where the EU is also going. If you look at the Directive on Union restrictive measures, Article 10.2 allows for confiscating the economic assets that have been frozen in case of violation of restrictive measures. I will come to my last slide before the questions. And it's about Article 13 of the proposal for a directive on combating corruption. This is where the EU comes closer to criminalizing unjustified enrichment. Here you have the three proposals from the Commission, the Parliament, and the Council. The stand is 29 January 2025. They are quite different one from the other. I will not bother you with the details, but I will try to explain in what they are identical and what they are different. In all cases, what's the same identical in all proposals is that they conceive of unjustified enrichment as a special status offense, so pflichtgebiet. It means that it is required that the agent, the perpetrator, is a public official, which is also a proper definition under Article 2, 3 to 5, number 5 of the directive. The second aspect in which they are identical is that the property must derive from certain offences, the corruption offences set out in the directive. And here there is a big difference between Article 13 and Article 16 of the proposal, because in all the proposals here, you can see that the property has to derive from the commission of any of the offences, so there must be a link. But if you read Article 16, they say something like, this is inspired by money laundering law, and you don't really have to prove basically anything. And this is a stark
contrast, stark contradiction between what's in the recitals and what's in the article. What is different between the several proposals? In the Commission's proposal, the perpetrator of this offence, they also have committed the predicate offence. In the Parliament's proposal, the emphasis is put on disproportionate and unjustified wealth, which is not present in the other proposals. And finally, in the Council's proposal, the predicate offence must have been committed by another public official. This raises a lot of questions. In the first place, concerning the Commission's proposal, when they refer to the same agents, so someone who commits a corruption crime and uses or possesses the assets coming from this corruption crime, this is a crime under this proposal, but this is not consistent with Article 3, number 5 of the Directive on Money Laundering, because this article of the directive allows member states to exempt from punishment self-laundering in the case of use or possession of assets. So this is inconsistent with the Directive on Money Laundering. If it's a different agent, then we have the same objections or remarks that I will refer concerning the Council's proposal. Concerning the Parliament's proposal, they rely on difficult to understand accumulation of disproportionate wealth and criminal origin. It's not understandable because when you refer to disproportionate wealth, then you don't have to prove criminal origin. That's a way of circumventing the need to prove criminal origin. So why do you require both disproportionate wealth and where such properties derived from the commission of offences and public directive? This is not compatible. The second place, you have here an offence of mere status or condition, which is not very good according to the prevailing literature. You're punished because of a state, a situation, not because of an act or an omission. And it also implies that any public official has at any given moment the duty to justify his properties or her property. Finally, concerning the Council's proposal, this is not really what the Council means. It's not really a crime of enrichment or unjust enrichment. It's basically receiving unlawful property. It's like receiving stolen goods, but not stolen assets from corruption offences. So this is not really an enrichment thing. It's not a money laundering offence because there is no intent to conceal or disguise the assets, and therefore I don't understand why you need a special status offence. Why does this offence have to be committed by a public official? Anyone who receives money from corruption could be a perpetrator of this crime. So I come to the last slide, and I'm a bit late, but I will conclude in a minute. As I said, I don't really have many conclusions, but I have a lot of questions. What is the impact of this shifting and replacing the offence with a spectre that goes with something, a suspicion, a part of the offence, criminal conduct? In confiscation law, the question is, what then do you have to prove as regards criminal conduct for Articles 14 and 16? How is it different from proving a criminal offence? Does this difference affect the object of proof, as we were discussing yesterday, or the standard of the proof, or both? In terms of criminal procedure, does this appropriation of criminal procedure to the purpose of confiscating assets, does it not raise constitutional issues? Criminal procedure is meant to establish whether or not someone has committed a crime and be punished for that. Can we use unlimitedly, unboundedly, can we use criminal procedure to confiscate assets which do not even generate from a criminal offence, a proven criminal offence? This is a very difficult question concerning the law on money laundering.
If the reason to criminalize money laundering is to protect the state's claim, the confiscation, should we broaden the offense of money laundering also to include assets that do not derive from offenses, but from criminal conduct, which you don't know what it is, because it's something that is prone to be confiscated. So should we also, as Pascal was saying, severing the link with the criminal, the predicate offense should be also including money laundering, criminal conduct, even if we don't know exactly what that means. Finally, concerning unjustified enrichment, if we rely on the unproven past offenses, this is against presumption of innocence. It's also notorious and clear how the European legislator is disoriented as to the model to be implemented. You have three very different proposals on the table. They don't even talk with each other, these proposals. Some of them are not enrichment offenses in any case. Again, when you use the state of unjustified wealth, the situation of unjustified wealth, is it okay to use criminal law in order to just restore or reinstate the legitimate order of property ownership? Finally, if unjust enrichment is meant to punish false declarations or omissions or disobedience, do we need a different offense? Do we need to have this kind of enrichment offenses, or is it enough to rely on the existing false declarations that every member state has? Thank you very much for your time. I'm sorry.
Thank you very much, Pedro. Thank you also very much for guiding us through this very complex system of confiscation and the different scenarios, and also showing the shiftings from criminal law to whatever. This is a question. Last but not least, speaker in this panel is Professor Caroline Ligeti. Also here, I think most of you know her. She's a very active and vigilant scholar in European criminal law, and having carried out a lot of studies and research which has shaped the European criminal law policy, including the European Public Prosecutor's Office. She's also coordinator of ECLAN, Fulbright of European and International Criminal Law at the University of Luxembourg. She's also currently researching a lot of interesting current topics like the use of information technology, which is like AI in criminal proceedings. She does a lot of comparative criminal procedure law, and she's also an expert in economic and financial crime. This leads us to our topic today, a very interesting question about the presumption of innocence and, as we heard, non-conviction-based confiscation in EU law.
Thank you very much, Thomas. Good morning to all of you. Thank you very much to Christina for the organization of this wonderful conference. Indeed, I shall talk about non-conviction-based confiscation, and I would like to start with an example. It's a judgment which is handed down this year in Luxembourg. It concerns a major corruption case. It's called the Taiwanese fregat case, and maybe because it impacted at least France and Switzerland, some of the colleagues might be aware of the facts of the case. I will be very short on the facts. It's about buying arms, in this case fragats, for the Taiwanese army, and in order to ensure that the Taiwanese, or convince the Taiwanese government to buy French military equipment, France paid a quite considerable amount to the Taiwanese officials, public officials. We are talking about billions of US dollars in 1991. This is important. So later on, it has been prosecuted in Taiwan as corruption, but Mr. Wang, who was the main culprit in the case, died during the proceedings. Those days, Taiwan did not have non-conviction-based confiscation. The suspect, the accused person, died during the proceedings, so the question was how to get back the money. And later on that case, Taiwan passed down legislation allowing, according to the German model, non-conviction-based confiscation. Also in the hope, in brackets, that this will be a sort of standard for non-conviction-based confiscation, which is in line with the Western, if I may put it that way, concept of non-conviction-based confiscation, allowing Taiwan to actually have mutual legal assistance and executors executed in a number of countries. And as you see on the title of this newspaper ad that I just copied here, there was an agreement. France paid considerable amounts back to Taiwan, the same for Switzerland. There was money still in Liechtenstein. Liechtenstein also agreed with the Taiwanese, and the end of the chain, 2024, came to Luxembourg. So it was a Taiwanese request for an executor, non-conviction-based confiscation, related to this corruption offense. We are talking about considerable amounts, and this was still before Luxembourg's implementation of the asset recovery regulation, but as we have heard already from Balsamis, the 2014 directive allows for certain forms of non-conviction-based confiscation, which Luxembourg implemented. So, the defense brought up a number of points that maybe, looking back so much in time, we could have a problem with retroactivity, if we consider that confiscation is a punishment. We might also have an issue with presumption of innocence, because clearly the suspect has never been sanctioned. So the overall conclusion, and I put the judgment number, yeah, I think it's an interesting one if you follow French, said that, well, retroactivity is not a problem for non-conviction-based confiscation, presumption of innocence is not a problem for non-conviction-based confiscation, but we allow under Luxembourgish law non-conviction-based confiscation only for assets which derive from money laundering. Here it was corruption, so no execution of the executor, leading to a situation that Luxembourg is actually the only jurisdiction who did not return any assets to Taiwan. So what do we learn from this? For everything that I'm going to say later on, we had a lot of technicalities around non-conviction-based confiscation, and clearly tension between this concept with a number of fundamental principles like non-retroactivity, but also with the presumption of innocence. What I will do now in my remaining time is actually give a bit of the context of non-conviction-based confiscation, and very briefly, because Balsamis and Pedro has already highlighted to us the EU legal framework. And I will then look briefly into the case law of the European Court of Human Rights, because the Luxembourg Court has not yet really moved specifically on this aspect, but the European Court of Human Rights of Strasbourg has a number of, I would say, not necessarily easily interpretable case law, and see whether this helps us really to place this new enforcement instrument into the setting of EU law. Non-conviction-based confiscation represents, I would say, the third generation of confiscation measures along the line that we have already heard. Crime should not pay. No conviction is required, and therefore we can do away or lessen certain procedural rules, including the standard of proof, and we had a lot of discussion on the standard of proof yesterday. It rests basically upon the principle that the owner should not be able to keep the property because the property has a tainted and unlawful origin, and in that sense, it's argued that non-conviction-based confiscation has essentially a preventive objective. It wants to prevent the property owners to actually enjoy that property. Increasingly, and I put on the slide a number of cases, there are more actually from the Strasbourg court, which also shows that there is also a restorative aim, as Pedro has already highlighted in his presentation, associated with this form of confiscation. Now, if you think about the example of the Luxembourg judgment, I think we can ask ourselves if it's really only preventive and restorative, or whether there is an element of punishment in it, and I leave it open. Essentially, when we look at non-conviction-based confiscation, the jurisprudence as well as a scholarly writing, I would say in German there is a Kulturkampf, it's a clash of cultures around how we see non-conviction-based confiscation, and Thomas Wahl in his introduction already, I think, alluded in that direction. So there is one let's say, set of arguments which says this is essentially alien in the system of criminal justice. This is an element of bringing in to criminal justice instruments which aim prevention, preemption, very far from the liberal criminal justice model, and will lead us to an authoritarian state. On the other, let's say, end of the spectrum, and I quote my dear colleague Frank Meyer, I think is the opinion, and I think what he wrote is very nice, and I quote it, it is essential that we underline the criminal economic dimension as well as the symbolic significance of confiscation. It is especially in academia that we rest comfortably in the comfort of the rule of law. We congratulate ourselves for our referencing of Sharia, and we caution against the return of an authoritarian state. But by doing all this, we simply refrain from making constructive contributions to overcoming the realities of modern crime. Of course, it's not alone with this statement, but I think it shows the other end of the spectrum. Essentially, the first scholars believe, and I reference back to what Stefan Braun said at the beginning of our conference, that confiscation and presumption of innocence is sort of a seismograph of freedom. So we are in the first group afraid of the authoritarian state, and in the second group of opinions more afraid that criminals may keep their proceeds and enjoy them even if they are unlawful. So where does the EU stay in that debate? I will not go in detail because this has been already mentioned, how the legislative framework evolved, and indeed this has been, let's say, a long road to find a common framework in the EU. First we had a framework decision, later on the 2014 directive. What I think is interesting in the case of the Luxembourg court is that it clearly said that certain models of non-conviction-based confiscation, especially cases related to Bulgaria, the court was very clear. These are civil asset forfeiture systems, so civil systems fall outside the scope of the non-conviction-based confiscation regime of the EU. The 2014 directive, there was a long negotiation on how to formulate non-conviction-based confiscation. You see on the slide on the element, so there must be criminal proceedings against a person. It allows only for a limited number of scenarios of non-conviction-based confiscation if there is an illness or absconding of the suspect. And what is very important, and I will a little bit go into the details of it, the evidentiary standard is a full proof of the crime. It's a criminal standard. The directive says, in the absence of illness or absconding, such proceedings could have led to a criminal conviction if the suspect or accused person had been able to stand trial. Now, this has led in national implementations to very different approaches. We have non-conviction-based confiscation within the scope of criminal proceedings, like in Germany. There was also a very long discussion, as Thomas Wahl has mentioned, in Germany, and eventually the Bundestag said it has to be within the framework of criminal proceedings. We have, on the other edge, the more common law, civil forfeiture model, but this is not only in common law countries, it's also in Bulgaria, where these are civil or administrative law measures, so they are not issued within the confiscation order, is not issued within the framework of proceedings in criminal matters, so therefore outside the scope of EU law. And then we have the hybrid models. I would say that Italy, at least one form of confiscation in Italy, would fall into this hybrid model, and this hybrid model then generates a lot of jurisprudence in front of the Strasbourg court. Now, given this diversity, as Alexander has already mentioned, the EU in 2024 made a second attempt to level the playing field and actually extended the cases where non-conviction-based confiscation can be ordered, and from illness and absconding, now we have also death and statutory limitation as cases. But what is very important, the standard of proof still remains a proof of the crime. Now, the question is how to apply this standard of proof for a measure which is non-conviction based. And this is where we find a lot of case law of the Strasbourg court. To contextualize this case law, I would like to come back very briefly to the interpretation of the court of the principle of the presumption of innocence. The court was, the Strasbourg court has a very large case law on the presumption of innocence, and in a recent judgment, Allen versus the United Kingdom, the court had rejected to somehow summarize and condense its case law, and essentially said that the presumption of innocence has two aspects. Everything that is the first aspect, I think we have discussed at this conference in more detail yesterday. It is about the requirement, the inter alia relating to the burden of proof, legal presumptions of law and facts, privileging self-incrimination, pre-trial publicity, premature expressions by the trial court, by public officials on the defendant's guilt. So we discussed all that. What is relevant for non-conviction-based confiscation is actually the second aspect of the presumption of innocence, which is a guarantee to protect the individual who has been acquitted of a criminal charge, or in respect of whom the criminal proceedings have been discontinued from being treated by public officials and authorities as though they are in fact guilty of the offense charged. So how to apply this second element to non-conviction-based confiscation? And here we have some recent case law of the court, which I think is puzzling, but showing the difficulty and the tension of, on the one hand, the one line of case law on the presumption of innocence, and the other line of case law on non-conviction-based confiscation. There is a relatively recent judgment, Episcopal. It is about the Italian non-conviction-based confiscation system, where the court is basically saying that Italy has violated in its judgment the presumption of innocence because when ordering a non-conviction-based confiscation, they actually also went into language on imputing criminal liability to the person concerned. So once again, the question is how to apply this proof, this criminal proof of the crime without actually imputing criminal liability to the person. And the Strasbourg Court takes a case-by-case approach, looks very closely to the language that the national court says. Does the court makes incriminating statements? If yes, then it's a violation of the presumption of innocence. If it's no, then it might be acceptable. So, is this really instructive or helpful for us in finding a balance and situating non-conviction-based confiscation in the system of EU criminal justice? Especially in the Episcopal judgment, and we see it also in later judgments, that there is a growing number of dissenting opinions of judges of the Strasbourg Court, saying that maybe there are aspects of the judgments which will be difficult to reconcile with international law standards, so the Warsaw Convention on Confiscation, as well as with the EU directive, because once again, if we go back to Article 15 of the directive on asset recovery, the directive says that non-conviction-based confiscation is allowed for thus absconding statutes of limitation illness if it would have been possible for the relevant criminal proceedings to lead a criminal conviction. And now the Strasbourg Court is basically saying in its very casuistic case law that if the language used by the national court goes as far as to assess somehow guilt, then it is a violation of the presumption of innocence. So how can actually the court do the assessment which is required by Article 15 of the directive without saying anything about the crime and the criminal conduct? So this dissenting opinion, I think, is very interesting to read. There are more dissenting opinions in the second case, Kosovan versus Moldova, and all these dissenting opinions actually evolve around the same question. I believe that in the future, the Luxembourg Court will also have the possibility to address this matter, because now we have the question treated from the perspective of the European Court of Human Rights. We have to see if the Court of Justice of the European Union will give us more enlightenment what actually is permissible for the court to assess in the context of non-conviction-based confiscation. But certainly for the time being, it is very difficult for the national practitioner to distinguish between permissible assessments from impermissible imputations of guilt in a post-acquittal or discontinued context. If now we come back to the contextualization and the very beginning of my presentation, is this an alien element in our criminal justice system, or is this a new form of enforcement mechanism that we somehow can reconcile in the constitutional framework of EU law? I believe that the question still remains on the table for the time being, at least based on the case law and national legislation. I don't think that we have satisfactory answer, so I'm afraid, in as much as my dear colleague Pedro, I will also leave you rather with a question than an answer. Thank you very much.
Yeah, thank you, Caroline. Also, ending with questions instead of solutions, but I think it's showed very much the problematic field, and I think there's also much room for research in our part in this subject matter. I would say we have around 5 minutes for questions before the coffee break. Any questions on this?
Thank you. Can you hear me? Oh, yeah. I have several questions, but I will not take this 5 minutes that we have for discussion just for my questions. I will limit it to just one and go for Professor Mitsilegas, specifically concerning the problem of mutual recognition and the scope of application of the regulation, because it is true that it expanded the scope of application by saying proceedings in criminal matters, but it also says that civil proceedings and administrative proceedings are excluded by the regulation. And there is this new case that has been cited by most of the speakers today, which is Garofalo versus Italy for the European Court of Human Rights, that has recognized a civil nature to the Italian anti-mafia confiscation. It explicitly says it has a historical purpose. So my question would be, would this mean that the Italian confiscation and similar measures would be explicitly outside of the scope, even though the purpose of saying proceedings in criminal matters was to include this kind of measures within the scope of the regulation? And I see that this problem can also happen with Article 16 of the new directive, because national legislators can at least implement that article in non-proper criminal proceedings. So all this national implementation will be outside the scope of regulation. So is the directive coherent with the scope of application of regulation? Thank you.
Thank you very much for this question. I have a couple of remarks to this. That's a very complicated issue, of course. First of all, it's interesting to see that the directive does not define what is civil or administrative proceedings, which is very interesting, and I'm curious to see whether there will be litigation in the Court of Justice in the future on that. The question I mentioned, of course, asking the Court of Justice, is this, in your view, excluded from the scope or not? Is it civil, and it doesn't labeling matter or not? Whether, in Italy, I know there's a very big debate about preventive confiscation, about whether labeling or substance, and what is really the substance. And I think in Italy there was debate because there are some criminal law safeguards and the national proceedings, it doesn't have to be called a criminal in order to follow the criminal law. So there is clearly the issue in the future, I think, and you've pinpointed it correctly, of divergence between the European Court of Human Rights and EU law. This is clearly, was in my presentation as well, and the European legislator knows this, because if you read the preamble to the regulation, it says that this is autonomous concept, it's an EU law concept, which is different, specifically in the preamble, it's different to the European Court of Human Rights. So, the EU is saying here, we're going to have it our own way, and because we want to draw the scope, whether it will withstand scrutiny remains to be seen. I think it's an existential question for the Court of Justice. I think for me the key question in the future is how the Court of Justice actually will define the autonomous concept of proceedings in criminal matters for the purposes of the application of the confiscation regulation. Apropos, the same concept is used in the directive on confiscation of 2024. Exactly the same. So, so I think it's interesting to see whether again the court will define it in the same way for the purpose of both instruments, or whether we're going to have this kind of schizophrenic view that the court defines it in a different way for the confiscation directive and in a different way for the purpose of the regulation. So I think it's very interesting times, and I think the case will come. I think can argue both ways. I think there are a number of jurisdictions in the EU which will still be very skeptical about recognizing Italian preventive confiscation orders according to the Municipal Commission regulation, but there are arguments making both ways.
Yeah, we have, are there other questions? Because we go back, otherwise we take this one and conclude.
Thank you for your presentations. Two different questions. The first one is about autonomous concepts. In a sense, all legal systems implicitly apply a concept of autonomous concepts, in the sense that it's for that legal system to determine the meaning of terms. Maybe private international might be an exception in some cases, but there's always that authority of the system to define terms. So autonomous concepts, in what way do you think it's sort of methodologically meaningful here? I suppose that's what Inge Fairfax said. Also for Kathleen, I wonder what is it important to have a threshold for setting up a suspicion of unexplained wealth? Is there a risk that these kind of mechanisms could be used to sort of set up an issue, and then at that basis of an issue, go on a fishing expedition to find out about a person's financial means for some other reasons, perhaps political reasons? Or, how does that work out in practice?
I can start with autonomous concepts. Thank you for this question. The claim by the court on autonomous concepts is that they are necessary in the EU law to ensure uniformity, but there is a tension between this claim towards uniformity and the fact that inevitably these concepts are context-specific in the EU law. And if I could land those articles that I think my contributions, it's like, so the court uses them for specific instruments in a different way. So if you look for consistency, perhaps it's not necessarily there. That's why I'm saying I'm curious to see confiscation, whether the court will go for the same autonomous concept, which is in criminal matters throughout, and whether this is applicable throughout European criminal law. No, my sense is not. So we look at different instruments in different ways in that sense. So we'll see how careful it is, but I think clearly, politically, if you look at the regulation, I think it's a clear signal that the EU legislature is saying here, we want to have something which is broader than what we have at least in the European Court of Human Rights. Broader also because because Strasbourg says, you mentioned Strasbourg saying a lot of it is not in criminal law. Whereas the EU has legislated under a European criminal legal basis. So the purpose here is to say, as far as we are concerned, this is criminal law, and the EU criminal law doesn't apply, in a sense, which is not existential.
Yes, and I think maybe just to pick up on this last remark of Sam is we are expanding a criminal law, but whatever we can empirically have in terms of value of assets recovered, these instruments are not very effective. There are studies of the EU showing that I think 1 to 2% of estimated unlawful assets are actually recovered in the EU. So we keep expanding, and now I'm coming to answering your question. If unexplained wealth can justify that on a suspicion, national investigative authorities start to use intrusive measures and go on a fishing expedition, which we don't know where it will lead. I think that there is really at least an empowerment, and we have to be very mindful about that and about this expansion of the criminal law, especially at times when we have rule of law questions even within the EU. I think we should be mindful of that.
And if I may just add one word, especially in systems where prosecutors seem to be more concerned about confiscating proceeds than actually having convictions on offenses.
So, thank you very much for the panel, for our speakers, for the questions. So we have now a break of, is it okay, 10 to 40 to the the 10-fold coffee break class. Thank you very much.
We saw in the previous session on confiscation of assets in the light of the presumption of innocence. And as we saw in the previous panel, confiscation is quite complex and fast evolving area. One that creates important shifts and impacts the traditional requirements of criminal law, while also raising important questions in terms of guarantee the protection of the presumption of innocence. And now we have the pleasure to listen to four distinguished speakers who will further explore these tenets from different perspectives. And our lead speaker is Professor Daniel Benvenuti from Valentino University in Bologna. Professor will delve into the long-standing debates surrounding the presumption of innocence and extended confiscation. So Professor Benvenuti, the floor is yours for 15 minutes.
Thank you for your presentation. I'm beginning by expressing my gratitude for being present here, seeing all of you after several years of absence, and I wish to thank my entire team for the excellent organization of this conference. Now, moving on to the next presentation, I have to say I have really not when we were in school. The best class just was visited by the teacher in front of you. I can imagine this because we had an actual step of experts in the field of communication. We had Thomas as the chair, Balsam, and and was in the performance day, and the father was present. I think we had the school also, very passionately having in sport events. So it would be easy to continue what is the point. Anyway, I have several notes here because I tried yesterday and today to very because in order to try to make a connection with what I'm now trying to present. And this is the exact modification and the parity of the need for modification and for make the connection to various slides. And as well important is to respect the function of the I will go faster than I did because after I finish my slides, I tried to make a presentation that unfortunately I didn't make the slides that were already sent, but I will perfectly very to present a case of from January 2025, which is really interesting in the light of all these mechanisms and see what the Supreme Court decided. Preamble, preparation for what okay, we must love the money. We must underline its crime, okay, and go the recent, not so recent, but recent from our published by our distinguished speakers. We basically must change the criminal money on the age of the good crime. And on the other side, we have the offenders. We have the persons who are convicted because they are not breaching the reduction of innocence, who have absolutely no respect for law and authority. This is obvious because they are doing crimes and they are following only material damage. And to quote Thomas, nothing is not problematic in this field. And for all of us who are reading on the subject, I think the feeling is the same. It's more confusing and more complex. I started my research in the development in 2006 when I started working and giving lots of context to the amendments to the Romanian legislation. And each time I prepared for this lecture, reading most of Catalyst works and as well. And I have the the same thing, there are more and more problems which arise as time reads. I'm going to say, I'm going back because we all look upon these council directives and framework directives, and there's directives from 2014 and the recent 2024 directive. And making connection to Petr's presentation and Article 16 of the confiscation of claim 12 of the lesson directive, which I think we can consider to be an extension of the extended confiscation from the previous procedure from the directive and from Article 14 from the same directive. I think I should have started by inserting the Convention on the Prevention and Fighting Against Corruption from 2003, when the Article 20 we had the illicit enrichment and the need for the state to adopt this convention to regulate criminal provisions regarding this illicit enrichment. Romania, for example, has transport national legislation in 2004. This convention found have no criminal. The need for extended confiscation and the consequences. What is the effect of confiscation? We don't know. It's remove the causation requirement and the offense and the proceeding. I think it's already, but the need for terminology is needed because we have confiscation. Sometimes considered as classic confiscation or direct confiscation. Is the confiscation when you convict someone of a crime or you set the office down in view of the crime, you have the time on the unlawfulness of identity life, general law. You can confiscate it because the link between the offense and the proceedings is demonstrated. Obviously, the need to confiscate goods beyond that stage was firstly in the framework of 2005 when we had the first regulation specifically for extended confiscation. What is the consequence? Which is especially in the field of procedural watering down of traditional criminal safeguards, reversal of the burden of proof, or lowering the burden of proof in any case, and a potential infringement of breach of the presumption of innocence. And then the balance theory needs to be we need a tobacco construction, or we need a criteria. I like German law, and starting in 2009, the change the origin of inspiration from the French model to the German model. But I think the German criminal law is a little bit dogmatic. I don't think that dogma here, or maybe philosophical theory, we need a criteria which will need to be applied theoretically in any case. At the time, I teach European law at the master's level and general law, general law at the second year undergraduate students. And I always lean for the need to identify a criteria, a general mechanism which theoretically can be applied in every case, and not a piecemeal approach and try to resolve the cases on a case-by-case basis. It's not easy, but if it identified as such, it will work in the future. And this is what actually the European legislature tries. Obviously, the field of working with directives, which means this is the objective, you have the means when you can try to achieve the goal. We have on one side the substantial material law, criminal law issues, and on the other side the procedural safeguards. Because of course this is not a problem of criminal law, it's becoming more and more a problem of actual procedural criminal law. On the substantive flow aspect, we can try to give more and more and try to identify exactly the area in which this confiscation should work. What offenses? Who or what persons? For a specific period of time, etc. For example, regarding the functionality for a specific period of time, it was indicated by the 2005 framework decision as a guideline. The main legislator opts for totally unhappy criteria. You can consider extended confiscation for goods that cannot demonstrate origin, the illicit origin, for a time span of 5 years, going back from the moment when the indictment act is issued. Why this me only 5 years? Why this starting point? The moment that the indictment act is issued in complex cases where complex team of lawyers act, it's difficult for the prosecution team to drag the indictment in very quickly. What very obvious from the moment you, as an attorney, also as a lawyer in the law, from the moment the suspicion of criminal case is going against one of the clients, your advice is be totally crystal clear with the plain language. So this 5 years period is a regression. Sure, most of the time will be consumed with nothing. Everything is spotless for the anyway, we can add and add conditions. I think it's not a very good condition, but the main but the time frame for which going back the institution will be analyzed. We need efficiency, and we concentrate on going after the money, or making it a criminal policy to start thinking complex and for the duty. Moving to procedural law and setting on we have a standard of proof and the utilization of legal results. The legal utilization of the confiscation and national regime can help us to try to overcome some standards. We can regulate, I don't know, as a single measure, going to the civil court. And in this case, we can try, at least in theory, to avoid one standard. And I'm moving on to the result of directive 2014. Actually, part of the preamble of this directive, I think, is very enlightening. Below what the European legislation is trying to reach. And we start to identify not only the field of third-party confiscation, it tells us it's for the national legislator to try to establish the nature of the measure. It can be subsidiary, it can be penalty, it can be an additional measure, it can have a single measure. It doesn't care for the European legislator. It's for the national legislator. The function and the purpose to make the execution work. Well, the employment of legal presumptions and the legal presumptions with the reversing burden of proof is what actually the 2005 decision and the following but in which situations the individual will be called upon to provide information. And the criteria would be specified and they were advanced by both in 2014, I like that. Maybe it's useful to use statutory presumption when it is easier for the defendant to provide an explanation than for the state to demonstrate it. So maybe this presumption can work when that you ignored these types of income. You only look at my, I don't know, salary, and you omit the use and use of figure presumption, the rebuttal presumptions were already touched upon. Does the end justify the means? Of course not, but the end is very important in this field. In a nutshell, it's confiscation for reason. We all know that the roots fully convinced that in root 3 actually was the part of rebuttal presumption. Provisions unclear of this new approach, and the 2014 directive a more precise legal wording of extended confiscation. No alternative routes, a more accurate legal wording. The 2024 directive with Article 14 and Article 16, which Pedro so well presented. Article 14 is that it's only an even better wording than previous Article 5, if I recollect from 2014 directive. It doesn't start the institutions regulated as the first paragraph, the determination mechanism, and the balance between the local income and the value of the property cannot justify its the second paragraph, and the third paragraph is the reasonable methods. Even more clear how the institutions work. It's not a problem in theory, the problem is on the procedural aspect. It's quite division of the presumption of the burden of the rules. It's shifting from the prosecution to the defense. Theoretically, it's impeachment, but the exceptions are legal presumption and the legal characterization of extended confiscation. The practical legal presumptions are relevant in this field, and I moving to the European Court of Human Rights case law. I think I have here the Fleece versus UK and the which the court is basically flagged in the field of extended confiscation and confiscation of assets in general, that the use of legal presumption in this field is forbidden. Also, Catholic make a presentation of all the relevant case law of the European Court of Human Rights in the field of especially third party confiscation. We move to the conclusions. We have so-called draconian provisions considered for increased efficiency of confiscation. What are the possible effects, the side effects? And I think we all have seen this probably at least once. For example, in Romania, we increase the penalties for drug trafficking. They are huge at this time. And the courts invent new constructions in order to lower the penalties because they feel the penalties are enormous, even considering the absolutely severe violations and the importance of the law of drug trafficking. And this could be a possible effect. Of course, with that one, we feel the need not to confiscate because they stress and press either legislative and extra legislative who just are other available options. And then moving now, because my time is already done, to a case which I want to present. It's the complicated part because we have a location. In January 2025, was the former mayor of the sector in Bucharest, and he was a member of the Romanian parliament, and he was standing for deputy, but because of his quality, the competent belonged to the chamber of the High Court of Cassation, Supreme Court, and the hearing went to the special panel of 5 judges. The judge here is a member of this panel, but was not member in that case, so nothing we can talk about this when no problem. What was he was indicted for corruption offenses of about 10,000 euro corruption, and for money laundering, it was at the house search, and after several searches of his whereabouts, the following year, the case is known as the Diamond case. He is between January 2008 and March 2019. His total income was about 120,000 euros. Versus what we have found after the search, the house search, and other searches. He has paid deposits on his ex-wife account and his housemate, who were all paying of about 1 million euros. He has bought houses and flats for his wife and his ex-wife for about 400,000 euros. He has given loan in cash to several persons at about a level of 900,000 euros. In his house, at the house search, there were found diamonds and jewelry of about 2 million euros. And there's another loan of 50,000 euros and a car about 60,000 euros. So this was in that. The National Anti-Corruption Department indicted him for corruption, 10,000 euros crime, and for money laundering, because all this money were several development contracts, his housemate had all the accounts, they were in Brussels and in Luxembourg buying expensive clothes, and the main was in Bucharest, cleaning all in the house. She never had an account before this deal. The first acquitted him of money laundering and rejected the extent of confiscation. Because he said, okay, you as a prosecutor only requested confiscation. We are giving and confiscation is possible. You didn't even mention the extent of confiscation. Okay? But the extent of confiscation is compulsory to revenue. The problem was nobody asked for it. And then the first question is, what should you do for the future as a prosecutor? You should ask for confiscation and a subsidiary for the extent of confiscation in the case is acquitted for the offense. And now I'm moving to a case of the European Court of Human Rights, where the court considered a violation of extent of confiscation. In case where you were acquitted for the offense, you are acquitted, you cannot extend confiscation for assets which were initially legal. That was not a crime, so everything is presumed to be illicit. And the following, I think this was not the case, important in the case here, because we had an acquittal for money laundering. So this is really big, but we could not justify anything else. The special panels of the G5 panels of the High Court, the Supreme Court, rejected the appeals of the public prosecutor now saying, okay, it's obvious we have no balance, but we cannot decide if the appeal was in the light of the European Court of Human Rights. It's not, it's penalty, punishment, and you have to have a second to the greater jurisdiction in this final. And you cannot have a appeal against our decision. You have all the money back. And it's interesting to see how the case has worked if we had Article 60 from the 2024 directive already regulated. Probably the same conclusion because it was not linked or part of any criminal organization. Thank you very much.
Enlightenment framework of extended confiscation and practical experience in our next presentation is the results of our collaborative action by the academics, by the Secret Voice. And this will be in advance, if I mispronounce the name, Professor Raymond Asioka will present the work conducted with Professor Rima Azubayete and Yolanda Zayan-Shulkivne, all from Nicholas Romanes University in Lithuania, and this presentation will be focusing on the standard of proof in the application of non-conviction-based confiscation.
Thank you very much. So first of all, let me thank you to Professor Christina for inviting us to this event. Secondly, thank you for the speakers for notes or the findings of their presentations, and of course to Riga City for best working weather ever for this conference. I like this weather, truly. So let me start with my report. And of course, it's not on one report of mine, because we were doing this report with our colleagues. So then we would like to present the working case of the standard of proof in the education of uncondition-based attestation. So why did we choose? Why did we choose this report? So because of the fact that the legal framework for the restitution of unlawfully obtained property and the standards for proving such restitution have expanded rapidly in recent years. So, and we can see from various judicial practice of national courts, European Justice Court, Court of Human Rights, and of course the judicial practice of constitutional courts of European countries like Germany, Portugal, Romania, Georgia, Italy, Bulgaria, of course Lithuania, and of course in 2025, the Constitutional Court of Latvia. So this question, the question now we are discussing at the moment, could be also seen as a trigger for academic discussions, starting from finding the ways to improve effective implementation of the principle according to which no one should be able to enrich himself from the legal activity to consent that criminal law as such. Criminal law principles, including the presumption of innocence, are being effectively ignored for the sake of experiencing justice. So, as a matter of fact, some of the findings of this conference are already devoted to detailed analysis of the legal provisions of confiscation. So we have decided to present, as I mentioned before, Lithuanian case. So in this slide, we can see different types of confiscation, different objects of confiscation, and different standards of proof. So I should emphasize that depending on the nature of the confiscation and its procedure, so the object of confiscation often changes. So from traditional elements of conviction-based confiscation to property presumed to be of a legal origin. So the analysis of this legislation, judicial practice, and the doctrine made us easy to choose a simplified scheme, as you can see in this slide, according to which we have analyzed the relevant judicial practice in the context of standard of proof. So recognizing that the seizure of property of criminal origin, whether it is regulated in the criminal code or in other specific laws. So we are considering it as a non-conviction based on this confiscation, or in certain cases a quasi-confiscation, if the person has not been convicted of a specific criminal act. So then we assess the standard of proof before choosing in such cases. That is to say, whether they rely on a presumption of innocence, what they say about the burden of proof, and whether they apply the standard of beyond reasonable doubt or the balance of probabilities. So, talking about the system of legal measures of controlling unlawful property, so we will present this system of confiscation or seizure of illegally obtained property that is applied to Bitcoin. So as you can see, there are legal measures by which the proceeds of criminal acts, property of lawful origin, or even property of unlawful origin can be seized and confiscated or taken into account to the state ownership. So afterwards, we will show what the standard of proof depends on the origin of property to be confiscated. With different rules governing the seizure of property by the state and the procedural way by which the issue of the seizure of property of the criminal origin is solved, whether it is civil or criminal procedure. And in this report, we will only present the extended confiscation of property under provisions of our criminal code, the confiscation of civil property under a special law, we have a special law, and we will discuss the de facto confiscation of property of illegal origin, recognizing it as the ownerless thing or unexplained wealth, according to the civil code of Lithuania. So let's start from extended confiscation of property according to Article 32 of the Criminal Code. So the provisions of extended confiscation of property have been enshrined in the Criminal Code since 2010. However, this provision began to be applied much more later, because due to the doubts on the part of the courts as to how it was compatible with the presumption of innocence. And more than in 2018, the ruling based on the practice of the European Court of Human Rights. So the Supreme Court of Lithuania, for the first time, started to discuss the standard of proof of the high probability, in addition to the standard of proof of guilt beyond reasonable doubt when applying extended confiscation. And nowadays, I should emphasize, the courts have essentially established the following standard for proving the origin of criminally obtained property. So a few years ago, the Constitutional Court of Lithuania, like many other European constitutional courts, ruled that this standard does not violate the presumption of innocence. Because the prosecutor must prove that the property is of criminal origin, even if the person from whom it is confiscated did obtain indirectly from the crime for which he is being prosecuted. Civil confiscation of the assets. So a few years ago, there was a special civil asset confiscation law adopted in this way. It looked like progressive law. Nobody knows what will be the future. So it was believed that extended confiscation of property, even when there is evidence that certain property is of criminal origin, sometimes cannot be applied, for example, due to the termination of criminal proceedings. So as you can see in this slide, as you can see in the fragments, extracts of this legal regulation, so this law established the presumption of illegality of property. So this law can be generally applied after the criminal proceedings, when a person has been charged with certain crimes, but the criminal proceedings have not resulted in a judgment of conviction. In the first and so far the only one case of the Supreme Court of Lithuania, it was clarified that firstly, in cases of civil confiscation, as in the aforementioned extended confiscation, the standard of probability applies, but secondly, the prosecutor must still prove, as you can see in the slide, not only the formal conditions for the presumption of the legality of the property established by law, but also the origin of the property to be confiscated. And what would be concluded, the Supreme Court of Lithuania, like the same European Court for Human Rights cases as the criminal courts when applying extended confiscation to criminal cases. For example, we can use the case of against and others against Georgia. It was emphasized that the proof of criminal or any other illicit origin of the property is based on a balance of probabilities or a high degree of probability combined with the owner's inability to prove the contrary. Moving to the slide number 6. So one fact we are emphasizing the fact that such a civil law institution as the recognition of property as ownerless and its transfer to the state ownership, which appears to have nothing to do with the disqualification of criminal assets, could also be held as part of the system or procedure of criminal assets. So let me explain why. So during the investigation of money laundering, including suspicious international transactions due to the high standard of truth required, so if the case cannot be brought into the court, so the investigation is terminated. One of the reasons is that it is impossible to identify the real holder of the funds that are suspiciously moving through the accounts or in cash of individuals. So such funds, which are usually frozen, can be recognized as ownerless property or unexplained wealth and transferred to the state at the request of state tax inspection to the court after the criminal investigation was completed. So after there is no dispute about this, as there is no interested party, so there is essentially nothing to do, as you can see in the first example. However, in cases where the person against whom the criminal investigation was for money laundering has been conducted or another interested party disputes courts, it is their legal property, so the evidence is presented in accordance with the general rules of civil procedure. In this case, however, it is not the criminal origin of the property that is proved, but the question of the ownership. I'm going to end. So finally, we will share a single court decision in a criminal case, as you see here. So the lower courts, having decided that money found during a search of the apartment of a person accused of trafficking small amounts of drugs couldn't be confiscated or returned to the defendant, even though he categorically denied that it was his money. So the Supreme Court upheld the prosecutor's decision appeal in Article 94 of the Code for Criminal Proceedings, which states that things that shall be returned to the legitimate owners in case the liability are not identified, they shall become a state property. The court therefore handed over the money to the state. And instead of conclusions, let me say that having analyzed the standard of proof applied in practice by the Italian courts, when deciding on confiscation of property not based on a conviction, it can be concluded that despite different regulations or improvements or etc., it is the court, at least for the time being, that must be convinced that there are legal and factual grounds for confiscation or other seizure of property related to the criminal act. In any case, the proper application of sufficiently different instruments of property confiscation is a never-ending process. And at present, the plenary session of this Supreme Court that will be deciding on the issue of traditional confiscation of the proceeds of criminal acts, although there seems to be a perfectly clear traditional instrument of criminal law. So thank you for your attention and wait for your questions for later. Thank you.
Thank you very much, Professor Decker, for sharing this very interesting analysis, which casts a critical light into the standard of proof used in conviction-based confiscation in the Lithuanian system. Now we'll shift perspective to the international dimension. Our first speaker is Professor Maria-Luisa Glasse from the University of Geneva, and she will discuss the presumption of innocence in the context of international confiscation of assets located in Switzerland. So Maria, the floor is yours.
Thank you very much, Julia, for this kind introduction. As much has already been said and brilliantly said on the question of the presumption of innocence in general and confiscation in particular, let me adopt both a restrictive and a broader perspective. Restrictive because I'm going to limit myself to assets located in Switzerland, and broader because I will not talk only about confiscation, and I really hope that you will forgive me this small digression that I call to interest. Clearly you are not very, yes, you are not very interested in pure domestic Swiss cases, although I will have a lot to say about them, both good and also very bad. But let's talk about international cases, where confiscation takes place in response to requests for mutual legal assistance. The configuration would be the following. It's an easy one, obviously. A state, Germany, Italy, Latvia, conducts criminal proceedings and realizes that Switzerland has acted as a hub for the flow of capital more or less clean capital. Let's not generalize. Of course, it obviously does not happen that all the time. The foreign state asked Switzerland to freeze the funds, and Switzerland orders the provision of measure that is seen. Then 1, 2, 10, 20 years go by, and finally a conviction is handed down. And Switzerland receives a request for confiscation. This time the measure will be definitive, depriving the person entitled to the funds of their right to purpose. It is also very convenient for Switzerland, since the confiscated assets will be shared, in principle 50-50 between Switzerland and the requesting state. Every year, some 10 sharing agreements are concluded. This adds tens of millions of francs to the Swiss Confederation funds. But let's now focus on what happens in Switzerland when the foreign state addresses the request for the forfeiture of the assets. Confiscation is a restriction of fundamental rights, as already mentioned, namely the right to property. And the Swiss Constitution subjects such restrictions to several conditions, including the existence of a legal basis. Under Swiss law, there are two possible legal bases for funds to be handed over definitively to a foreign state under criminal law. And the distinction is made according to the legal nature of the funds and the reason for the seizure. On the one hand, and you will see that I'm radically simplifying the situation here. On the one hand, proceeds of crime that was the result of the offense, and the funds intended to persuade the perpetrator to act are subject to confiscation under Swiss law. On the other hand, when the proceeds of crime are no longer available, but the perpetrator has become richer, the crime should not pay, as we already said, then the path to take is that of what we call compensatory claim. To make the distinction between one and the other, the conditions under Swiss law are relevant, regardless of the qualification that was made under foreign law. This means that the Swiss authorities will go through the facts and decide again and decide which paths should be followed, not taking account of what is said in the foreign state judgment. For example, assets linked to a tax fraud in Germany will be subject to a compensatory claim rather than cyber tax stream, and it will be also the case of certain very broad forms of confiscation, called confiscation in Italian law, that will be reclassified and take that as compensatory claims under Swiss law. If it is a case of confiscation, the path to be followed is general mutual legal necessities. And if it is a compensatory claim, then the foreign decision will have to be enforced. And this is important because these are two very different forms of cooperation under Swiss law with different conditions and different paths. On the one hand, general mutual assistance is dealt with administratively. So it's a pure administrative procedure where the federal Ministry of Justice is the competent authority for handing over of assets. And in case of a dispute, a special administrative procedure with restrictive conditions is provided for. There is no room at all for presumption of innocence, except if the criminal proceedings in the foreign state as a whole were so obviously incompatible with the human rights standards and the right to fair trial, that this right was not satisfied, and it then amounts to a ground for refusal of cooperation. On the other hand, the enforcement of foreign decisions takes place in two phases. First, an administrative one, and then a criminal or judicial one. In the first one, the Ministry of Justice will rule on the general grounds for refusal of cooperation, and then the second part of the second phase, in the foreign judgment is subject to an executory procedure, a criminal procedure in which only the facts will remain non-questioned, unlike their legal qualification. It is, of course, not a matter of repeating the trial on the merits and ruling on the conviction or acquittal of the perpetrator, but the legitimacy of the compensatory claim must be called into question, and the entitled person can be heard again new evidence may be required. The presumption of innocence has here an ambiguous place. There is no presumption of innocence for the perpetrator, but there is, again, and to some extent, a presumption that the assets are clean, with the exception of assets belonging to a criminal or terrorist organization, for which the presumption will be reversed. To conclude this first part of my presentation, one can say that the presumption of cleanness depends thus on the type of assets that are linked to the crime, and it can sometimes be difficult to predict which path will be taken. This being said, I told you that I would like to take a different digression here. So let's talk about the almost inevitable step before confiscation, that is to say, the seizure. Because here there is a very serious, let's call it like that. For me, as a Swiss lawyer, it's a very serious matter, even more serious because of the Swiss financial sector's importance. This whole process of confiscation that we're talking here about for foreign state involves, and I realize that what I'm saying right now will seem very banal, it involves trust in the foreign state, obviously. But the case of Russia and the very recent Swiss practice undermines this logic. Before 2022, cooperation between Switzerland and Russia worked on the basis of prior international guarantees, including the guarantee of a fair trial that had to be given by Russian authorities before a confiscation was ordered in Switzerland. There is, of course, a lot to say and criticize about guarantees in general and in particular in some states, but that was the case. The way it was done, we cooperated with a country we trusted, or at least in whose guarantees we trusted or we tried to trust. And then came February 22, the invasion of Ukraine, the denunciation of the European Convention on Human Rights, and the withdrawal from the Council of Europe. A political decision was taken in Switzerland. International cooperation with Russia must be suspended until the situation regarding fundamental rights, and in particular fair trial, will improve. But then, big question. What to do with the 400 million Swiss francs still seized in response to MLA requests made by Russia before 2022? My logic was very naive, very simple, very academic, I would say. I thought that seizure is a temporary measure intended to ensure that a definitive measure can be taken. So, since cooperation must not be refused, then no definitive measure is possible, and therefore there is no reason, no right to maintain temporary measures, so the seizures must be lifted. Not at all, answered the federal tribunal. The issue has been referred to this highest Swiss judicial authority, which has decided and reiterated in two other decisions since then, and that cooperation proceedings might not be closed by refusal, but suspended, and that the seizures must be maintained. For how long? Well, this is not very clear or not clear at all, but in any case, for as long as the declaration appears in project, nobody knows what it means, but according to Swiss case law, it can be even 25 years after solving the frequency case that Catherine talked about before, for such amounts when money is linked to white-collar crime. But there is even worse. The Ministry of Justice was invited by the Federal Tribunal to regularly check with the Russian judicial authorities to find out whether the criminal proceedings are progressing. The same judicial authorities that are not trusted and with whom there is no cooperation because they do not meet the requirements of the trial. So it seems that there is a presumption that the situation in Russia will improve more or less soon, but in the meantime, the assets should remain in safe hands. But it also means, and this is what strikes me apart in German as well. I would be very interested to know how such situations have been dealt with in your respective countries. I welcome your points of view and your comments, and thank you for your attention.
The 10 minutes, we will now conclude this panel with a look at recent national developments. Our final speaker is Jens Rosenberg from the University of Latvia, and he will share a recent analysis of Latvian case law concerning the handling of procedural crime and the presumption of innocence.
Dear participants, dear guests, dear colleagues, we all know that sometimes press conference presentations are short. And the closer we are at the end of the conference, the more weight this procedural principle gains. Since my presentation happens to be the last one, I hope I bring you good news. In the context of criminal proceedings, actions concerning criminally acquired property have always a connection to the presumption of innocence, and therefore I assure you that my remarks hopefully should stay level within allotted time. So let's start. When the presumption of innocence does not apply the confiscation of criminally acquired property. Answers to this issue can be found in the case law of the European Court of Human Rights, but however, since my topic is focused on the case law of Latvian courts, I'd like to draw attention to the insights included in the judgment of the Constitutional Court of the Republic of Latvia, the recent one, dated in March 2025. In this case, the applicants considered that the proceeding for confiscation of criminally acquired property, so-called indemnity proceeding or non-confiscation-based, non-eviction-based confiscation, they considered that they were punished by confiscation of their property despite no proof of their guilt in the criminal offense. This approach is really inappropriate, as the Constitutional Court also found. So the court emphasized that the presumption of innocence is a criminal procedure guarantee applicable within the main criminal proceeding as compared to the person who is subject to criminal prosecution, and accordingly the presumption of innocence does not apply to special indemnity proceeding for the confiscation of criminally acquired property, which focuses only on determining the collective origin of property from civil perspective. Also known as non-conviction-based confiscation. So confiscation here regarding this indemnity proceeding, where no individual judge does not constitute a form of punishment, and therefore cannot serve as a basis for applying the presumption of innocence. And accordingly, the Constitutional Court concluded that the presumption of innocence laid in the second sentence of Article 92 of the Constitution of Latvia is not applicable, and that the applicants in this case was property was recognized as criminally acquired and subsequently confiscated within this indemnity proceeding. So, but where or when the presumption of innocence may intersect with the confiscation of criminally acquired property? How this potential intersection occur? And the answer, at least from Latvian law perspective, lies in reverse requirement of proof and legal presumptions of fact, especially when employed within in personal process, that is where the guilt of person being assessed. These are specific areas where the issue of criminal conviction of property may potentially conflict with presumption of innocence. Article 125 of the Latvian Criminal Procedure Law includes a comprehensive description of all legal presumptions of fact accepted in Latvian criminal proceedings manual. According to this provision, the listed circumstances are considered proven without further procedural action unless evidence to the contrary is presented during the course of proceedings. And if a person involved in the criminal proceeding believes the presumptive fact is untrue, they are required to provide evidence contradicting this fact. And two of these legal presumptions are particularly relevant for my today's topic. First of all, the law law says that it shall be presumed that the property laundered has been criminally obtained if a person is unable to provide a reliable explanation of the lawful origin of the property, and if the totality of evidence give authority grounds to believe that the property is likely of criminal origin. That's one presumption. And the second one, which is probably more important, there is nothing that the final and binding court decision in non-conviction based proceeding or in them proceeding is considered as a proof of fact in the main proceeding in the trial. Imagine a situation where an investigative authority assumes that certain suspicious financial activities indicate the possibility of money laundering and possibly criminal origin of funds. The presumption is based on the objective element of actions carried out, so-called steps. And then the individual is invited to explain the lawful origin of the funds. And if the person fails to do so, or provides convincing proof, or simply remains silent, the property is presumed to be of criminal origin. In fact, this is actually not a pure or classic presumption of fact, as it is based on the evidence creation of balance of probabilities, because this is the starting point for a person's obligation to explain the origin of the money. So there must be some initial evidence for the prosecutor that gives the balance of probabilities. This is believed that probably origin is illegal. And this is followed by return to the main money laundering proceeding in persona. And here the next legal presumption of fact can be triggered. And it's deemed to be proven that the court has established by final and granting judicial decision that the property was acquired criminally. In other words, first, in the proceeding, the criminal origin of property is presumed due to suspicious activity of the person responds, and the person has remained silent. So here works the first presumption. And then, in criminal procedure in persona, this presumption is used to find the person guilty for money laundering, since the property already is established as criminal in previous criminal procedure. At least one important feature of the crime of money laundering, the object of crime, the legal property, now is presumed in the main criminal procedure. This means that Latvian law permits a double presumption, which ultimately supports the finding of guilt in money laundering. And here my conclusion, if a suspect or accused person in Latvia does not want to be convicted of money laundering, they must credibly explain the lawful origin of the property. And if they fail to do so, or if they simply remain silent, the property may be recognized as criminally acquired under the presumption in a process in rem. And this recognition then triggers the second presumption that the object of offense, criminally acquired property, is present and proven within in persona process. And I guess that here would be a quite controversial whether the situation would be consistent with the presumption of innocence, particularly with the Directive 2016-343, the presumption of innocence. And one aspect of the presumption of this presumption is right, of course, to remain silent. And also in articles 27 and 28 of this directive is clearly stated that the exercise of right to remain silent should not be used against the suspect or the person and should not be considered as evidence that the person has committed the offense concerned. These considerations provide a strong argument that the person should not be convicted only for exercising their fundamental rights and choosing to remain silent. Authorities anyway must prove actual guilt, not rely on the assumptions or subsequent presumptions. In any case, to comply with this presumption of innocence, the court duly verify and assess such evidence independently. By the way, small spin-off from the courts about political perspective. Ministry of Justice in Latvia wrote in annotation the amendments of criminal procedure law adopted in 2017. It was many amendments related to confiscation of criminal property, that with regard to grouping of a general objective element of criminal offense, the object of crime, illegal property, the application of lower standards of proof, balance of probabilities, shifting of one's probability, is not permissible. As this would violate the presumption of innocence. This was the opinion of our Minister of Justice and legislator in 2017. Then, just 2 years later, in 2019, in another annotation of amendments of criminal procedure law, the Ministry of Justice wrote and the Parliament accepted that the lower standard of proof for one element of the crime, the object of crime, illegal assets, is permissible and legitimate solution since for all other elements of the crime, the standard of proving adults will stay as we know it for criminal law. So in a couple of years, the modernization of criminal law forced our ministry and the legislature to change their opinion. Briefly about the case law. At this point, let us return to the aforementioned judgment of the Constitutional Court from March 2025. Also, in this judgment, the Constitutional Court declined to evaluate the evidence objections regarding certain provisions of criminal procedure law governing the confiscation of criminally acquired property in light of presumption of evidence. The Constitutional Court did include one brief, and for being seemingly out of context, one brief statement, actually one sentence, that the presumption of innocence protects individuals so that the facts established in non-confiscation-based proceeding are not used against them when assessing their guilt in committing a criminal offense. So today, the Constitutional Court actually has not been asked or assessed the constitutionality of specific provisions of criminal law about this dual level of presumptions that I mentioned before. But still, this brief statement, this one sentence in the judgment, would arguably be interpreted as a subtle message to other general courts that the principle of presumption of innocence may prohibit using findings from in them proceeding related property as the presumptive facts in subsequent impersonal process. So it's like a message. Yes, in all we can impose presumptions, but please, in every process, evaluate how it should work. The case law of Supreme Court, the Senate, as we call it in Latvia. So far, the Supreme Court has not evaluated any cases where the legal presumption of property is criminally acquired based on prior judgment from indemnity procedure. At least no such cases can be found in the publicly accessible Senate-based database. However, in 2024, the Supreme Court considered the issue of determining the object of money laundering offense in the context of standalone money laundering. And the Senate concluded that under the criminal procedure law, the prosecutor must first prove the criminal origin of property according to standard balance of probabilities, and only then the accused person the obligation to prove the lawful origin of the property. And in determining the criminal origin of one of the funds, the object of offense, the court must assess whether the body of evidence gives ground to presume that the property is likely of criminal origin. Again, on the balance of probabilities. This shows that even at the highest level of criminal justice in Latvia, the use of single standard of proof and reversed burden of proof have been accepted, namely that the accused must prove the lawful origin of property and the information provided by the person is also subject to judicial evaluation. And here, no potential conflict with the constitutional level of presumption of innocence was identified. Furthermore, I should say that Senate did not distinguish between duty to prove and duty to point evidence contradicting the presumption. They actually, in Latvian case case law does not undertake an detailed analysis of whether the direct order of proof in these situations is intentional or persuasive in nature. But it is distinction will be relevant in assessing whether and when the direct order of proof applies to this presumption of innocence. However, I guess that it's fairly likely that in the near future these issues will be examined both by the Constitutional Court in Latvia and also the European Court of Human Rights. I hope I have fulfilled my initial promise to stay by me against the presumptions and all. I know it's thank you for your attention.
Thank you very much, Professor Reisenberg, also for keeping with the 10 minutes. Thank you very much to all our speakers for their insightful presentation. I think we now have some time for discussion. So I would like to open the floor to questions from the audience.
Thank you again. Thank you for all the presentations. I would like to ask just a short question to Professor Yanis Rosenberg. If I understood it correctly, concerning the offense of money laundering, if you have in-bank proceedings beforehand, the illegal origin of the assets are evaluated on the basis of the balance of probabilities. And then this constitutes evidence enough for the purpose of the offense of money laundering later. The offense is proven.
It constitutes a presumption that the money or assets involved is of illegal origin.
So you don't have to prove any kinds of offense in the money laundering proceedings.
The prosecutor still has to prove the part sales that some activity happening has to special events to hide or to mask the origin.
But if it comes from trafficking drugs,
yes,
yes,
that's considered as a presumption that it is so. And the defendant has a right to go on with his own obligations that it is not so, and he has obligation to prove if he's not happy with this presumption.
And the Constitutional Court said that this, well, did not say it.
The Constitutional Court said that in this one specific case, no one was accused and criminally sentenced. And the person may play the Constitutional Court only for actual breach of his fundamental rights, and since all the confiscation took place, the Constitutional Court simply said that presumption of innocence is not relevant for your in-bank proceeding when you will be sentenced, actually, based on those presumptions and come back next time.
Yes, but given the actions that we took from that sentence from the Constitutional Court, do you think that the Constitutional Court is leaning towards saying that this presumption could be against the presumption of innocence if someone is convicted for money laundering on that basis?
Hard to say. My personal opinion is that the Constitutional Court is not sending the message that this presumption itself definitely will be contrary to our constitutional presumption of innocence. If the general courts, the criminal courts will use it reasonably and will balance the presumption of innocence and this presumption of fact. But this not should be applied just automatically. We have such a possibility according to law, and we don't take care of it anymore. Some evaluation, I think, is expected. But as always, law, usually it's written more or less reasonably. 99% it's question how you apply this law, reasonably or not.
But if there are no further questions, I would thank against our distinguished speaker for their invaluable contribution, and you, the audience, and I would probably give the floor to Christine for some concluding remarks.
Come to the end of this today's conference, I would like to first thank you all for being here, to share your thoughts. I think we made quite good, I think. But we talked about different aspects of consumption of innocence, starting with philosophical aspects. And even Kafka came out, and some like him very much, some just don't like so much. And we talked about criminal assets, we talked about reverse burdens, simplified procedures, legal persons, media exposure, and much, much more. And throughout, one thing is reminded here that this principle is essential as ever, but it demands our continued attention. So I sincerely thank ECLAN for trust and this opportunity to host this conference here in the University of Latvia. And thank you everyone for joining us. I hope that this experience was valuable and that those visiting Riga enjoy their stay. And thank you again for your time, for your insights, and for your presence. And now, before we are saying goodbye, I warmly invite you to the farewell coffee, this one, and to those who want visit our small historical students' detention hall. There will be such a possibility after, I think, 15 minutes. So, thank you once more, and I hope to see you.